ಸಾಯಿಗಿರು ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಹಾ, ಕೇಳಿಸ್ತಿದೆ ಸರ್.
ಸರಿ ಸರಿ. स्टेपलर दे दो भाई, स्टेपलर दो। नहीं, मेरा स्टेपलर नहीं है मेरे पास, देखो। और थोड़ा पेपर कट करके रखो, पेपर कट करके रखो, पेपर नहीं इधर।
ಮೇಲ್ ಕಳಿಸ್ತೀನಿ ಸರ್.
ನನ್ನ ಕಡೆ ಇಲ್ಲ ಸ್ಟೆಪ್ಲರ್.
ये मंगा करना पिनो वो दिन 3 था
नहीं है, कभी स्टेपलर नहीं है इधर। मैं क्या करूं? लेको स्टेपलर लेको। ಯಾವಾಗೈತಪ್ಪ ನಿಮ್ದು ಸನದ್ ಮಾಡ್ಕೊಂಡ್ ಬಂದೆ? ಗುಡ್ ಗುಡ್ ಗುಡ್. ಯಾವಾಗಿಂದ? ಹೌದು, ನಾನು ತಗೊಂಡಿದ್ದೆ. ಯಾರ ಹತ್ರ ಕೆಲಸ ಮಾಡ್ತೀನಿ
ಸರ್? ಆರಾಗ ಕಮಲ್ ಸಾಹೇಬ್ರದಾಗ ಒಂದ್ 2-3 ದೊಡ್ಡ ಭಾರಿ ಜಜ್ಮೆಂಟ್ ಇದ್ದು RSA ದಾಗಿನ.
ಏನಾದ್ರು ಸರ್?
RSA ಜಜ್ಮೆಂಟ್ ಭಾಳ ಚಲೋ ಆಗಿದ್ದು. ಅವು ನಂಬರ್ ಇಲ್ಲ ನನ್ನ ಕಡೆ.
ಯಾವ್ದ್ರ ಮೇಲೆ ಸರ್?
ಹಿಂದೂ ಲಾ ಮೇಲೆ.
ಭಾರಿ ಬರ್ದಿದ್ರು ಸಾಹೇಬ್ರು.
ಅಲ್ಲ 4-5 ಬಂದವು, ನಂಬರ್ ನನ್ನ ಕಡೆ ಇಲ್ಲ. ಆಮೇಲೆ ಬೆಟ್ಟಾಗ್ಲಿ
ನೋಡ್ತೀನಿ ಸರ್. ಬೇರೆ
ಇದ್ರೆ ಎಲ್ರೇ ನೀವು ಇಟ್ಕೊಂಡಿದ್ರೆ ನಂಬರ್.
ಅಲ್ಲೇ ಬರ್ಬೇಕು, ಅಲ್ಲಿ ಡಿಸೇಬಲ್ ಇರ್ಬೇಕು. ನಿಮ್ಮ ಅಪೋಸಿಟ್ ಸರ್ ಯಾರು ಇರ್ಬೇಕಲ್ಲ? ರಾಂಗ್ ಪೋಸ್ಟ್ ಸರ್. ನಿನ್ನೆ ಅದನ್ನು ಹೇಳ್ಬೇಕಂತ ಇಲ್ಲಿ ಕಾಲ್ ಮಾಡಿ ನಿನ್ನೆ ಮಾಡಿದ್ದೆ ಮೇಡಮ್. ಕಾಲ್ ಮಾಡಿದ್ದೆ ನೋಡಿ ಸಿಕ್ಟಾಗಿ ಹಾಕ್ಬೇಡ ನಾನು ಹೇಳಿ ನಿಮ್ಮ ಮುಂದೆ ಬರ್ಲೇನು ನೋಡಿ ಮೇಡಮ್, ರಿಜಿಸ್ಟರ್ ಕರೆಸಿ. ನನ್ನ ಮುಂದೆ ಹೇಳಿದ್ದಾರೆ, ನಾನು ಕೂಡ ಹೇಳಿದ್ದೇನೆ. ಕೇವಲ ಡೇಟ್ ಮೆಟ್ರೋ ನಿಮ್ಮ ಮೆಮೊ ಇದೆ ಮೇಡಮ್. ಒಂದ್ಸಲ ತಪ್ಪಾದ್ರೆ ಥರ್ಡ್ ಟೈಮ್ ಅವರು ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡ್ತಾರೆ.
ಮಾಡಬೇಕ್ರಿ ಇನ್ನೊಂದ್ಸರ ಪಿಟಿಷನ್ ಪೂರ ಓದ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಮ್ಗೆ ಏನು ಐತಲ್ಲ ಡೆಮಾಲಿಷನ್ ಇದೇನು ಮುನ್ಸಿಪಲ್ಸಿ ಲೇಬರ್ ಇಲ್ಲಿ ಯಾವ ಇಲ್ಲ ಅಲ್ಲ 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 ಎಲ್ಲಿ ಬಿ ಆ ಕಡೆಗೆ ಅಲ್ಲ ಇಲ್ಲ ನೋಡಿ ಆ ಕಡೆ 7 ನಂಬರು ಚಲೋ ಆಗಿಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್
ನಿಮ್ಗೆ ಚಲೋ ಏನ್ ಲೇಟ್ ಆಗಿರ್ತದೆ ಈಗ ಅಲ್ವತ್ತಂದ್ರೆ ಅಲ್ಲಿ ಟೈಮ್ ಡಿಸ್ಮಿಸ್ ಆದ್ರೂ ಲಿಬರ್ಟಿ ಅದನ್ನೇ ಹೇಳಿದೆ ನಮ್ಮ ಮನೆಯವ್ರಿಗೆ ಅವತ್ತು ಅರ್ಗಿನ ಕೇಳಲ್ಲ ನಂದು ಫಿಕ್ಸ್ ಲಿಬರ್ಟಿ ನೀವೇ ಬರ್ತೀರಾ?
ಮುಂದೆ ಆಟೋ ಅಂದ್ರೆ ಪೋಸ್ಟ್ ಇಲ್ರಿ ಯಾವ್ದು ಇಲ್ಲ ಹೋಗಿ ನೋಡ್ಕೊಂಡ್ ಎಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ವಿ ಎಲ್ಲ ಮಾಡಿದ್ವಿ.
ಏನಿಲ್ಲ ಅಂದ್ರೂ ಆಟೋ ಲಿಸ್ಟ್ ಆಗುತ್ತೆ. ಹಿಂಗಾಗಿ ಕ್ಲಿಯರ್ ಮಾಡಿದ್ರೆ ಮತ್ತೆ ನಾವು
ಹಿಂಗೆ ಏನ್ ಸರ್ ಅದ
circular, they are 24 hours. If it is not compliant, it will be before the ARG.
ಹೋಗ್ರಿ ಇಲ್ಲಿ ಸಬ್ಮಿಷನ್ ಮಾಡ್ರಿ ಹೌದಾ ನಾವೆಲ್ಲರೂ ಅದಕ್ಕ ನಿಂತು ಫುಟ್ ಆಫೀಸರ್ ಒಳಗೆ ಹೋದ್ರಿ ಸರ್ ನಿನ್ ಮೆಮೊ ಪೋಸ್ಟಿಂಗ್ ರೀ ತಗೋರಿ ಸರ್ ನಂದು ನಾ ಮುಂಜಾನೆ 10 ಗಂಟೆಗೆ ಬಂದಿರ್ತೇನೆ. ಹೌದು ಜೋಗೇಶ್ವರದ್ದು ಇಲ್ಲೇ ಹಿಂದ್ಗಡೆ ಅದಾವ. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಬಂದಾರ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಬಂದಾರ ರೆಗ್ಯುಲರ್ಲಿ ಲೇಟ್ ಮಾಡ್ತಾರೆ ಸರ್ ಫಾಸ್ಟ್ ಇತ್ತು. ಬಟ್ ಯಾವಾಗ ಲಿಸ್ಟ್ ಮಾಡ್ತಾರೆ 24 hours ದಾಗ ARG ಮುಂದೆ ಬರ್ತೈತೆ ಸರ್ ಕಂಪ್ಲೈ ಆಗಿತ್ತು ಅಂದ್ರೆ ಬೋರ್ಡ್ 24 hours ದಾಗ ನೀವು ಫೈಲ್ ಮಾಡಿ 24 hours ದಾಗ ARG ಮುಂದೆ ಬರ್ತೈತೆ ಸರ್ ಕಂಪ್ಲೈ ಆಗಿತ್ತು ಅಂದ್ರೆ ಡೈರೆಕ್ಟ್ಲಿ ಕೋರ್ಟ್ ಮುಂದೆ ಹಂಗೆ ಸರ್ ಈಗ ಎರಡು ಕಡೆ ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡೋದು ಅಂತ ಕೇಳೋದು ಸರ್ ಈಗ ಬೆಳಗಾವ್ದವ್ರು ಕೆಲವೊಬ್ರು ಮೆಮೊ ಪೋಸ್ಟಿಂಗ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್ ಅಲ್ಲಿ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅದರ ಒಳಗಡೆ ಇರ್ಬೇಕು ಹೈಕೋರ್ಟ್ ಮಾಡೋದು ಹ್ಞೂ ರೀ
Sir, how high are you, sir?
ಮೊನ್ನೆ ಸಿಗ್ಲಿಲ್ಲ.
ಇಲ್ಲ sir.
ಫಂಕ್ಷನ್
ಹಾ ಮತ್ತೆ 2 ಫಂಕ್ಷನ್ ಇದ್ದು ಸರ್ ಅಟೆಂಡ್ ಇಲ್ಲ ಸರ್. ಆಸ್ ಪರ್ SOP ನೀವು ಕಂಪ್ಲೈ ಮಾಡಿದ್ರೆ ಡೈರೆಕ್ಟ್ಲಿ ಬೋರ್ಡ್ ಮುಂದೆ ಬರ್ತೈತಿ. ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ARG ಮುಂದೆ ಬರ್ತೈತಿ ವಿದಿನ್ 24 hours. FR ಏನು ಸರ್ ಇದು? ಏನು ಫಾರೆಸ್ಟ್ ಏನು ಇದು ಮಾಡತ್ತಾರೆ ಸರ್? ಇನ್ನು ಇದು ಡಿಫಾರೆಸ್ಟೇಷನ್ ಮಾಡತ್ತಾರೆ ಇಲ್ಲ ಬರೀ ಇದನ್ನ FTTS ಎಲ್ಲ ಕೊಡ್ತಿ ಎಲ್ಲ ಫ್ರೆಶ್ ಅದಾವು. ಡಿಲೇ ಆಗ್ತೈತಿ
70. ಅದೇ ಲಿಸ್ಟ್ ಮಾಡಿಸಿ. ಇದ್ರ ಜೊತೆ ಹೇರ್ ಆಗ್ಬೇಕಂತಂದ್ರೆ ಲಿಸ್ಟ್ ಮಾಡಿಸಿ ಡೇಟ್ ಇರುತ್ತೆ.
My lord, my lord, a humble submission, my lord. Court officer, it is muted.
Yes,
Sir,
yes. Page number 12, 46 and 47. Page number 13, 48 to 53. Page number 14, serial number 54 to 57. Page number 15, serial number 58 to 62.
My lord, serial number 58. I request that this case, along with another case which I have filed, that is WP 109431/25, may kindly be clubbed because it is having all the same parties and same question of law is involved in this particular case.
then who
Lordship,
moved the memo for this matter?
Lordship, we had moved the memo for the petitioner in serial number 58, list 1.
Hmm.
So I request, my lord, since I have also filed a writ petition and parties are same, even authorities are same,
Yes, yes, along
and
with
the question,
with the other matter next Thursday.
please, my lord.
Yes.
Page 16, serial number 63 to 69. Page 17, 70 to 74. Yes.
On the list.
My lord, a humble submission, my lord.
Yes.
My lord, I'd like to mention a matter. Writ petition number 16445 of 2024. It is a disposed of matter, my lord. I represent the respondent wife. The court had given directions to the petitioner husband to sign necessary documentation and complete formalities for the admission of the minor child. Now, the minor child received the offer on 2nd of February, my lord, this month. And the last day to comply with it all is the 7th of February, which is this Saturday. The mother has completed all of the formalities, but the petitioner is not cooperating, the husband, my lord. Therefore, I request that the matter may be taken up tomorrow. I have filed an IA to this effect, my lord,
What are you?
seeking directions that the petitioner may comply and sign on.
Why should, when there is already a direction, why should there be a further direction?
My lord, despite informing the
No,
petitioner,
despite an order, if somebody is not doing, remedy is not to file an IA and get another order. What is not done because in furtherance of earlier order will not do now.
my lord,
You file a contempt.
yes, my lord, but by then the child child stands a chance of having her admission cancelled. That is by this
No,
7th.
that's what that order is. Earlier order is already clarified this issue, isn't it?
Yes, my
Asking
lord.
the father what is supposed to be done. So why should we have another order for the same thing?
At least to be spoken to, my lord, to the
Yes.
parties.
Yes.
List one further hearing matter. Serial number 1.
Lordship, serial number 32.
Justin C. Angadi.
32 is in orders. That's why it's not called.
I need an accommodation, my lordship. I am not keeping well. I could not travel.
Is this matter after 2 weeks?
2 weeks.
Yes.
Your Lordship, this is the matter which was mentioned yesterday. A retired bank officer losing his money in an online scam. Then he files an FIR before the Hubballi police station, jurisdictional police station.
Yes, what are your instructions?
Bank, yes. First time I also directed to take to bank instruction. But in this case, my lords, when my lords, the orders were passed by the by the court below for release of the amount, my lords, the banks, my lords, are not parties to that litigation. And in the meanwhile, since this is a big racket, my lords, where online scams were conducted, the bank, this respond number 2 bank, my lords,
There is an order of the court.
Yes, there is
an order of the police which is binding on you.
No, definitely the court, my lords.
So then we have
Yes,
to
yes.
set aside this
No,
order.
what I wanted to, my lord, put forth is that the police stations of Uttar Pradesh and Delhi have also, my lords, treated this transaction as a fraud transaction, and because of that, notices were issued to the bank, and that's why, my lords, we have marked it. The account is marked as lien. That is the reason, my lords. Now, my lords, the court orders for, my lords, release of the amount.
Jurisdictional court has already passed an
Yes,
order.
yes, please.
So our police authorities outside the.
Bound by the orders.
Yes. The present writ petition is filed, seeking the following prayer. The facts of the case are, the petitioner is a retired bank employee and is having a bank account in the respondent number 1 bank. He is a victim of the online fraud and has lost all his retirement monetary benefits along with his previous savings to an online scam under the pretext of online trading. He has lost an amount of rupees to a tune of rupees 73,61,000. In this regard, the petitioner has made a complaint. And the same is registered as crime number 0040 of 2024. The police, after a full-fledged investigation, have filed the charge sheet, and the matter is pending before and they have filed the charge sheet, and the same is numbered as CC number 4358 of 2024, and the same is pending consideration before the court. The respondent police could recover an amount of rupees 35,59,815.94 paise from the accused person. Then the petitioner has filed an application before the trial court under section 451 and 457 of CRPC, and an order was passed to release this entire amount.
Entire 35 lakhs 59,815.
Then an order was passed.
Two orders, Your
Two
Lordship.
orders were passed on 33/30/2024 and 15/3/2024, directing the police to release directing the respondents to release the entire amount of 35 lakhs 59,815.94. The petitioner, after having received the amount by virtue of the orders, transferred the money to his 2 accounts with respondent number 1. Subsequently,
Respondent 1 and respondent 2, Your Lordship. 2 bank accounts, different bank accounts.
respondent number 1 and 2. Subsequently, the petitioner received intimation from the respondent number 1 and 2 that the said accounts have been frozen in view of other 3 complaints filed by the different victims of the same accused person. These other victims have registered 3 complaints before respondent number 4, 5, and 6. Hence, in view of the same, the accounts are frozen, and the amount in the said account is likely to be released in favor of the other 3 victims of the online fraud, respectively. Agreed with the said action and the said action of the respondents, the petitioner is before this court. Land counsel appearing for the petitioner submits a petitioner is a senior citizen. Yeah, his petitionary benefits in this scam, he lost all the amounts, and when he has approached the jurisdictional magistrate and filed an application for the release of the amount, and when an order is passed, now it is not open for the banks 1 and 2 or 2 and 3.
Banks 1 and 2.
Banks, the respondent 1 and 2 banks, to freeze the account, basing on the intimation from the police that the complaints are registered. It is submitted that this action of the respondents is beyond the powers vested with them, and in clear disobedience of the orders passed by a competent court. Next one. Learned counsels appearing for respondent number 1 and 2 submits that in this online trading, several victims have filed their complaints, and basing on that, they have received the requisition from the police to freeze these accounts. As such, they have frozen the account of the petitioner. Whenever a complaint is received from the police, with regard to a crime, and generally the respondents, not generally, the respondents are bound to freeze the account. Anything else?
We were not parties in the criminal case.
It is submitted that the bank is not aware of the orders passed by the criminal court, as they are not the parties before the criminal court. Next part. Having heard the land counsels on either side, peruse the material on record. The petitioner has filed a petition under section 151 and 157 of CRPC before the first additional civil judge and JMFC Hubli.
451.
451.
Huh?
451 and 457.
451 and,
Please.
and 457.
Sorry.
And two orders were passed on 33 to 2014 and 15/3/2014, wherein the court, an amount of rupees 35,59,815.94 is released in favor of the petitioner. Then this amount is deposited by the petitioner in respondent number 1 and 2 bank accounts. Even if they receive a communication from the police that in view of the crime registered, the accounts has to be frozen. In the light of the order passed by the magistrate, the bank cannot pass such an order freezing the account of the petitioner. If they receive a communication, the bank has to inform to the police that in view of the orders passed by the court, they can't freeze the account of the petitioner. It is a contention of the learned counsel for the respondent 1 and 2 that this particular aspect is not in their notice. In their notice, in that view of the matter, the notices dated 2 notices.
There is no notice, Your Lordship. Directly the accounts have been frozen.
Notice are
The
issued by the bank.
proceedings dated so and so or set aside, and the writ petition is allowed.
Obliged.
Yes.
Bill number 2.
Further direction belongs to the bank. A positive direction to the bank belongs to defreeze the account.
Huh?
A positive direction to the banks to defreeze the account.
Is set aside? No, once that is set aside, it will be, that order is freezing
So what
the
is
account.
challenge, my lords, is.
What is the prayer you
petition.
sought?
There has to be, my lords,
To defreeze the account and a direction to the banks not to freeze my accounts on the same grounds again. Because
at future, my lords,
Let's.
is
what
anticipating
is the
what will happen
prayer?
in the future. But in respect of these 2 amounts, my lords, that he has received,
page 7 are the
Where is
prayers.
that? Where is your prayer?
Page 7, Your Lordship, of
Page
the
7.
petition.
7. Accordingly, the writ petition is allowed, directing the respondent 1 and 2 bank to defreeze accounts of the petitioner.
further prayer, my lords, is in anticipation of the further prayer that not to freeze it in the future. Lords, that, my lord, would be if any other amount, my lords, is received by whatever means. But he, my lords,
Who cannot freeze the account which he has received from by virtue of the orders passed
by the court, yes.
and the respondents are directed not to freeze the account of the petitioner in respect of the order that is passed by the
Please.
competent court.
Highly obliged.
Is next.
Please.
My lord, appear for,
Number 2.
please, I appear for petitioner, my lord. Petitioner is a chit fund company, my lord. Respondent number 1 was the principal borrower. Respondent number 2 is the, my lord, guarantor. Now, there was an award against the principal borrower, respondent number 1. It was put into execution. During a pendency of execution, respondent number 1, my lord, JDR, principal debtor, he expired. And a memo was filed by the petitioner. Present petitioner was a decree holder, stating that there are no legal heirs in his knowledge. But the guarantor filed a memo stating that there is one legal heir to the JDR number 1. Taking that memo on record, my lord, the execution petition itself is closed without giving an opportunity to the decree holder to bring on record the legal heirs of JDR number 1. Order is at page 22.
Page?
22. Now, my prayer is, my lord, the order be set aside and both the matters.
Let's see the order.
Please. Page 22, my lord.
Notices are served.
Notice I have sought for dispensation because the principal debtor has already expired. There are no legal heirs brought on.
Yes, where is that?
Page 22, may I read, my lord?
Hmm.
It's order dated 28/6/2025. It starts from page 21. Sri RMB filed power for JDR number 3 and also filed.
21 is your wakalat.
Yes, my lord. Previous order. Page 20. Page 20. Order dated 28/6/2025, my lord. JDR number having 5 legal heirs, along with the memo, counsel for JDR number 3 furnished a copy of form number 7 issued by MDR DHR Society, wherein it is shown as one Sanjay is the nominee and he is the son of JDR number 1. DHR counsel filed memo stating that JDR number 1 died without any heirs. As per the documents furnished by JDR number 3, it shows that JDR number 1 is having a son.
Petitioner, judgment letter is before this court, agreed by the order dated 28/6/2025. During the pendency of the EP proceedings, the JDR number 1 died, and it is stated by the decree holder that there are no legal heirs. Then the guarantor, who is JDR number 3, has filed a memo stating that he's having 5 legal, that he is having legal heirs, and he has furnished the details of the family members. Then the court, by order impugned, had closed the EP on the ground that the DHR has suppressed the material facts. Land counsel appearing for the petition submits that when it is brought to the notice of the court that the JDR 1, there are surviving legal heirs of JDR 1, the court ought to have given an opportunity to the petitioner to bring the LRs on record, and without doing so, the court had dismissed the petition. It is dismissed, the close the EP. It is submitted that the procedure that is adopted by the court is contrary to law, and it will cause lot of hardship to the decree holder. Next paragraph. Land counsel appearing to the petitioner further submits that he has not the land counsel petition. The MMO is filed seeking dispensation of notice to JDR 1, who is no more. And what about JDR 2?
Lord, he is a guarantor. No, there is no relief as against him.
As far as JDR 3 is concerned, they are not seeking any relief. They filed a memo to dispense with their notice, and accordingly, the court has passed an order dispensing the notice to the respondents. Next paragraph. Having heard the land counsel for the petitioner peruse the material on record. When there is a judgment and decree in favor of the petitioner, then during the pendency of the EP proceedings, the JDR died. It is submitted by the decree holder that there are no legal heirs. Then later, it is brought to the notice of the court that there are surviving legal heirs to the JDR. In that case, the court ought to have given an opportunity to the decree holder to implead the legal heirs, and the court ought not to have closed the EP. In that view of the matter, the order dated 28/6/2025 is set aside, and the petitioner is permitted to bring the LRs on record. Accordingly, the writ petition is allowed. What about the next one?
Same order.
All same facts.
Same facts.
Yes.
Same order. Order or date also same.
Yes, same.
Please.
In this, you sought for dispensation.
Yes, both the matters.
Memo for dispensation
Yes.
of notice in the second matter, dispensed with at the risk of appellant.
Please.
Yes, next.
Please, oblige.
Seal number 3.
Lord,
Yes,
appeal
somebody?
for a petitioner.
Suresh R. Budihal.
My Lord, will kindly see the charter of demand came to be placed. Charter of demand. Industrial dispute. And government referred the matter to Industrial Tribunal Hubli.
Who
And-
appears for the respondent?
Viresh
Suresh
Budhia.
R. Budihal.
Where is he?
Suresh Budihal.
Whether he comes or not, I will hear this matter at 2:30.
Awesome.
Yes,
Seal number
next.
4. Santosh Satyakadigi.
You the file.
Layman's appeal, my lord. Case of injury,
Hmm.
respondent number 2 is served but unrepresented, my lord. Respondent number 2, insurance company is served but unrepresented.
Appeal for the Reliance General Insurance. You want to file wakalat or you are ready to argue?
No, my
Matter
lord,
is
matter
settled.
is order settled.
So and so is directed to take
What's
notice
it?
on behalf of the insurance company. Then counsel for the appellant shall serve the copy of the appeal memo. List this matter next week. Delete
My
from
lord,
the
Well, matter is settled,
Matter may be
yeah.
referred to the local other. We have ordered in.
the It is, both the parties submit that the matter may be referred to the Lok Adalat. Place this matter before the Lok Adalat.
Please.
Delete from the caption dismissal. Yes, 5.
Still number 5.
Request for password.
Srikanth Tipat,
Request password,
Yes, pass over.
please.
pass.
Yes, 6.
Preliminary hearing matter, still number 6.
Petitioner is a property concern, my lord.
Again,
Petitioner is a property concern, my lord. Registered under a KVAT Act, my lord. The respondent number 1 concluded the assessment proceedings for the assessment year
You're
2014 and
questioning
15, my
what-
lords.
You're questioning which order?
Questioning the order
Page
of
number 11, my
recovery.
lords, the impugned order.
Notice passed by the,
JMFC
Commercial
court.
tax officer, respondent number 1, my lords.
oh, this is WP 104836.
Yes, 4836.
Please, my lords.
That's what he has challenged.
But
in
attendance
Millards.
is necessary to answer to a charge of offence punishable under section. You're hereby required to appear in person on the date. This notice is questioned.
Yes.
Please, my lords. Subsequently, my lords, they concluded the assessment proceedings, my lord. Based on the information available in the departmental websites, my lord, may I read the page number 12, my lords.
No. If a notice is issued, what is wrong in appearing before the court and telling the court the same thing?
At the time of assessment, my lords, I was not in possession of the C form, my lords.
No, whatever it is, court has asked you, it's just a notice.
Subsequently, recurring proceedings have been initiated, my lord.
Where are they questioned?
Please, my lord, it's at page number 14, my lords, before the trial court.
Of certiorari in the light, quashing the impugned notice.
Please,
That is
my
what
lords.
is questioned in this writ petition.
They have levied the tax, interest and penalty, my lords.
That's under the.
At the time of assessment, I was,
62 of the Millards Act. There is appeal provided to challenge the original order. He has only,
Oh, even forgetting all that.
Please.
It is a notice.
it is only a notice.
Why should, on a notice you should come?
my lords, subsequently, recovery proceedings have been initiated, my lords.
So subsequent, come to the prayer.
Please, my lords.
What is the prayer? Please tell.
Seeking quashing of the
Quashing,
notice
yes.
issued by the Millards JMFC court.
And
also
subsequently,
remand-
I am seeking,
That's subsequent. It is not there.
my lords, all I'm seeking is remand to the assessing authority, my lords, for fresh consideration of the C forms.
What is the fresh consideration?
C forms, my lord. That is the document,
You seek one prayer
please, my lords.
and you seek a consequential prayer is unconnected with the main prayer. You are questioning a notice issued.
Please, my lords.
No, we will not interfere with the notice. When we are not interfering with the notice, where is the question of passing any other order?
My lord, the trial court is not competent person to adjudicate the matter regarding C forms, my lord.
Tell them,
My lords, if I approach the trial court, I may be levied with the interest and penalty, my lord, 25% pre-deposit.
have you questioned the assessment order?
No, my lords.
Then,
For appeal, my lords, the pre-deposit is required, my lord, 25% of the
Come.
interest and penalty,
the
my lords.
present writ petition is filed. Seeking the following prayer. On a notice that is issued, the petition is before this court questioning the notice dated 27/8/2025. It is also an admitted fact that he has not questioned the original, the assessment order. Learned, AGA submits that against the order that is against the assessment order. He has a right of appeal under section
62 of the act.
under the section 62 of the act. Even on that count also, the present writ petition is not maintainable. Accordingly, the writ petition is disposed of giving liberty to the
It may be-
petitioner to avail the.
One submission, my lords.
Yes,
It may be kindly remanded back, my lords.
I will not remand anything. That is not the prayer you sought. That is, you say notice and remand the matter. What is notice?
My lord,
Until an order is questioned,
Yes, my lords.
where is the question of remanding it?
my lord, at the time of receiving the notice, I was not in possession of the C forms, my lord. But now I am,
Then what did you do?
my lord, C form issuing authority is the sales department of the concerned supply state, my lords. After duly compliance,
My question is very simple.
please, ma'am.
So please, you don't complicate it.
Please, ma'am.
You asked, this is your prayer.
Please, ma'am.
I am only concerned with what you are seeking in the prayer. We can't grant you beyond the prayer. Your prayer is questioning a notice.
Please, ma'am.
When you question a notice, where is the question of remanding the matter to the primary authority and setting aside everything, when that was not the, that is not what you have questioned?
But in the prayer, I have sought for remand, my lords.
Remand to whom?
Respond number 1, the assessing authority, my lord.
That is why
The-
appeal is provided.
Huh?
That is why appeal is provided. He can file an appeal.
We can't help it.
My lord,
Please do whatever you want to do. Next
my
matter.
lord, one submission, my lords. One kind submission, my lords. May I rely on this division bench judgment? The second page, my lords, second paragraph. The learned counsel for the petitioner relies upon the division bench judgment of this High Court and so to the effect that C and D forms could be filed even of the.
We will not be wasting not even 1 minute, Mr. Counsel. Without you, I can understand, you question the order of the preliminary authority,
Yes, ma'am.
saying that your appeal is not an effective remedy.
Yes,
You didn't even question that order. And without questioning that order, what do you expect the court to do?
My lord, last submission, my lords. The remedy available to the petitioner was not effective remedy as the petitioner was.
Next matter.
Seal number 7. Sunita Padge,
Similar matter.
AGA 7.
Similar.
What is urgency for moving these memos?
Finally, we warrant is issued, my lord.
Huh?
Finally, we warrant is issued.
Similar matter.
Similar matter.
case.
Same order. Yes, next.
Seal number 8. By Lakshmikant Reddy. Saupagya.
Your Lordship, initially in this matter, FDP proceedings is challenged. However, Your Lordship, now both the parties are ready to settle. If Your Lordship says so, we'll go for a mediation because.
Yes, it may be referred. Your Lordship.
And,
Because that-
one more
by both the
submission, Your
counsel,
Lordship.
The matter may be sent to the mediation. Both the
Wow.
parties shall appear before the mediation center when?
Any date, Your Lordship.
Mediation center, Dharwad, on 19th of February.
One more submission, Your Lordship. Pursuant to the order, now entries are being changed. If they are consented, Your Lordship, and with respect to of entries, Your Lordship, status quo may be ordered.
Either that or this, not both.
If that is the case, Your Lordship will withdraw the petition because we have challenged the FDP proceedings, Your Lordship. Only, Your Lordship, instead of going for one more proceedings, we wanted to settle in before this honorable.
If you won't file a memo.
Please, I may be permitted to withdraw, immediately I'll file. Because
Memo is
even I
filed
don't want to
stating
waste the
that
court time.
wants to
Please.
withdraw the writ petition, dismissed as withdrawn. Yes, next 8.
With liberty to file regular appeal. Regular appeal, Your Lordship. I have challenged the FDP proceedings.
With the liberty to file regular appeal in accordance with the law of limitation.
Please, writ.
Yes.
Seal number 9. DL Patil, DL Artham.
Yes.
Child custody matter, Madam.
Yes.
Period number 8 is father's petition. Interim order is passed regarding child custody only on Saturdays and third Saturday.
Please come to the impugned order, page number.
Yes. Impugned order is at starts from page number 58.
58. Yes. Operative portion.
Operative portion is at page number
I number
63.
1 and 3 filed by the petitioner is hereby allowed in part visitation rights of his minor children on every first and third Saturday between 3 to 4 p.m. at childcare room in the family court, Hubli. Yes. What is your submission?
My submission is that, my Lord, instead of Saturday, because Saturday will be working days for the father and as well as the children also, they will be going to the school. At least to Sunday's whole day may please be granted.
What is the age of the child?
3 and 5.
3 and 5. Where do the parents stay?
Father is staying in Dharwad, Sattur. He is employed as a medical officer in SDM Medical College. And wife is staying in Hubballi. After
Distance?
15 to 16 kilometers from there to Hubballi. And he is ready to visit there also. They are not allowing, even for court visit also, even after passing of this order also, they have not brought the children and permitted him to visit in the court premises also.
My first submission is that he has not paid the maintenance since
That we
September.
will,
No,
go
one
into
submission.
later. First,
Please,
First
my
you
lord.
make submissions on this.
In the second connected petition,
I saw that. So what is your
there in
submission?
para number 12, I have clearly requested the respondent, that is in my case, respondent, that's the father, I have invited him to visit my house. No question of any quarrel with respect to whatever the apprehension is there in the mind of the father. I don't want to make my children to suffer because of the quarrel between myself and my husband.
Are you paying maintenance to the child?
We have paid. No. We are in 125 proceedings, we are paying the maintenance. What?
20,000.
Since September 2025 till
20,000
date.
rupees per month.
Huh?
20,000 rupees per month.
It's paying 20,000.
No, let him file an affidavit, if that is the reason. In the morning, I have ascertained and making the submission.
October 15 because it was posted for orders.
Till October 15, it has been paid in the court only. And after 15, it was posted for final interim maintenance of 20,000 rupees per month. And October 15th, it is posted for orders. Orders has not yet come. It is waiting.
No, on every date, the court is adjourning the case.
October, November, December, January, February. I mean,
5 months.
It's 5 months.
Yes.
He has to pay 1 lakh.
He is ready to pay.
When will he pay?
He will pay immediately also. Within 3-4 days, he will pay that amount.
Yes, what do you say now about the visitation?
As far as the children are concerned, my lord, children are suffering from certain psychological and neurological disorders. In my petition, I have disclosed that fact. Let the father visit the house, whatever the time he feels like. We will make arrangement to see that none of my family members there in the house. To that extent, I am ready.
That will not work out.
One submission. Alternative, my submission before your lordship is that after the passing of the order, petitioner, that is the father, did not visit the court continuously since the date of the order. Question of my brother making a
the court. Now you please tell the court what is your submission about he meeting the children on the Sunday.
Sunday, as far as place is concerned, I request hardly an hour to ascertain and make a submission, my lord. As far as the place is concerned, let him make an arrangement for the payment of the maintenance amount.
That
Because
he has already said. I will file that.
Please,
will be part
please.
of the order. Please find
Please,
out.
my lord, please.
Yes.
Pass.
Yes, next.
Bill number 10. Please pass. Yeah, number 10.
Please pass over.
Pass.
Yes.
Bill number 11. Arvind Pachapure.
This is challenging the constitutional validity of an amendment under the Sauharda Act.
Amendment to the
Sauharda, Karnataka Sauharda Sahakari Act. It's a cooperative society, milords, wherein milords, in cooperative societies, milords, Act 1959, milords, there is a government control, milords. Looking into all these aspects, milords, this enactment came to be passed with some reason statement of object, milords. I'll read, milords. Why it came is.
As far as the constitutional validity of the act is concerned, they need to file their objections that we will consider.
Yes.
Now, what is the interim order you are seeking?
Implementation means what happens, my lords. Now, the first grievance of this society, there are 6,514 societies under the Sauharda, my lords. Under the cooperative, there are 50 to 60,000 lords all over the state. Now, the first amendment, which is lords being agreed by this society,
Was the amendment carried out?
lords, the amendment is carried out, lords, on as of today, lords, they have not issued any rules, lords. 12/9/2025, lords. Now, pursuant to this amendment, lords, they are required to, lords, I produced one document at annexure F, lords, page 97, memorandum regarding delegated legislation, lords.
According to you, that operation of the act itself has to be stayed.
Yes, because it requires to.
Which provision, according to you, is unconstitutional? Which is the provision?
Yes, no, what I'm saying is, milords.
Point out from your.
Yes, milords. 97, your lordship may kindly take, milords. Page 97.
That's in Kannada?
No, it's in English.
Yes.
It's a bill, milords. But this clause 6, not in all the clauses, I'll just point out, milords. Clause subclause 3, clause 6 of section 20B proposed to be inserted by clause 6 empowers the state government to prescribe the manner. Second, milords, empowers the state government to prescribe the manner of contesting. Third, my lords, empowers the state government to prescribe the manner to file assets and liabilities of the candidates. Empowers the state government to file assets and liabilities of the elected directors. So in all these sections, my lords, what I'm trying to bring to your lordship notice is, my lords, the statement and object of my lord, the Sauharda Act. I'll just read only one para, my lords, of the Karnataka Sauharda Sahakari Act. Court officer. Karnataka, the first, what it says is, my lords, the Karnataka Sauharda Sahakari Bill 1997 statement and object, my lords, among other things, provides for, lordship got the statement, the recognition, encouragement.
Where do you get that?
Let's say it's there, let's in the act itself,
In the
first
object,
page.
object and reasons, first page.
Let's right. First page, statement.
First page when the act starts. Code officer.
No, this object is of the old act.
No, what I'm saying is not so. The purpose of enactment has to be looked into, not the statement and objects and reasons of getting into this. Not what it says is not.
This Karnataka Act number 74 of 2025.
Please.
It's amended Act number 74 of 2025.
Yes, not yes.
There,
my lords.
To amend Karnataka Sauharda Sahakari Act.
Let's in the synopsis. I've just made a synopsis.
Where is
there?
that?
There I am.
Yes.
Sir. There, my lords, what it says is
Now,
the first.
in the earlier, in the unamended act,
please,
whatever now they have said, there is a prescribed qualification number and all in the earlier act.
Yes.
Yes, that is there, my lords.
Yes.
The difference is.
By virtue of this amendment, the government wants its own.
No. Before that, my lord, a preliminary submission. Kindly take the prayer in the writ petition. They wanted entire amendment has to go. That amendment is consisting of not less than amendment to the not less than 25 sections have been amended. It is a well-established propositions of law. When there is a constitutional amendment has been questioned, as my lord has posed in the earlier question to my lord and friend, it should be very much specific. Kindly take the prayer for the moment. The writ petition is required to be dismissed on the ground of there is no specific pleadings.
Specific provision.
No specific question. The entire amendment.
The clauses which I am.
You should, if you say, when you're questioning the constitutional validity, it should be of a particular, let it be 100 provisions, but you should say this provision in the light of so and so, the manner in which it is formulated is unconstitutional. You just can't say, just like that, the entire act is unconstitutional.
No, the clauses which, my lords, if those clauses are
To mention, that should be your prayer, not the entire act. Which provisions of that particular provisions of the act which are unconstitutional. Entire act won't be unconstitutional.
No, there are, my lords, except two sections, because all what I'm saying is, I'll not amend that accordingly also, my lords. But there are decisions of the apex court saying that, my lords, if the main section goes, if the soul of the act goes, but the entire thing has to be struck down, my lords. If it is ultra vires, not if we come to
court will decide.
Yes, my lords. No, what I'm saying is,
your prayer should be specific.
yes. No, that, my lords, I'll do it, my lords. Now, my lords, the main grievance of all this.
They have to amend, they have to formulate the rules. Rules have not come into existence. Without that, what they will do now?
No, this is not the amount of 20% as a state reserve liquid, my lords, what liquidity of which has to be maintained. For that, my lords, they are apprehending that, my lords. Now, for example, my lords, this society, my lords, has 100 crores of investment. Now, out of that, my lords, they lend to the depositors. Now 20 crores, my lords, I have to deposit it with the state, which will not be returned to me either in contingencies or in any situation. This is the one thing, my lords.
What is the purpose behind it?
No, there is no reason for it. Why 20% also there is no reason.
In case of any of bad administration
Correct.
or any other thing, when the other depositors are at this thing to take care of the interest.
No, that cannot, the government cannot interfere in those aspects at all, not because for the reason.
Please please specifically mention which are the provisions
I'll,
unconstitutional.
I'm not
Make a
sorry.
prayer to that.
I'll not amend to that action. But two sections only will be left, my lords.
The
Then
entire
counsel
pleading
for
has
the
to.
petitioner submits that the act so and so is unconstitutional, and the same has to be set aside. Then the additional advocate general appearing on behalf of the state submits that the petitioner cannot seek a relief that the entire act is unconstitutional. He should make a specific, he should have specifically stated which provisions of the act are unconstitutional, and such a prayer is not maintainable. Then counsel submits that he'll amend the prayer. This is
Instead of that, my lord, my submission, my lord, let my lord file a fresh petition, because it's the.
Two sections.
No,
It's just a formality.
because there is ground, there is no ground also. Except, please, I leave it him,
Will only withdraw.
Please, not that application for impleading lords have filed lords. Directors, now it is before your lordship, my lord, that may be allowed, not that.
Number 2 of 26 is filed to implead P2 to P over there.
They are all directors of the society, my lords. In fact, by oversight.
Petitioners.
Yes, petitioner society, as petitioner.
Why entire people should be there? Either it will be represented by a secretary or the president.
No,
Why
it is
should the
represented by the secretary, my lords.
Not necessary.
But again, that will be again, my lords, a technical
What is a technical
hurdle, my lords. There are few decisions of the apex court which says that, my lords, society alone cannot, but directors are to be made as a party.
No, Act itself says all the grievances of the society should be represented by the secretary.
Because I am relying on Article 19, my lords. 19, my lords, the fundamental right, my lords, inure to the benefit of the citizens. Now, that is being interpreted by the Supreme Court, my lords, in 9 judges bench, my lords, where corporation or association or society, they can't claim on the fundamental rights which are entitled to citizens. So therefore, not that again.
26 is filed.
Please.
The directors as P2 to P18. Accordingly, number 2 is ordered, and the petition shall carry out the necessary amendments in the cost title. This is matter after 2 weeks. Yes,
Please.
well.
Please.
Bill number 12. Kiran Kumar Chettimat, 12.
For petitioner, my lords. Petitioner is the wife of the respondent number 1, my lords. The marriage between the respondent number 1 and petitioner, my lord, both of the marriage is second marriage, my lords. Due to the love and affection, my lords, he relinquished, the respondent number 1, my lord, relinquished the share of his.
Come to your prayer. What is
Please.
the prayer?
To set aside the compromise
Pass
decree.
the compromise decree dated passed in OS number by this so and so, property situated at this so and so. Why should we? Who are you? You are the husband.
Please, madam.
Who are the? What is the suit for OS number 489 of?
489 suit filed by the my lords, his sons, respondent number 2 and 3, my lord, seeking relief of partition and separate possession, my lords. He is the children of respondent number 1, born out from first marriage, my lords. They filed a suit, collusive suit, my lords, without making me party to the proceedings.
Father.
I am for the wife, my lord.
Who are the parties to that? Your husband is a party.
My husband is party, and these sons born, their children born out from the first marriage, my lord. They are the parties. I am not party to the suit, my lord.
Why will you be made a party? How can you? Okay, our second wife will be made a party.
He relinquished, kindly see annexure C, my lord. He relinquished he relinquished his entire share to me, my lords.
Who?
Respondent number 1, my lords. Husband of this petitioner, my lords. After relinquishing his share to me, my lords,
What is the document?
Registered document, my lords. Kindly see annexure E, my lords, page number 13.
When was the relinquishment date?
14/8/2024, my lords.
14/8/24. When is the decree?
Compromise decree 12/11/2024, my lords.
Where is the relinquishment date?
Annexure E, my lords, page number 13.
The land council appearing for the petition submits that one of the parties to the partition, that is husband, partition suit, has relinquished his rights in her favor by relinquishment deed dated 14/8/2024, and thereafter, along with the other wife and the family members, he had obtained a conclusive decree, that's a compromise decree dated 12/11/2024. Considering the submission, there shall be stay of all the there shall be stay of operation execution of the compromise decree dated 12/11/2024. You know, issue notice to the respondent.
Still number 13?
Yes.
Petitioner matter pertains to recreation club. The respondents are interfering with our day-to-day activities.
Not insist.
Where did you say when and how they are interfering? How they are interfering? Where did you say?
They are orally directed to the close the club not in writing .
Nowhere he asked.
This honorable court, several orders has been passed.
I've seen that.
Please,
That's
please.
all. The
Please.
problem is, because there is an order, one will not come to
Please.
the court. You should come to the court with your grievance.
Please,
That is what I'm saying. When you're filing a writ petition, be specific about it.
please. They are not.
Every amusement park, the same order will not apply.
Please.
Because it is an amusement park. What is happening?
Plus now they are not. They are interfering with it. Orally directed to us. They are not to open the.
It's all some understanding between the police and you. So you will come orally. You will also orally to the court. There should be some factual basis. The present writ petition is filed seeking the following prayer. It is stated that the petition society is registered association, registered with the Register of Societies, Bagalkot. The association has been formed for providing entertainment to its members and its provides equipment and guidance for playing skill games like caroms, chess, etc. It is a grievance of the petitioner that the respondents, without any authority of law, interfering with the business of the petitioner and a coordinate bench of this court. In WP number 107476 of 2025, date 13th day October 2025, has passed an order relying on the earlier judgment of the court in WP number 21211 of 2017. As per the same, the respondents cannot interfere with the business of the petitioner's club. Considering the same, the writ petition disposed of, directing the respondents not to interfere with the petitioner's with the activities of the petitioner's club without following the due process of law. Next para. This will not preclude the police from entering into the premises, as they have every right to monitor and inspect the activities if any unlawful activities are conducted. Yes.
Number 15, Sadiq Gurwala.
Yes.
Page 6 is my prayer. And the impugned order is at page 57.
Page number?
6 is my prayer.
Who are you?
Well, I am judgment debtor.
Judgment debtor.
And a suit for ejectment. It has been decreed. I am directed to vacate. That order has become final. That order has become final. I have not challenged it. In page 57 is, my lord, a possession warrant is been issued. Kindly turn to, my lord, in page 5, para 14.
Page?
Page 5, para 14.
Page 5.
Page 5. And this is on maids, my lord, I have no case. Only therefore I am para 14, my lord, page 5. I have said that I will file an undertaking affidavit saying that I will vacate the premises if the respondent appears and gives reasonable time.
What is the nature of the premises?
It is a residential house.
Where is the undertaking?
My lord, para 14 I have said it.
No, that is not, you can't call it an undertaking.
No, what I have said it is.
No, you file an undertaking. You file an undertaking before this court. Undertaking affidavit should be filed.
Yes, my lord, the time.
And also, when are you going to vacate the property? Then only we'll pass an order.
Yes, my lord, I will mention that time. My lord, whether they agree it or not, my lord.
That's what, first of all, come up with an undertaking, and it is submitted that the petition is ready to undertake ready to vacate the premises if a reasonable time is granted. And in that regard, you will file an undertaking affidavit before this court. The petition is permitted to take out hand summons on the counsel appearing for the respondent before the trial court and shall file a memo to that effect. And along with that, you should also file an undertaking before this court. Lives this matter on 16th of February.
16th of March.
16th.
February. Please.
You want before that?
Before that, because there is a threat of this.
Matter on 12th of February.
Please. Till then, my lord, some interim protection. Because
Come, you whenever, if you serve it today, tomorrow also I will take up. Because that's how we will not stall the proceedings. We'll pass a full and final order.
it is a residential house. Petitioner is deciding with
They are
his
not going
vote.
to do it today itself.
And now after this, they have taken steps to, my lord, to open by breaking the door lock open.
When was the decree?
My lord, decree is in 2018.
2000?
18.
What reasonable time you require? 2018, without questioning that, we are in 26. Already you have enjoyed for 8 long years.
Therefore, for alternate, my lord, accommodation.
Alternative,
Immediately, my lord, if they put it them out.
What you can't get in 8 years, how will you get in whatever time the court grants you?
No, now the difficulty is, now the order is passed to break open the door lock. That is the
What
man.
I'm saying, how can we interfere with that? 18 order.
Therefore, I am not on merits, my lord. I don't have case on merit. Therefore, I said it.
Whether it is on merits or not, you are going to have the same interim order, what you will get on merits.
Yes, my lord. Till then, my lord, if I am, my lord, put out, they out of from my possession.
According to you, when are you going to vacate?
My lord, I seek, my lord, 1 year time. Whatever they give, my lord.
Then no, not required. I will not grant 1 year time. Maximum is 2 months. More than that, we will not grant. 2 months time we will grant if you want. 1 year, that is out of question. A decree of 2018 in 2026, if the court grants 1 year, that is mockery of justice.
6 months time, my lord, so that I can, my lord, do it.
No, 36 months time will not be granted. Please get instructions from your client. If you want, if he is agreeable for that, I'll pass an order. This is matter on 12th February.
Till then, some interim protection. Till then, my lord. Your lordship may say
By
that.
12th, an affidavit shall be filed before this court. An affidavit shall be filed before this court by 11th that the petitioner is going to vacate the premises within 2 months from 12 to 2026. Till such time, there shall not be any coercive steps. List this matter on 12th. If the undertaking affidavit is not filed before this court, the writ petition shall be dismissed on that ground. Yes.
Please.
Number 16, FU party.
The petitioner shall take out hand summons on the counsel for the respondent and shall file a memo to that effect by 10th. Yes.
My lord, meanwhile, my lord, award may be stayed.
Huh?
Sorry, my lord. I was
Number
a
16.
little confused. Sorry.
Yes. What is the writ petition about?
Lord,
Where is the prayer? Please come
Lord,
to the
prayer, Lord, your lordship will kindly challenge.
Upadalat award dated 14/12/2025.
Yes, Lord,
Yes.
award, Lord. Lok Adalat award, Lord, without making us a
What
party.
is the suit for?
Lord, suit was for permanent injunction.
Suit for?
Permanent injunction.
Permanent injunction.
Yes.
Hmm.
Lord, in that, Lord, your lordship should kindly, the respond number 3 colludes with respond number 1 and 2. Lord, this matter, Lord, your lordship, in fact, Lord, heard earlier, Lord, there is a judgment of this honorable court, your lordship's judgment.
I think in respect of this, the other day, another advocate is.
Jogalbayu temple, Lord, your lordship.
No. Now, the other day, in another matter, it is brought to the notice of the court, the notified temple under the Endowment Act. If that is so,
Well,
I am going to recall the earlier order also, and I am going to impose costs on everybody who has misrepresented before this court. And I'll also take a serious note on the HCGP also, or the AGA, who has not assisted the court properly. What is that number? The other day, one writ petition is filed saying that this is a notified temple and they have taken the information.
This
under
is
the
not
right
a
information.
notified temple. It is a private temple.
I've seen it the other day. They said that they have obtained it under the Right to Information Act.
Lord, I have produced your lordship's order copy.
My order is basing on instructions saying that it is not notified.
Is it in respect of same temple?
Same temple.
I have produced the order copy.
I know, I
Your
remember.
lordships are right.
That is what I said to the advocate.
Yes.
Then he has obtained the information under the right to information. They say it is a notified temple. Now all the councils who are misrepresenting about this, I mean all the parties who are misrepresenting before the court, they will face the music. I will also recall the earlier order also, provided I have given a date to that matter. Find out where is that. List this matter along with that matter. Yes, next.
Nice. I will take instruction, Lord. I will get Lord
Yes,
notification.
take that number. The other day, the writ petition, you remember? With regard to the same temple.
I will collect.
Yes. Next.
I appear for petitioner, my lord. The parties are engaged the service of senior counsel. Senior counsel is an.
I appear for the petitions council, my lord. There is another writ petition pertaining to the same subject matter. If your lordships could call that petition also, and the matter could be taken up in the afternoon, my lord.
What is this matter about?
Other three writ petitions, my lord.
What is this matter about?
Not three.
Matter
There
is,
is
my
a
lord.
dispute between two groups
No.
in respect
It
of
is
the
not
society.
dispute between
They
two
say
groups,
that they are the
sir.
duly
That
elected
is
board of
matter.
directors.
If the
And
petitioner, we will. The
we are saying,
senior
my lord,
counsel
we
is
are saying we are
addressing.
the legally, my lord, the board of directors duly elected.
Along with all those matters.
Lord, WP number.
Give those numbers, your numbers.
Lord, I have given, Lord. Same.
Senior also is saying the same
Please,
number.
please, same. Their party.
Other three matters are pending before this honorable.
That number.
Yeah, I have given order. Same.
Please,
Same.
my lord.
Same.
There is an interim order, my lord.
Same,
Please.
my lord. All these three cases.
Monday, my lord.
List these matters on Tuesday, not Monday.
Please.
Much. Lord, I filed application for
If interim order is there, extend. Yes. Huh?
No, there is no interim order.
If it is not there, it will not be granted.
In this
Implementing application I
petition,
filed.
it is fresh petition. It is fresh petition.
Implementing application I filed, my lord.
No, that also would be considered on Tuesday, my lord, along with the others.
Yes, my lord. That is also along with on
Yes, ma'am.
Tuesday,
Yes.
my lord.
Please.
IA number 1 of 2026, the petitioner shall file objections if any.
Please, ma'am. Much.
By the- Yes, next date of hearing.
Please.
Yes, 18.
Seal number 18, urgent seal number 19. Kiran R.
Appearing for petitioner in this case, your lordship. Your lordship, in this, the contract was awarded for completion of 22 independent feeders, wherein I've completed the project with certain extensions granted by respondent. I've submitted a letter, which is at Annexure A, asking for refund of the penalty that has been deducted. However, the certain internal communications happened, and thereafter Annexure B came to be issued by respondent number 5 to respondent number 1, that I have given the additional information.
Executive engineer, what is this letter dated 8/1/2021? You appear for the respondents.
Petitioners, senior.
Who appear for the respondents?
Yes, BS Kamte. Yes, or has come.
Huh?
BS Kamte.
The so-and-so is directed to take notice on behalf of so-and-so. The petitioner shall have the copy of the writ petition on the council. List this matter on Wednesday.
Obliged.
Yes, next.
Seal number 20. Bode Nagaraj.
Yes.
The petitioner's father was an authorized holder in distribution of essential commodities to the card holders. On 14/3/1993, authorization was granted. But the petitioner's father has died on 31/8/2025.
Is it is it transferable?
It is transferable, subject to
Heritable?
Yes, only for after death of my lord's original licensee, it is transferable for a period of my lord's 2 period, but that is 10 years in total. If he is not attained the age of 65 years.
Where is that? Where are those
It is there in the minutes.
rules or notifications?
Writ petition itself, they have filed, my lords. Kindly see annexure L in page number 29.
Annexure?
L in page number 29, my lords. That is amendment brought to the, my lords, the control order.
Let's read that.
Please. My lords, last para starts, my lords. Whereas the said gazette notification available public so and so, and whereas the objections and the suggestions received from the public have been examined and suitable changes made in the.
No, let's see. Provided that the authorized authority may order for such transfer.
Please.
In the event of death of the authorized dealer before 65 years of
Yes,
age.
yes.
So if he is
In the present
65
case,
years
he has
of age,
attained,
it is not.
he has attained 68 years. The father of the
68.
petitioner attained the age of 68.
Provided further that the person has no other source of income.
Yes.
To the spouse less than 65 years of age, unemployed son above the age of 18, unmarried daughter so and so, widowed daughter about the age of 18 years.
Having
What do you
passed
say?
10,
He is aged about murder. The petitioner aged about
Not the
41 years.
petitioner, the deceased is aged about 68.
68 years.
So how are you entitled? Look at it.
Annexure N, your lordship may kindly.
No, come to page 30.
Please.
Read it.
Please,
Read. Page 30.
please.
3. Amendment of clause 13.
Class 13. In the Karnataka Essential Commodities Public Distribution System Order 2016, in class 13, for the proviso to following proviso shall be substituted, namely, provided that the authorized authority may order for such transfer in the events of death of the authorized dealer before 65 years of age, provided that the person has no other. So this similar endorsement has been passed by this honorable court.
Where is that?
Annexure N, your lordship may kindly. Ink page 50, my lord, this starts from ink page 50, your lordship. Relevant, my lord, annexure, ink page 52, para number 4. Ink page 52, para number 4. The issue raised by the petitioner is no longer integra. This court has in several matters, including the order dated 5/8/2019, in WP number 10652 of 2019, held that the advance days of the earlier license who had expired would not be a ground to reject an application for transfer of license on compassionate basis. Applying the very same dictum to the present case, I am of the considered opinion that the petition is required to be allowed. As such, I pass the following order. But in annexure Q also, similar order has been passed.
No, let us see. Let us see what has been, what was considered by the court.
Writ of certiorari is issued, the impugned endorsement dated 24/11/2023.
No, it appears that in the entire order, they were only considering about 10th standard.
Please, 10th standard we have passed it, madam.
We are not on 10th standard. We are on the point that
Yes.
as on the date the deceased is more than 65 years old.
On compassionate grounds, it should not be, that restriction should not be imposed. So in several matters, this on.
Where are those several matters? Please show that. Now this judgment.
Annexure in N.
1 minute. This judgment at page number 33 deals with the qualification of 10th. It does not deal with the first one. So where is the other judgment you are relying on?
Annexure Q.
Annexure?
Q. 54, in page 54, madam. Para number 3, my lord, is the relevant. Ink page 55, para number 3. Petitioner is the son of original license holder, S. Chantan Gowda. The license was renewed from time to time. The father of the petitioner unfortunately passed away on 10/2/2025. After the death of original license holder, petitioner made a request to the authorities to transfer the license in his name. Representation came to be filed on 8/5/2025. Respondent number 3, without considering the provisions of the Karnataka Essential Commodities Licensing Order.
This also doesn't lay down that law.
Please.
It also doesn't, please read in where it is decided in this order.
Para number 4, Your Lordship.
Please read.
Learned counsel for the petitioner lays in orders in similar situation passed by this court in WP number 103733 of 2024, WP number 10048 of 2024, and in WP number 13559 of 2020 and connected matters. It is relevant to mention that in several writ petitions, this court has already decided the age and passing SSLC shall not be a ground, not be a bar for transfer of license on compassionate ground. Under these circumstances, the petitioner would be entitled to favorable order. Learned AG representing the state sustains the order passed by the authority and submits that in case this court were to agree to the contention of the petitioner, the representation so made will be considered in accordance with law. Petition is allowed. The impugned endorsement dated 12/6/2025 issued by the respondent number 3 at Annexure M is possible. A writ of mandamus is issued directly.
Absolutely, there is no nexus between the relief that is sought and the order that is passed. Now, the learned judge says it is already covered. Where is it covered? That you show.
In this case, writ of mandamus is issued to transfer the
Please
license.
understand, please understand.
Please.
You have to know this order dated 23rd December 2021 of Justice Dinesh Kumar is pertaining to the age of the children who are seeking on compassionate grounds. Basing on this order, this writ petition is disposed of by Justice Arur, which has no application to the facts of this case. Now you have to only tell the court which is the order that it is stated that 65 years is held to be bad. That provision is held to be bad. That amendment is held to be bad.
Anyhow, that has been upheld by this court but subsequently, by referring this judgment this judgment has been referred.
Understand, I can't pass an order without me understanding it. Isn't it? If I have to pass an order, I should understand and I should be convinced. I am not convinced with what you are stating. If you're relying on any order specifically dealing with the age of the father, then please place that. Then I'll hear it. This is matter after 2 weeks. Yes, next.
Bill number 21 urgent, bill number 22. Vijay Kumar P.
Yes.
Petitioner has challenged Annexure F and H of the order passed by the courts below. Lord, the Annexure F is the order passed on IA seeking for temporary injunction. Under Order 39, Rule 1 and 2. Lord, it was rejected. Subsequently, MA was.
The plaintiff or the defendant in the suit?
I am the plaintiff, my lord.
What is the suit for?
Suit is one for the permanent injunction as well as for mandatory injunction, stating that, my lord, after getting it surveyed, it was found that, my lord, about 3 cents on the northern side of my property, my lord, the defendants had encroached. And on the basis of that, my lord, the suit was filed along with the plaintiff, my lord, I filed IA seeking for temporary injunction under Order 39, 1 and 2. It was rejected. Subsequently, challenging that order, MA was preferred and this system has been conferred. My lord, there's the relevant portion, it is, my lord, in page number 46. Say that, my lord, the survey authority.
Come to the read from the reasoning part.
Please. Page number 46, my lord, they say that, my lord, earlier, my lord, the survey authority, my lord, issued me a.
Read.
Please, para 9. Para 9, my lord. I have perused the documents produced by the parties. At this stage, the plaintiff has produced the certified copy of the registered schedule 59/1983. On going through the same, it appears that the plaintiff has purchased a survey number 248 measuring 1.29 acres from the children of the Bhadravadi Shivappa for valuable consideration about 9,000. The plaintiff has produced the RTC extract of survey number 248B. On going through the same, prima facie it appears that the said property is standing in the name of the plaintiff. The plaintiff has produced the form number 3 of the suit's scheduled property, Khata 3/112B/0 issued by the municipality, HPRD. On going through the same, prima facie it appears that the suit scheduled property is standing in the name of the plaintiff. The plaintiff has produced the tax paid receipts. The plaintiff has produced the certified copy of the application dated 13/3/2025. On going through the same, prima facie it appears that the plaintiff has filed an application before the municipality, HPRD, requesting them to direct defendants to stop the construction work. Further, the plaintiff has produced the certified copy of the notice dated 17/3/2025. On going through the same, prima facie, it appears that the concerned municipality has issued the notice to the defendant number 1 to 3, directing them to construct the building by leaving the enclosed portion. The plaintiff has produced the certified copy of the survey notice, statement and survey sketch. On going through the same, prima facie, it appears that on the basis of the application filed by the plaintiff, the survey authorities have conducted the survey and issued the Hadbust sketch dated 27/2/2025. In the said Hadbust sketch, it was mentioned that the adjoining landholders of survey number 249 bar B4A have encroached 0.50 acre, it is cents, my lord, about cents of land, and adjoining landholder of survey number 249 bar 4B have encroached 2.50 acres of land. The relevant portion of the said Hadbust sketch is has under ಈ ನಂಬರ್ದಲ್ಲಿ ಬಾಂಡದಿಂದ ತೋರಿಸಿದ 0 acres ಸೆಂಟ್ಸ್ ಪ್ರದೇಶವನ್ನು ಬಾಜು 24 ಸರ್ವೆ ನಂಬರ್ನ ಹಿಡುವಳಿದಾರರು ಈ ಬಾಣದಿಂದ ತೋರಿಸಿದ 2.5 ಸೆಂಟ್ಸ್ ಪ್ರದೇಶವನ್ನು ಬಾಜು ಸರ್ವೆ ನಂಬರ್ನ ಹಿಡುವಳಿದಾರರು ಒತ್ತುವರಿ ಮಾಡಿರುತ್ತಾರೆ. It has been encroached and they have given me an endorsement. Now subsequently, the plaintiff has produced the photograph and CD. The plaintiff has produced the order of the Assistant Commissioner Hospete in case 66/2001 dated. The plaintiff has produced the certified copy of the license dated 18/2/25. The plaintiff has produced the certified copy of the blueprint. The plaintiff has produced the certified copy of the property number so and so and number so and so, MR number T65, MR number 95, MR number. On going through the license dated 18/2/2025, prima facie it appears that the defendant number 1 and 2 have obtained the license from municipality to construct the building in site number 3A 3B. According to the plaintiff, the defendants have encroached 3 cents of extent in the suit scheduled property towards northern side. As per the contents of the plaintiff, the survey authorities have conducted the survey, submitted the report, and 3
Yes,
cents.
I have seen.
Please. Because, now my application has been rejected, stating that the survey authorities, after making survey, they given a report that about 3 cents
That is
was.
stated by the appellate authority.
Please.
That is stated by the appellate authority.
On basis of that, my lord.
No, ultimately you seek a mandatory injunction. At this point of time, how are you entitled for that? Saying that the defendant is encroaching the property. How can that be decided? Basing on that survey
Now, my
report.
lord, they have 3 cents on my property. The construction is
In the
going on.
event, if you succeed in the appeal, succeed in the suit, that can be done.
Now, even, my lord, if I want to construct a compound wall also in my land, my lord, I can't do, my lord, since they have been
Anyhow, there is
going
no
on.
sufficient material before
Even,
the
my lord,
court.
they say that prima facie case I have not made out. Even, my lord, hardship to irreparable loss I have also incurred, since I am not able to construct or put up a compound wall in my property. Only, my lord, the hardship of the, my lord, the defendant is considered. As more of all, my lord, the survey authority, they themselves have given a report stating 3 cents have been encroached. Prima facie, my lord, they have given a report.
What are they doing now?
Please.
What is the defendant doing?
Building is being constructed.
Huh?
They are constructing, the defendants.
What is the extent of land which is in dispute?
3 cents in my lord, it is an open site, my lord.
3 cents is a big, it's a huge land.
About more than 1 gunta, they have encroached in my.
Please come. The present petition is filed. Agreed with the orders passed in I number 1, invoice number 102 of 2025 dated 2nd July 2025. The petitioner before this court is the plaintiff in the suit. He has filed the suit seeking mandatory injunction.
Permanent as well as permanent injunction.
Permanent injunction as well as mandatory injunction. An IA was filed, that is I number 1, under order 39 rule 1 and 2, seeking an order of temporary injunction restraining the defendants from making any further construction in the enclosed portion of the suit scheduled property. The court by order impugned has rejected the said application. While rejecting the application, the court has observed that according to the plaintiff, the defendants have encroached 3 cents of the land. In that regard, he is relying on a sketch that was issued on 27/2/2025. Per contra, the defendants have produced the order of the ADLR HP Halli in appeal number 1 of 2024-2025, dated 26/3/2025. And as per the same, the survey sketch issued by the surveyor on 27/2/2025 has been stayed by the ADLR HP Halli. And the ADLR has also stayed the survey work dated 27/2/2025. The plaintiff has filed the suit basing on the survey sketch dated 27/2/2025. The court has also observed that the plaintiff has not filed any document to show that he has questioned the said order passed by the ADLR. The defendants have produced a construction license dated 11/11/2024. On going through the same, it appears that defendant number 3 and 4 have obtained the license from the municipality for constructing the building. And the defendants have produced a Karnataka bank statement where a housing loan of rupees 65 lakhs was sanctioned to the defendant. The whole basis for the plaintiff to come before the court is the survey report, which has been stated. Hence, at this stage, if temporary injunction is granted, it causes injustice to the defendant. The plaintiff has filed the present suit for the relief of mandatory injunction and possession. If the plaintiff succeed in the suit, the rights will be protected by way of mandatory injunction. And basing on the sketch which is stayed with ADLR, the injunction cannot be granted, restraining the defendant from making construction. Next para. Land counsel appearing for the petitioner submits that the petitioner is the owner of the land, and in support of his case, he has filed the documents to show the ownership, which prima facie shows the title of the property of the petitioner. If the respondents proceed with the construction, that would cause a lot of hardship, and as a balance of convenience and irreparable loss or in favor of the plaintiff, the court ought to have granted injunction. The court, without considering all these aspects, had rejected the application. Next para. Having heard the land counsel, the petitioner per is a material non-record. This is a suit filed for mandatory injunction and temporary injunction. Here, there is no dispute with regard to the title of the plaintiff and the title of the defendant. The whole dispute is with regard to the encroachment of the plaintiff's land by the defendant. For that purpose, he has sought for a mandatory injunction and a permanent injunction. The petitioner has filed the suit basing on the sketch report dated 27/2/2025. According to him, that shows that the defendant has encroached the land of the petitioner, the plaintiff. That was appealed by the defendant, and in the appellate authority has granted stay of the survey and also the said report. In the light of that, the trial court has rightly held that at this juncture, the court cannot pass an order against the defendant, restraining him from making the construction. And if in the suit, if the petitioner succeeds, the court will grant a mandatory injunction. In the considered opinion of the court has rightly balanced the interests of the parties and rightly had rejected the IA seeking injunction, restraining the defendant from making construction. In that view of the matter, this court finds no reasons to interfere, accordingly dismissed. Yes, please.
At least direction will be issued for early disposal.
Huh?
Suit for
Suit is of which year?
25, not done.
25 suit.
Not sir.
Yes.
Seal number 23, urgent seal number 24. Shatab Hassan, sir. Yadwad.
Lords, appearing for the petitioners, Lords, my prayer may kindly be seen at page number 10, Lords.
Page number 10.
Please, Lords.
Yes.
Lords, what I am seeking in this petition to call for the tender is in respect of this property, Lords. Now, this property is a public property belonging to the respondent, and the same was allotted to be in the year 2009, and the same was extended in 2015, Lords. Now, what has happened, Lords? Without calling for the tenders, the respondent is trying to allot this property.
Please read the prayer.
Lords,
Please read the prayer.
Yes, Lords. Issue it in the nature of mandamus directing a respondent to call for the tender in respect of property that is public toilet block number H7 constructed at GLR survey number 324/1 situated at Belgavi, consisting of 8 public toilets and 3 bathrooms in the interest of justice and equity, Lords. Lords, this property.
Can there be a mandamus? Can there be a mandamus of this nature?
No, Lords. What I am seeking is already produced some Lords lease agreement. Lords,
That's the reason in respect of this property was earlier, as per the lease agreement, the same was allotted to me. And now, my lords, what I am seeking to call for the tender, my lords, in respect of this property, my lords. So I can participate in the tender, my lords, subsequent, because I have spent huge amount for the developing this property.
No, we will tell the respondents what to do, when to call for a tender, when to do what.
Now, why I'm asking, my lords, since I'm already in the possession of the property, spending huge amount. Now, without calling for the
We are
tender,
not concerned with that.
he's trying to allow
Entertain. The present seeking the following prayer. The prayer as sought for by the petitioner is not maintainable, and this court, exercising the jurisdiction under 226 of the Constitution of India, cannot issue a mandamus directing the respondent to call for a tender in respect of the property in the review of the matter. In view of this one, the writ petition is dismissed.
No, so I have sought this writ, my lords.
Yes, next.
My lord.
VC. Appearing through VC.
I appear respondent. What is VC?
Yes.
I am the caveat appear respondent.
Yes.
This copy has already been served to the other side, my lords. Which is the Copy served. plaintiff. May I, my lords?
Papers of, you're ready?
Yeah, sir.
Yes.
Yes, my lords. Plaintiff's amendment application for the amendment of plaint came to be rejected, my lords. Plaintiff wanted to insert
What is the
certain
suit for?
suit for partition,
what is the suit for?
partition and separate question, my lords.
You are the plaintiff.
I am the plaintiff, my lords.
What is the IA?
Well, IA is for amendment of plaint, my lords. Plaintiffs wanted to insert of about 5 properties.
No.
Yes.
Suit is of which year?
My lord, suit is of the year of 2013, my lords.
2013, you
Please.
want to amend the prayer in 2025.
My lords,
What is the amendment you are seeking?
I wanted to I wanted to insert certain 5 properties which were purchased by my father in the name of second defendant when she was not residing with us, my lords. So that he admits during his cross-examination in the year of 2018, and it is part and parcel of his deposition, my lords. What prevented us to seek this amendment belatedly was, my lord, till 2024, my lords, there was a writ petition pending which was disposed by this honorable court, holding that defendant number 2 can continue as defendant number 2, as well as the children born out of defendant number 2 and first defendant were continued to implead as LRs of defendant number 1, my lords. That issue was pending and we were contesting, my lords. And in fact, the defendant number 2 they filed written statement on 16/8/2022, and the trial court framed additional issue on 18/8/2022, my lords.
Yes.
So that's why, my lords, at the earliest we could not file, my lords.
Come to the order.
Yes, my lords. Impugned order, my lords. The reasons will start from ink page 27, please, my lords.
27.
Please, my lord. Para 8, my lord. The trial court says, my lord, admittedly, this suit is filed by plaintiff seeking relief of partition in separate possession. On perusal of the application IA 58, it is apparent that plaintiff has intended to insert item number 10 to 13 and 14, the properties as joint family properties. In the amendment sought, they have sought only to insert 10 to 14. No additional pleading is sought to be inserted as to how these properties are joint family properties. Only accompanying affidavit of plaintiff 1 has contended that these properties were purchased by NG Nagendrappa in the name of second defendant, with whom he had illicit relationship by using joint family funds. Absolutely no reasons are assigned by the plaintiff as to why there was a delay in inserting these properties. At one breath, plaintiff number 1 has contended that the second defendant is not the wife of NG Nagendrappa, but she had illicit relationship with NG Nagendrappa. Secondly, he has contended that these properties were purchased by NG Nagendrappa in the name of second defendant by using joint family funds. Dual stand taken by plaintiff number 1. Further, as this application is filed under Order 6/17, due diligence is to be shown. This suit is filed in the year of 2013. Trial is already concluded, and the case is posted for arguments on merits. There is absolutely no diligence shown by the plaintiffs. Further, there is no reason signed in the affidavit as to why such amendment was not sought earlier point of time. Even the affidavit annexed to this IA 58, plaintiff 1 has specifically claimed that these properties were purchased in the name of defendant Number 2, these are new facts which have been tried to be inserted. New facts are pleaded. There is nothing pleaded earlier in the plaint stating N.G. Nagendrappa had purchased these properties in the name of second defendant number 2. Even now, there is no such prayer to insert such pleadings. Therefore, the amendment of plaintiff is trying to introduce altogether new facts which changes the very nature of the suit. There is absolutely no due diligence shown and no reason assigned as to why this application is filed after such delay. There are no bona fides also. Suit was filed in 2013 and we are in 2026, and this case has taken more than 30 years to complete trial. When second defendant is not admitted to be family member of the properties standing in the name, cannot be termed as joint family properties. The plaintiff has not properly explained why all these years since 2013.
Yes.
Yes.
My lord, this is now it is posted for argument last occasion. They have filed 5 applications. One is, my lord, this amendment sought. Another one is for impleading. Third one, they have not challenged. I number 57, 59, 60. They have another.
That defendant number 2 is not the wife. Why was she impleaded?
Please, madam.
You appear for defendant number 2.
Yes.
According to them, defendant number 2 is not the wife.
Not the wife.
Then why was she impleaded in the suit for partition? Yes, Mr. Counsel.
My lord, they
defendant number 2 is not a member of the joint family.
Yes,
why was she impleaded as defendant number 2?
As during the pendency of the suit, my lords, during 2021, my lords, the plaintiff, the first defendant died, my lords. They came on record by filing necessary applications to implead themselves as defendant number 2 to 5, my lords.
Now you want to amend the prayer, but you don't want to amend the pleadings. Without pleading, what is the effect of a prayer?
No. It's my respectful submission, my lords. These properties which were sought to be inserted in the plaint, which were the properties which were purchased by my father when he was having relationship with the second defendant. Please, please.
Whatever it is, by amending a prayer and without there being any pleading with that regard, what is the consequence of it?
In the plaint, there is a para stating that the properties, subject matter of the properties are joint family properties, my lords. The properties which are purchased by utilizing joint nucleus, my lords. In fact, in the evidence of my father, when he was subjected to cross-examination, he admits that he has purchased properties in the name of.
You're not answering the query of the court.
Yes, my lords.
Now you have said A, B, C, D is a joint family property, which is purchased by your father in the name of defendant number 2.
Yes.
But you do not, there is no amendment to the pleadings with regard to this, that out of the joint family proceeds, this property is only you want to amend the prayer. Any prayer without the pleading, what is the consequence and why should the court do it?
Except one line that. Except that one line.
You didn't want any pleading to be amended. You didn't want any additional amendment to the pleadings.
Unfortunately, that line they did not seek, my lords, but that will not prevent the plaintiffs to agitate their case, my lords, because my respectful submission, my lord.
2013 suit, we are in 2026.
Please, my lord.
You know about this in the year 2018.
Yes, my lords, but till 2022, my lords, till 2024 February, the issue of allowing the defendant number 2 and her children as a part of defendants was pending before this honorable court, my lords, and there was an inquiry held on that point, my lords. That got decided in the year of 2024. Admittedly, my lords, 2022, 18/8/2022, additional issues were framed on defendant number 2 filing written statement, my lords. I do consider, my lord, there is some delay, but that will not take away the legitimate right of the plaintiffs where my father himself has admitted.
Not only delay, and the amendment as you sought right now, it can't be allowed.
My lords, my respectful submission, my lords, the trial court has went to the merits of the matter instead of considering the IA, my lords. It has held that the defense new case is set up, my lords. Absolutely, there is no new case set up, my lords. My respectful submission, my lords.
The agreed with the order passed in I number 58 in voice number 15 of 2020.
I would like to place on judgment, my lords. My colleague will place the judgment, my lords. Insofar as due diligence, my lords.
I've seen the judgment.
Yeah, pass.
I've seen recent judgment of
Justice A.R. Agde. Yes, my lords.
I've seen that.
Yes,
We
yes.
have to apply the same to the facts of the case.
True, my lords.
No
Insofar as
judgment cannot be applied.
I understand,
The
my lords.
present
My lords, my
petition is
response to
fine.
submission, my lords. If these properties were not inserted, it will lead to multiplicity of proceedings, my lords. That is what my
I asked you,
apprehension.
where is the pleading?
Lords, that
Without
one
a
line,
pleading, what is the prayer? IA number.
we are relying on only one line of the pleadings which is available in the plaint, my lords.
Notice number 15 of 2013 dated 13 January 2026. The plaintiff is before this court. The plaintiff has filed the suit seeking partition. Defendant number 2 was later impleaded in the suit, as it is the case of the defendant number 2 that she is the wife of. She has married the father of the petitioner, plaintiff. When the matter is posted for argument, at that stage, the SIA number 58 is filed under Order 6, Rule 17, inserting item number 10 to 14 of the scheduled properties in the plate. The court, by order impugned, has dismissed the same.
May I request one thing, my lords, before. My lords, if permission be granted, I'll file fresh application, my lords. That may be considered, my lords.
Why should
Just
the
one
court do
line.
it?
My lords, my response,
No,
because
why
it
should
will
the
lead
court
to,
do it?
well, if these properties were not inserted, my lords, it leads to multiplicity of proceedings, my lords. Because all along from
Nobody's talking.
2013,
No, already you had enough time from 2013 to 26.
true, my lords, but the properties which were not implemented, I mean, not inserted, my lords, it lead to multiplicity of proceedings. My lords. All along, I've been contesting the matter, my lords. One opportunity, my lords. We will not seek much time, my lords. We'll immediately file application. Anyways, matter is posted on 9th, my lords.
They are already advanced argument yesterday, my lord. It is only posted for Monday for submitting citations. That's all, nothing else.
It's in citation.
Before the trial court.
Because though we intimated the trial court, my lords, about the pendency of
The
this
trial
matter.
court has observed that in the entire affidavit, in the petitioners have not filed, has not sought for amendment of the pleadings. No, they want these properties to be inserted. At one stretch, they say that they have no relationship with defendant number 2. And at the other stretch, it is a case that the properties which are purchased in favor of the second respondent belongs to the joint family. The court has also observed that the petitioner, there is no due diligence on the part of the petitioner. The suit is filed in the year 2013. Until 2026, they have not taken, until 2025, they have not taken any steps for seeking the amendment of the pleadings and accordingly dismiss the petition. When counsel for the petitioner submits that unless and until these properties or unless and until this amendment is allowed, it would cause a lot of hardship to the plaintiff. It is submitted that though they are aware of this in the year 2018, in view of the in view of the pending writ petition before the High Court, they could not come up with this application before the court. He does not dispute the fact that they have not raised any pleadings, additional pleadings, sought for any amendment, but only they wanted the properties to be included as the joint family properties. Next paragraph. When counsel and the petitioner counsel has relied on an order passed by a coordinate bench of this court in WP number 108512 of 2025, dated 16th December 2025. He relied on paragraph number
25 minutes.
What is that?
25 minutes.
He relied on paragraph number 25. Extract this. Relying on this, it is submitted.
25C, where I exactly fall.
It is
certain
submitted
developments
that
which
the due diligence as observed by the court. In the light of this order, the petitioner is entitled for a the petitioner is entitled to seek amend the pleadings even at this stage. It is submitted that the court, without considering the impact of the consequences of the same, had dismissed the petition. Next, Land Council appearing for this defendant number 2. You appear for defendant number 2.
Please, madam.
You appear for all defendants.
All dependents.
Huh?
All, please, madam. 1, 2, shoot. Lalitamma. Yes, ma'am.
So, Land Council appearing for the defendants submits that the matter, the petitioner, in fact, the matter has come up yesterday and the petitioner has advanced his documents. The matter is posted to Monday only for the
I was
purpose of,
constrained to address my arguments minutes because
the
though we
purpose of
intimated the
filing
court.
for the purpose of filing the citations. It is submitted that the petition, the court had rightly considered all the aspects in detail, how the amendment is not permissible at this stage and rightly dismiss the petition and there are no grounds to interfere. Next part. Having heard the counsel for the, on either side, there is a material non-record. A suit of 2013, the IA number 58 is filed under Order 6 Rule 17 to insert some of the properties of, as a joint family properties. It is the case of the petitioner that is aware of the same in the year 2018. The matter is, when the matter is posted for arguments at that stage, they have come up with this application. The court had rightly observed that except inserting the properties as a joint family properties, the petitioner has not even amended the pleadings, nor it is his case that why these properties have to be included as the joint family properties. Any amount of the evidence or the prayer that the inclusion of these properties as joint family properties without there being any pleadings or inconsequential. The court has rightly considered this aspect and rightly dismissed the petition. The judgment which the petitioner has relied on as to any judgment has to be applied to the facts and circumstances of the case. In the considered opinion of the court, the judgment which the petitioner is relying on does not apply to the facts and circumstances of this case. And in the considered opinion of the court had rightly dismissed the petition and this court finds no reason to interfere. If these kind of petitions are allowed after 13 years, the whole purport of the amendment, the purport of the amendment, the fixing of the timeline for every under the CPC is only for the purpose of a speedy disposal of the case. And if in the manner in which this application is filed, and if this court allows, then there will not be any end to the litigation. And for decades together, the matters cannot be decided.
Please.
Yes. Next.
Number 27. Dilraj, Rohit, Square.
Petitioner, my lord, seeking parole for himself, my lord. The lordship may kindly see, my lord, page number 18 is the endorsement issued by the jail authorities.
They have rejected the parole.
Rejected the
Petitioner is, what are the offences?
My lord, they have specified, my lord, there are several offences, my lord, almost 25 offences. In that, my lord, most of the cases, my lord, ended in acquittal.
No,
my lord,
now he is in jail under which, he is convicted under which provision?
under COCA, my lord, and section 302, 307 of IPC.
When was the conviction?
My lord, this is dated 4/4/22.
4/4/22.
22.
Why, what is the reason for the parole now?
My lord, his father expired, my lord, on 29/4/2025. 4/2025. My lord, during that period, my lord, for 12 days, my lord, he was granted parole with police escort. My lord, he has spent, my lord, almost 5 lakhs towards the expenses, my lord, traveling and police escort. Now, my lord, Shraddha has to be performed, my lord, as per Hindu culture, my lord. And for that, my lord, he needs a minimum of
No, you said the death was on 29/4/2025.
25, almost 1 year back.
Huh?
Almost 1 year, my lord. Another 3 months, my lord, 1 year back.
Hmm.
During those days, my lord, from 3/5/2025 to 14/5/2025, he was on parole.
for 12 days, emergency parole.
Now now the parole is sought for what time?
To perform that final rites, my lord, Shraddha.
What is the time?
Now, the requisition was for 90 days, my lord.
That can't be considered.
Minimum, my lord, their lordship, as this honorable court deems fit, my lord. As this honorable court deems fit, my lord, minimum period, my lord,
That is
15,
for a day.
15, minimum 15 days.
No. We will not. And with these kind of offences, obviously entitled.
Leave it to the court. At least for 1 week, my lord, he has to perform the
Lords,
puja.
the-
Nobody's there.
What has happened when
He's the
when he was
eldest son,
released
my
on
lord, and
parole on the
nobody-
last occasion?
Lords, he is a habitual offender. He is a habitual offender, involved in, my lord, so many cases. And his associates also not provided the parole by this honorable court. His associates.
No, what is the endorsement for rejecting the
Endorsement
parole?
issued, my lords, kindly see page number 21.
Please read that.
My lords, last one. My lords, according to rule 22 of the, my lord, prisons rules, under section 191(2)(j)(1), a prisoner who has been classified as a habitual criminal for the purpose of these rules and who had more than 3 convictions or against whom cases or bail applications pending.
Why did they grant earlier then?
As earlier was a emergency parole. His father was, my lords, expired and he was been enlarged in, my lords, emergency parole. Now he is seeking for
You're the
performance
only
of
son?
1
Only son, my lord, other brother expired.
my lords, performance of rituals of 1 year.
He's the only person, my lord,
Allah,
nobody else.
he has been released on, my lord's, emergency parole only to, my lords, my lord, perform the last rituals of.
What happen if we grant for 1 day? 1 day under the escort.
My submission is, even his.
Get instructions on this.
Please, next.
1 day we'll grant him parole, only for that particular day where he has to perform the rituals.
No, at least for their lordship, kindly consider, at least for
When
1
is
week.
that? 4 months' time is there still for that 1 year period. Let him get instructions. This is matter on
16th, ma'am.
on 19th of February.
16th, my lord, because I have one more matter here. I have to come from Bangalore.
16.
Please, please.
Get instructions.
Yes.
For a day. Yes, next.
Number 28. Narsamano.
Seeking to pass the annexure B, my lord, so far as imposition of 12% forest development tax, my lord.
Let's see. Please come to the prayer. What is the prayer you seek? Sale intimation letter issued by respondent number 3. Who is respondent number 3?
The deputy conservator of forest.
Conservator of forest. Yes, what is wrong with this order?
My lord, the division bench of this honorable court held that, my lord, the amendment of Forest Development Act 2016 is ultra virus, my lord. My lord, the same issue
Imposition
is
of
pending.
12%. Imposition of 12% of, my lords, the forest development tax is, my lords, set aside.
See the letter.
Yes.
Where is that letter?
And against which, my lords, the.
Page number 10.
Unfortunately, the problem is,
Please.
what is the judgment, how it applies to the case. In every case, that order is cited and orders are passed. How the petitioner will have the benefit of the order, we have to see.
My lord, page number
What is
10.
the sale notice? Come to the
Page-
notice.
Page number 10, my lord.
Yes.
Page number 10, my lord, the FDT column, my lord. FDT column. The 12% FDT has
Sale
been.
intimation letter.
Yes.
What is the name of the petitioner?
Vagish T.
Tipani.
Gangai. Please, petitioner.
Period of auction. We are pleased to so and so. Your requested deposit payment as per the schedule below. Total mark. FTD so and so. What is that writ petition where I have passed order? You have the copy of that?
My lordship not passed any orders.
That forest one, as far as. Yesterday only I signed that order. Similar order. Yesterday I signed it. Maybe I have taken it. Yes. Next.
Number 29.
Take notice for response. In this case, take notice.
So and so takes notice.
Here for the petitioners council.
Number
Lord,
29. Srinivas Nayak.
we came with a voluntary retirement scheme for all our employees, and this employee opted for it. And he's been paid his entire amount of money, and then he's left the services. After about 8 months, he files a 2A application before the before the labor court, making a claim that the entire VRS scheme is bad. That, of course, has to be a collective dispute, if at all. That, of course, not. And as soon as the notice is issued, we've come to your lordships challenging it, because one judgment of the Andhra Pradesh High Court has answered this question, saying once there is a VRS scheme, there can only be a collective dispute. It can't be an
But that can be, the same thing can be informed to the.
no, I
labor
know.
court.
But what happens, my lord, is then there'll be a large number of people who start coming. This whole difficulty is, may I just pass on one judgment to your lordships? Because we are asking for a writ of prohibition in this case. And your lordship will kindly notice, my lord, that if at all there's a collective dispute, and then this honorable court has also held that he ceases to be a workman if he accepts a VRS. And therefore he can't be a workman at all under the Industrial Disputes Act. May I humbly request, my lord, to look at this judgment? My lordship has that judgment. Can I humbly request, my lord, to look at para 19 at page number 9, my lord, para 19. And this is the same exact issue occurred in that case as well. And it was challenged immediately. It is the contention of the petitioners and the IDs that they were illegally retrenched under the guise of VRS. They claim that their consent was obtained under coercion and by force. Therefore, they would have the right to address the grievance in this regard before the Labour Court by invoking Section 282 of the Act. On the other hand, petitioner company contends having availed voluntary retirement. Petitioners and IDs are no longer workmen within the meaning of Section 2S of the Act of 47. Reference is made to the definition of retrenchment, which specifically excludes voluntary retirement of the workman from its ambit. Delay on the part of the petitioners and the IDs raising this dispute is also pressed into service as a ground to urge Labour Court would have no jurisdiction to entertain the petitions. It's only the question of jurisdiction. Then, if my lords kindly come to para 24, arguments are there. I'm not troubling your lordship with the arguments. His lordship then examined it. However, the third contention raised by the petitioner company as to the Labour Court not having jurisdiction under Section 2A, owing to the nature of the dispute sought to be raised by the petitioner in the ID's merits consideration. The threat of judicial thought as voiced in the decisions referred to supra clearly indicate Section 2A has been put in place to redress the grievance of an individual workman, which constitutes an individual dispute relating to dismissal, discharge, retrenchment or termination of service of such individual workmen. A collective dispute affecting a large body of workmen cannot be equated to an individual dispute, redressable under Section 2A of the Act of 1947. Such a dispute would necessarily have to be addressed collectively by use of the machinery provided in the Act, which requires a separate process altogether. Same cannot be brought before the Labour Court by way of a petition under 2A2. In the present case, allegation of the petitioners, the IDs is that more than 150 employees were subject to coercion and force to agree to the VRS. Further allegation is that terms and conditions of the VRS were not lawful and proper. Merely because each of the petitioners and the IDs were relieved from service on the basis of said VRS, it cannot be construed to be an individual dispute pertaining to them independently. They all stand on the same footing. Relevant to note, only a select few out of the beneficiaries are before the court, but the adjudication resulting from the claim would affect all of them. Dispute being not individualized necessarily had to be addressed collectively. Merely because the impact of the collective dispute is felt individually by each of the petitioners, it cannot be equated to an individual dispute pertaining to an individual workman so as to bring it within the said provision. This aspect ought to have been gone into by the Labour Court at the initial stage before issuing notice upon the IDs to the petitioner company, as it goes to the very root of its jurisdiction under Section 282 of the Act of 1947.
I think in that the petitioners in number have gone. In this case,
In this case, not this one now, and then we've just received notice of another 16. So the same lawyer, my lord, files one, and then they start filing again. They get notice issued, and then they file again. The failure on the part of the Labour Court in doing so clearly demonstrates Labour Court was on the verge of usurping and exercising jurisdiction, which it did not have under that provision, and then Lord, it struck it down on the ground law that it is illegal exercise of jurisdiction.
No, I'm not able to understand what exactly is the ratio laid down in this.
The ratio laid down.
They're dealing with what I could understand from this is the group of people have approached the court, approached the Labour Court, questioning under 2A, questioning the VRS scheme. He said the observation of the judge is it is an independent dispute under Rule 2A of the under Section 2A of the ID Act, but not the group of people cannot go.
No. 2A can only be done by an individual employee. So only an individual employee can file a complaint. Here also, not individuals had filed complaints.
No, here the group of people have gone.
No, 150 of them. But my lord will kindly see, there were, please see the petitions, my lord. First question in the first page. Have the jurisdiction to entertain. Number of petitions were filed. If your lordships kindly see ID number 72 to 80, 87, 14 to 19. All of these were individual petitions because a collective petition can't be filed under 2A2. It has to be, my lord, individual workmen grievances only.
What will happen is if we start entertaining all these red petitions, now 16 you have received notice. So why should we do it?
No, but-
We will tell the labor court to do what they are supposed to do.
Ultimately, my lord, if I want to show you lordship, one judgment of Karnataka High Court as well, which answers this question, saying in a VRS scheme, he's not a workman at all. The second he accepts a VRS scheme, he ceases to be a workman. Please see this judgment. At page 17. I'm sorry. The same question again of a VRS scheme of a ladyship Justice Hemleka. Can I respectfully request, my lord, to look at para 19, my lord. Once the workman has opted for voluntary retirement and having taken all the benefits under the VRS scheme, workmen cannot now contend or dispute that the voluntary retirement was obtained by force or undue influence. The relationship of employer and employee comes to an end on receipt of his retirement benefits. This is not a case where the infirmity in the reference can be shown only after evidence has been adduced. It would be a futile exercise.
Idea.
Yes.
So what is the procedure
So-
followed by the tribunal when application is filed before that?
My lord, what they have to do is they have to make a collective reference under 10, under section 10. Then, my lord, it goes through the process of conciliation. Then, my lord, I get a chance also to participate in it. After I participate in it, they file a reference to the labor court if, my lord, there is no answer to the entire issue. But an individual workman can't go saying, because, my lord, if your lordship sees a claim that they made before the labor court, it is that the entire scheme is invalid. But that can't be done individually. That is a jurisdictional question.
We will see what the tribunal will do once any application is filed by any workman.
Individual, my lord. 2A, my lord. Lordship, may kindly see section 2A.
Yes.
Where any employer, my lord got that? Where any employer discharges, dismisses, retrenches, or otherwise terminates the services of an individual workman, any dispute or difference between that workman and his employer connected with or arising out of such discharge, dismissal, retrenchment or termination shall be deemed to be an industrial dispute, notwithstanding that no other workman or no any other union of workmen is a party to the dispute. Therefore, this is as your lordships remember, my lord, earlier there was only a union who could go on behalf of the workmen. So even if one workman was removed, the union would go on behalf of the workmen. Then they realized that asking the union to go every single time would be difficult.
No, I absolutely understood
Yes.
what it is. What is your submission? I'm only looking at the point. What is the labor court even before issuing the notice to the respondent? Is there any application of mind is
Yes, ma'am.
required? Where is that? That we will see.
That is exactly 2A, because 2A, my lord, itself provides that it has to satisfy these requirements.
Where are the tribunal and which provision deals with it? The labor courts. And once an application is received under section so and so,
that-
what is the procedure to be
That
followed?
that is not there in the act. That's not there in the act. That is what Justice Sanjay Kumar, my lord, holds when he passes the order saying you must apply your mind at that point in time.
That's a case where an order is already passed. No, we don't know. What is that the labor court wants to do?
In that judgment also, no order was passed. It was only order of notice. Before no, it was not a final order, my lord.
A few with the notice, that I'm not able to understand.
My lord, please see, this is an issue where only notice was issued.
Tribunal is also a tribunal which the party will go and submit.
Yes, that of course, I knew your lordship would ask me that question, which is why I'm relying on this judgment, because here was a simple case. Please see what it was done. The last page, my lord, first line on the top of the page of Justice Sanjay Kumar's judgment. This aspect ought to have been gone into by the labor court at the initial stage before issuing notice upon the IDs to the petitioner company, as it goes to the very root of its jurisdiction under 2A2 of the Act of 1947. The failure on the part of the labor court in doing so clearly demonstrates the labor court was on the verge of usurping and exercising jurisdiction which it did not have under that provision. As your lordship will see, it was a batch of writ petitions filed. At the first page, it was one writ petition number 724 and batch. The entire batch was before the court. Therefore, my lord, your lordships will appreciate, under 2A, not more than one workman can file. Only one workman has to file. Each of the others is an individual dispute. And that is how, my lord, 2A applies. But
No. If the writ petitioner goes before the tribunal, what will happen?
my lord,
What is issued to you is a notice.
issues notice, my lord.
Then
But
you say that they are not entitled to issue notice, that you can tell the labor court. What happens is, Now, when particular tribunals are constituted, we should let them do their work.
I know, my lord, but not when they don't have jurisdiction,
They
very
will not
clearly.
understand, no, prima facie, when they say that this is a problem. Anybody would like to know what the employer says. That's how a notice is issued to you.
My lord,
Go before them and tell them that that is not maintainable. He will, if he says he entertains it, then at that point of time, the petitioner can come before the court. No, this is too premature, the stage.
I can only point out to your lordships, my lord, both this honorable court, in the other judgment which I pointed out.
All these judgments, whatever, now, according to me, this is Sanjay Kumar judgment, if it has entertained, as of, I am not inclined to entertain the writ petition at this stage. No, this writ petition is on the merits of the matter, I think.
No merits. Here also it was an order of reference which was challenged before the court. Again, an order of reference was set aside by this honorable court, saying, my lord, but please appreciate this, my lord. If your lordships permit also people to go to labor court at the stage, my lord, after they accept the VRS, and in this case, we paid not 4 times the retrenchment compensation.
I'm not at all on the merits. I'm only on the procedure. Why, when a notice is issued by the labor court, what you're telling the high court, the same thing can be said to the labor court. And if the labor court is not understanding, then at that point, come to the high court.
Of course, my lord.
Be the procedure.
No, that is one stage, which is why, my lord, your lordships know that either I get a writ of prohibition or a writ of certiorari. Certiorari is after the order, but prohibition is not before the order.
Now the notice, now once you go and tell the court that in the light of these judgments, you can't entertain. No, it's not that high courts don't have any work.
No, my lord.
Work.
We are all before your lordships all the time, my lord. But, my lord, I think in this case, your lordship must, my lord, at least lay down some law, at least from our high court, saying
The law is already laid down.
that is true. I'm saying, my lord, what I'm humbly submitting is your lordship may then please consider this. Ultimately, as an employer, my lord, I have now defended so many other proceedings in court for no fault of mine. And in a proceeding which inherently, my lord, has to be answered in only one way, and that it has no jurisdiction.
That labor court only.
I'm sorry, madam?
All of them have to go to that labor court. You don't have to go to several other.
No. Labor court may be the same. Labor court may be the same. Like I've come to your lordships, not now. We'll of course have to come before my lord. But ultimately, my lord, after 8 months, it can't be a scenario, my lord, where the workmen say they've received almost 4 years of wages. In this case, my lord, 4 years of wages have been paid straight away at the time of VRS. That was a scheme. After that, they come and start another process saying, now you go and defend the entire proceeding before the labor court. And whether the labor court will consider it as the first stage, or not will say, I'll decide finally.
Direct the labor court to decide the maintainability of it in the light of these judgments at the threshold.
I know your lordship's discretion is there, but I can only persuade my lord to see.
If the labor court says anything and not understanding what are the judgments, then it's altogether a different issue. We'll tell them to, I'll say the labor court we'll keep this pending, we'll keep this writ petition pending, and say the labor court, I'll record your contentions and say the labor court shall decide this, and whether whether the employees are entitled, whether the workmen are entitled to raise a dispute under section 2A in the light of the fact that already the VRS scheme is over, and particularly in the light of these 2 judges.
Yes.
So that what will happen is, by the time you get, how many of people have taken VRS?
Everyone, almost everyone, because 114.
So without 114 and you coming to this court with this one writ petition, that they will decide it, it will be over. Then you will get an opportunity to come before the court.
Yes.
The present writ petition is filed, seeking the following prayer. Then a senior counsel appearing for the petitioner submits that the petitioner is a private limited company and incorporated in the Companies Act and the year 2019. The petitioner company is operating a factory located at plot number 260-262 Belur Industrial Area, Dharwad. In and around April 2025, the petitioner company decided to close the operations at the Dharwad unit due to heavy underutilization and a challenging business environment. And on April 16, 2025, the petitioner company intimated to all the employees at Dharwad unit through publication on all 10 notice boards in both Kannada and English, and offered 2 initiatives, a voluntary retirement scheme and internal job postings. The petitioner received the respondents, the employee along with the respondent signed application. The petitioner received the application of the respondent along with other applications from other employees numbering
114, 114.
114 under the opting for voluntary retirement scheme, including option for the early bird payment of INR 50,000. On April 27, 2025, the petitioner company accepted the respondent's application for the voluntary retirement scheme under the acceptance letter dated April 27, 2025. And it was agreed that the petitioner's it is agreed that the respondent's last working day would be on May 15, 2025, as his services were required for the functioning at the Dharwad unit. Then on May 15, 2025, the petitioner and the respondent entered into a settlement agreement, and where a lump sum amount is paid. That as per that, the petitioner, the employee is eligible for a lump sum ex gratia payment, that is 2 months salary for every completed year of service till the date of exit under the scheme. An early bird offer incentive of INR 50,000 along with gratuity and encashment of unused leave bonus due. And the payment under the voluntary retirement scheme and the settlement agreement are towards full and final settlement of all contractual and statutory entitlements that the respondent may have in connection with their employment with the petitioner. And as per the same, the employee, the respondent waives and releases the petitioner from any notices, claims, demands, damages, lawsuits, obligations, promise and cause of action. On May 19, 2025, the petitioner company has transferred an amount of rupees 19,53,891 after deducting the TDS. Then on August 16, 2025, the petitioner received a legal notice issued on behalf of the employees of the petitioner company, alleging that the petitioner was supposed to give notice prior to removal, termination of the employees, and that the scheme was implemented forcibly. Then the respondent has filed a case before the Labour Court Hubli, that is case number 4 of 2026, and the notice was issued to the petitioner company, which was received on January 12, 2026. On January 30th, 2026, the petitioner appeared before the Labour Court and sought a short adjournment to place on record. What is this?
They placed me ex parte. I appeared. I said, I want to file my wakalatnama, give me a week's time. Labour Court said, it's your place ex parte and post it straight away for issues and evidence.
No, you're set ex parte.
I'm set ex parte as of today. Anyway, I'll make an application to recall that order.
Set ex parte and post it to January 9, 2026 for further proceedings. Then a senior counsel appearing on behalf of the petitioner submits that the application or the industrial dispute that is raised before the tribunal is not maintainable, is no more an employee of the respondent firm. It is submitted that in this particular case, already an amount of rupees, after receiving an amount of rupees 19 lakhs and odd, this dispute is raised before the tribunal. The tribunal ought to have considered the same before issuing the notice to the petitioner company, whether such a dispute can be raised by a employee who has taken voluntary retirement. He had relied on two judgments. One is in the case of Bayer Bioscience Private Limited, Hyderabad, or the judgment of the Andhra Pradesh High Court in Bayer Bioscience Private Limited, Hyderabad, versus presiding officer, Labour Court 1, arising out of WP number 724 of 2008 and batch. Then the senior counsel has relied on paragraph number 9,
19,
11, this is 9, relied on
actually 19, Lord.
paragraph
19,
number 19,
19, 24, and
24,
24 to 26.
24?
To 26.
24 to 26, extract that. He has also relied on judgment passed by coordinate bench of this court in case of Triveni Turbine Limited versus Government of Karnataka. Reported in 2024 SEC Online Karnataka 12884. In this, he relied on paragraph number
19. 19.
paragraph number 19. Please extract that. Relying on this, this judgment that is submitted that in these cases also, when a notice is received by the company where the employees who have taken voluntary retirement has raised the industrial dispute, in both the cases, High Court of Karnataka as well as the High Court of Andhra Pradesh has interfered with the same and has passed orders. It is submitted that as they have about 150 employees have opted for the voluntary retirement. Now, if now one after the other, the petitions will be filed, and it would be difficult for the petitioner to defend the cases. Once an order is, in the light of this, if this petition is entertained, and this court adjudicates whether such an application under 2A is maintainable before the labor court, the issue will be settled. Next para. Having heard the senior counsel for the petitioner peruse the material on record. There is no dispute about the fact that in the similar circumstances, the division benches of Andhra Pradesh High Court and also a coordinate bench of this court has interfered with the writ petition and passed an order. As a matter of procedure, this court is not inclined to entertain the writ petition at this stage, though the petitioner might have a case on the merits of the matter. The employee has knocked the doors of the labor court. Labor court has issued the notice to the petitioner herein. If the court, if the labor court, under the light of these judgments, it is submitted that the labor court has no jurisdiction to entertain these petitions that are filed under 2A. This aspect has to and need to be decided by the labor court immediately, and thereafter the court, because there are about 150 employees.
114. 114.
114 employees have taken VRS instead of issuing notices in every case. First, this issue has to be decided by the labor court, and basing on that, the remaining applications, if any, shall be decided by the court. This court is not proposing to issue any notice to the respondent, as no adverse orders are passed by the court. Accordingly, this writ petition is disposed of, directing the family court, directing the labor court to difficulty of sitting the family, directing the labor court to decide the maintainability of the petitions that are filed under Section 2A of the Act in the light of the judgments passed by the Andhra Pradesh High Court in Triveni Turbines Limited versus Government of Karnataka.
Triveni is Karnataka. Triveni is Karnataka. Beer is Triveni is Karnataka.
Yes, it's Triveni. This is both in the light of those two judgments.
Lordship may fix some time limit, Lord. Otherwise,
The labor court shall, by giving the hearing to both the parties, shall decide the same within a period of 4 weeks from the date of receipt of the copy of the order. Yes.
Orders matters. Number 30. 14 person. Ravindra Naidu.
No representation. This is matter after 4 weeks. Yes, 31.
31.
No, in this matter, no representation. The needful shall be done within a week, or else the writ petition shall be dismissed without further reference to the court. 31.
Number 31.
31 also.
Rest mode.
31 also same order. Yes, 32.
Number 32 urgent. See number 33.
Yes, 33.
Abhijit, yes.
Your Lordship, in this matter, earlier we have filed a affidavit also, Your Lordship, for extension of time to survey the.
From the last 2 years, the respondents have not taken up the survey. Learned HC surveys that it would take some time. Respondents cannot keep the application pending eternally. Learned SCGP shall get specific instructions regarding what is the time that is required to complete the survey.
Your Lordship, earlier we have filed an affidavit before this honorable court, Your Lordship, seeking a 12 months time of extension.
The affidavit is not been filed yet, ma'am.
It is filed, Your Lordship, on.
Is it filed?
Sorry, Your Lordship, in another writ petition 1004111 of 25, the affidavit was filed, Your Lordship. Will conduct the joint survey and make submissions, because as the survey number which now petitioner is seeking for clarification, Your Lordship, that belongs to forest area. For that reason, we need a permission from the government, state of government of India, government of India, Your Lordship, to get the survey and get the permission from the government. To that extent, we have filed affidavit in earlier petition, Your Lordship. And now, as per my instructions, Your Lordship, we have taken the instructions that the present survey number, which is in between two districts, Your Lordship, Uttar Kannada and Belgavi. And with the permission of this honorable court, joint survey has been conducted. And the earlier number, Your Lordship, is renumbered as survey number 167, Your Lordship.
Whatever it is now, when is it going to be completed?
Your Lordship, as per my instructions, Your Lordship, it is difficult, and now he has to change the survey number and need a 4D in that survey number, record of rights, and he has to get correction first. Then we'll seek direction from the government of India also.
Matter, my
And,
lords, what has happened is.
I'll file my.
Then you file your objections.
Please,
You'll
Your
get you'll get an opportunity
In
to
this matter,
Your Lordship, I'll file
may I
my.
make a submission, my lords? In this matter, as the respondent say that there is no survey been done, an order was passed by this honorable court directing the respondent to carry out a survey within a period of 6 months. The same is not been done, and a contempt petition is pending with regards to the same. As of now, on one hand, the applications are not been considered.
objections on record in this case.
Please,
Because
Yes, ma'am.
without objections, any order is passed, your purpose will not be served.
Yes,
So
ma'am.
please wait for some time. Post this matter after 2 weeks, by the time the objections shall be on record.
Please, Your Lordship.
Or else the court will pass orders basing on the material on record. Yes,
Please.
next.
Bill number 34, Shivraj S. Balloli.
Hearing for the petitioner, my lords. Lords, on the previous occasion, your lordships had directed me to produce a translated copy of Annexure H. I may be permitted.
What is this?
Lords, a suit for partition and separate possession was filed by the decree holders before the executing court. Then that subsequently came to be dismissed. Then subsequently they filed a appeal before first appellate court, which came to be allowed. Defendants filed a second appeal before this honorable court, which came to be dismissed, and even they filed a review petition, which also came to be dismissed. Now a EP is filed before the executing court. Now, my lords, I was not made a party to the suit originally, which was filed by the plaintiffs, that is decree holders.
Who are you?
Sorry.
Who are you? We made a party.
I am the relative, because the decree holder. I am her brother's wife. I am also entitled to the share in the property. Now, subsequently, I have filed a suit, my lords, before trial court, which is pending adjudication.
What is the suit you filed?
Suit for partition and separate possession, my lords, which is pending adjudication, and also there is a stay granted in that case. Pursuant to that, I have filed a IA number 3 in this court, executing court, under Order 21, Rule 97 as an obstructor, which is pending adjudication. And pursuant to that, my lords, also the decree holders have filed an IA number 2, which is under challenge now in this writ petition, by way of which the possession warrant has been issued, and it is in process. Now, my submission is that, my lords, if once the possession goes to the decree holder,
You are in possession of the property.
please, I'm also in possession of the property without me making
What
a.
is the property now in question?
It is a house property, my lords.
Please come. Then counsel for the petitioner submits. The petitioner is a third party obstructor, and he has filed an application under 21 Rule 97. And he has also filed another suit seeking partition. in the suit where the decree is passed, he was not made a party. Now, the court has ordered for the possession was ordered. If the same is affected, it would cause lot of hardship and prejudice to the petitioner. Considering the same, they shall be stay of all further proceeding. Pursuant to so and so, so and so. The petition is permitted to take out hand summons and file a memo to that effect by 24th. What is calling by?
Recalling, my lords, this petition was initially dismissed for non-prosecution. I have complied with the office objections. Your lordships were pleased to direct.
The IA number so and so. 25 matter is also dismissed for default. The present petition is IA number so and so is filed to recall the order dated so and so.
There is one council submission, my lords, which is that IA number 2, which is under challenge. That I have not.
Let me complete this order. IA number 1 of 2026 is filed to recall the order dated so and so for the reasons stated in the accompanying affidavit. IA number 1 of 2026 is recalled and the writ petition is restored to file. The council's objection with regard to the office objection serial number 56 is upheld. Where is the stay petition? The same earlier order which I have continued. So considering the fact that he is a member of the joint family and already end the suit is pending with regard to the same properties, they shall be stay of all further proceedings. And he has to take out hand summons and file a memo by 24th. If the same is not filed, the stay granted by this court stands vacated. Is 35.
Lords, my only prayer is stay in regard to the execution of the possession warrant. That's all. Please, my lords.
Order.
Please, my lords. Highly obliged.
In this case, this honorable court ordered for my lords hand summons.
Is appearing?
He is appearing for one respondent. Lords, may I pass on this family tree, my lords?
No. R1, R2 and R4.
Yes.
You appear for?
R3, madam.
R3.
Then R1, R2, R4.
I have served them. So I filed acknowledgement also.
That memo. What is the name of the advocate?
It's a trial court advocates.
It is submitted that as per the order passed for this court. They served hand summons on the council appearing for the respondent. And for R1, R2, R4, who appears?
Yes, please.
On the council?
On the council's minutes, and the name also reflected in the memo minutes. ಇಲ್ಲ ಮೆಮೊದೊಳಗೆ ಹೆಸರು ಹಾಕೇನು ನೋಡಿ.
Served on the council?
ಎಲ್ಲರದು ಹೆಸರನೇ ಆಗದ ನೋಡ್ರಿ, ಮೆಮೊನೇ ಹೆಸರು ಅದಾವ್ರಿ.
Different councils are appearing.
Yes, ನೋಡಿ, different councils, different names.
R1, look at that, R1, R2, R4, council so and so are appearing. And he has served notice on them and a memo is filed. In spite of service of notice, on which date it is?
That's on
Date is, look at
very
date.
next day. Notes.
On so and so, no wakalat is filed on behalf of the respondents. And its notice to respondents 1, 2 and 4 is held sufficient. Yes.
Notes, may I pass on this, Junior?
Take that.
Notes, it is arising out of regular appeal. Notes, brief facts of the case are this. Notes, Chandrasekhar filed a suit for partition against all the defendants. Suit was dismissed. Notes, against that, regular appeal is filed. During pendency of the suit, Basava, who is on right hand side, she executed will in favor of my lords respondent number 4 to defend number 4 to 7. Defend number 4 to 7 in the year 1996. My lords.
Who is Basava?
Mother, my lords, mother.
Mother of whom?
Mother of all the plaintiffs and defendants. Mother of plaintiffs and defendants. She executed a will in the year 1996 in favor of defend number 4 to 7. That was produced before the trial court and that is marked. However, there is no finding because she was alive during pendency of
Oh,
the
I
suit.
remember this
That
case.
matter.
So,
Yes, ma'am.
during the pendency of the suit, there was no finding by the court with regard to the will.
Yes, ma'am.
Because will has to be proved by the party who is the
Even, my
life
lords,
upon
during pendency of the suit, Basava was alive.
alive, and that with regard to the will, what is her, what did she say?
There is no, my lords, plea with regard to will.
So
Nobody
now,
has.
Now that has to be decided whether there is a will executed by Basava bequeathing these properties in favor of so and so, so and so.
Yes, that.
No, without that, the court cannot say that by virtue of the will, you will become the legal heir of so and so.
Yes, my lords, precisely.
And the court has accepted you to contest the matter as a legal, you people were treated as legal heirs.
All
of
the
Basava.
people.
All the people.
All the people. Here, what has happened is, my lords,
Now you will be, now that bill has to be proved by you.
that finding is not called for. Court, my lords, I filed application to recall treating all these people as LRs.
That is done.
That is already done. I sought for recalling, and my lords, I filed application to treat me as legatee under the will in terms of that will. That application was opposed by this third respondent. He was earlier beneficiary under that will also.
That means a declaration by the court that by virtue of the will, you are the legal heir.
I am seeking to represent her estate on the basis of the will as contemplated order, order 22 rule 5. The court did not hold inquiry. Straight away.
Inquiry means now the will has to be proved.
Limited extent, my lords.
That's what, whatever is the extent it has.
Yes,
to
my
be
lords,
proved.
that order 22 rule 5 mandates that only.
Now, an issue could be framed, but an issue needs to be framed.
Not required.
No, not for treating you as an LR, but when you are claiming that she has executed a will only in favor of 4 and 7, the leftover are 3, 8 and the plaintiff. So now they will raise a dispute with regard to this will that has to be proved.
Exactly, my lords. Till then.
Such time you are there already on record. Why can't you wait for that? Why do you require a declaration?
And now matter is, my lords, it is at appellate stage now. Suit is dismissed. Now matter is at appellate stage.
Will is take first you have taken this at the time of appeal only.
Yes, my lords, she died and I taken up this contention. My lords, he claims that Basava has executed another will in his
You
favor.
have filed an IA saying that you are the legal heirs of so
Basava.
and so by virtue of the will dated 24/2024. What are the objections filed by the respondent?
He claims that there is that my will in my favor is cancelled and another will is executed in his favor.
Please give the paper.
My lords,
Let's see the order. Yes.
my lords, impugned order, my lords, annexure B, my lords, I request,
Yes.
page number 24. That is with regard to treating as LRs.
Yes.
Reason portion, my lords, starts page number 28.
Please read.
I have carefully perused the records of the record of rights of the parties not clearly decided by the trial court. For the reason present appellant preferred an appeal on the strength of will dated 30/6/1996. Notice the sentence formation is incorrect. The respond number 4, 6 and 7 claims the property. They are the beneficiary under the will dated 30/10/1996. Respond number 5 has specifically contended that respond.
When did this Basava died?
Basava died 12/4/2024.
12/4.
2024.
When was the suit decreed?
Suit was dismissed, my lords.
Dismissed when?
Suit was dismissed 11/12/19.
11/12.
2019.
Will dated?
Will is dated, my lords, 30/10/1996.
30/10.
1996.
So as on the day when the suit was pending, there was a will in your favor.
Yes, my lords.
And that was stated by you in the written statement.
Yes.
And what did Basava said? Basava also is a contesting party.
She is also contesting party, my lords. She, on the point of will, nobody has discussed.
Yes.
Nobody has discussed. And my lords, contesting respondent is also beneficiary under that will, my lords. He is also beneficiary under that will, my lords.
Yes.
Yes, my lords.
Speak further.
Yes, my lords.
Respondent.
The respond number 5 has specifically contended that respond number 2 cancel the earlier will dated 30/10/1990.
Respondent number 5 is defendant number.
Defendant number 5.
Defendant number 5.
Specifically contended that respond number 2 has cancelled the earlier will dated 30/10/1996 on 15/2/2020. Thereafter, respond number 2 executed will dated 5/3/2020 in favor of respond number 5 in respect of RS number 1238/2A/1 measuring 1 acre 19 guntas. Based on the will dated 5/3/2020, he was owner and possession of the property bearing 1238/2 bar A, 2A bar 1 to the extent of 1 acre 19 guntas. Considering the facts and circumstances of the
Now, at this stage, IA, the court has to conduct a mini inquiry on who is the
Representative.
who, as per the will, who are the legal who have inherited that property.
who has to represent the estate, not
Represent the
inherited.
estate. No, ultimately it is a kind of whatever
No,
it
no,
is,
my lords.
share of Basava.
He has to represent the estate of the Basawa till adjudication of the appeal.
What is the stage of the appeal now?
Final arguments.
What were you doing till now?
At that time only, my lords, it is, my lords, appeal, my lords, in regular appeal, there are only issuance of notice and arguments. There are no other stages here. So, my lords, after we came to know, we filed application, and the court, instead of calling for finding under order 22 rule 5, and my lords, that finding is only for limited purpose. That will not grant any title. Basically, after disposal of this appeal, either myself or himself, they have to file a separate suit for declaration stating that, my lords, Basawa is, despite this appellate court holding that either I am the my lords, legatee under the will or him.
Comprehensive suit for partition. All the issues have to be decided in the suit. Why would you file another suit for this limited purpose?
For limit, my lords,
Can't be.
no.
That has to be decided in this.
No, my lords.
How can it be? No, one suit saying that so and so is entitled for this share, and this share of Basava, whether Basava has executed a will in favor of A, B, C, D or not, you file a separate suit. Why can't that be decided in a comprehensive?
My lords, my lords, he has to seek for declaration that will is, my lords, genuine, which is executed.
Part of this suit only. It has to be decided by the court. All the rights of the parties.
It can't.
In that case, this is also not required. Now, Basava died. All the heads of Basava will be representative or are taken as the legal representatives of so and so. And if you say the will, that has to be decided by the court by using necessary evidence. When there is a dispute saying that will is not executed, it is cancelled, separate will is executed. Now the rights of the parties, now Basava share. What is
This is not Basawa share. The court holds that there is already partition. This is Basawa's independent property. Trial court holds, while dismissing the suit, my lords, trial court holds that this is Basawa's independent property. She is the only owner of the property.
So now, by virtue of this, you say that you are going to succeed to the property of Basava.
No, I'm not saying that I'm going to succeed the property in this.
Let the court say this whether who has succeeded to the properties of Basava by virtue of the will and all. Let it be decided in an independent suit. Even prima facie, why should the court decide it?
But to represent, my lords,
it is an independent. No, it is a partition suit. According to you, it is not a joint family property.
Yes.
It is not a joint family property.
Yes.
No, it has to be decided. No, that can't be decided in this suit.
Lords, I have to file a separate suit, my lords. He has to.
Then you file it.
Either, my lords, he has to file. I have to file, my lords. Similar situation to represent the estate, my lords. Order 20. Whenever there is a question arises, my lords, to as a legal heir of any deceased person, if there is any dispute, court has to hold limited inquiry under order 22 rule 5, and thereafter it has to proceed.
That is in a normal circumstance.
Regular, all the cases.
All of you are the sons of Basava, isn't it?
Yes.
All of you are sons of Basava. And you say that because my mother has executed a will in my favor, I will represent her. She has executed another will, and that factor, whatever is a property of Basava, is not the question that has to be decided in a suit for partition. Because that is not the joint family property at all, according to you. Property is not a joint family property according to you.
It is assertion of the plaintiff that it is joint family property. Assertion of the plaintiff. Once suit was dismissed on this count.
All these issues that has to be decided in the suit. Now we can't say now that by doing a summary inquiry, court cannot say who is representing. Now court has to necessarily know what to say, whether yours will is cancelled, somebody else will is there will be a finding on the will.
Yes, there will be a finding for limited purpose. Order 22 rule 5.
This is one limited purpose.
Yes,
there will be subsequent suit. Now when you say that it's a joint family property according to the plaintiff, is it not supposed to be decided in this suit?
That is certainly that will be decided, my lords. My lords, my question is, my grievance before this court is, lords, permit me to represent the estate of the Basawa during pendency of the appeal.
Why should it be done when there is another will?
That is what, my lords, we both are fighting for that.
Let the court decide it comprehensively.
That has not decided.
It has to be decided comprehensively, not on an IA. There
It
should
has
be,
to be
there should be, there should be an issue if now at the time of appellate stage, now you have brought this will into existence or you have placed it before the court.
Interestingly, my lords, interestingly, he has not filed any application to treat him as LRs as per the new will, that alleged new will. He has kept quiet.
That's because I'm already on record, my lord.
As LR.
Yes, my lord.
Everybody has been treated,
The purpose of
not
order
as a
22
LR.
rule 10
Not
is-
only person, my lords. All the persons have been treated as LRs.
That is rightly done by the court.
That was filed by, that was on the basis of,
Without that bill being on record, without any issue in that regard, without deciding anything. Now, when in the light of the inter se disputes between the parties, now why should the court say that you are representing the estate?
it has to, it is,
That property, where will it go now? What will happen to that issue?
that is, my lords, tomorrow, my lords, this regular, one moment.
Yes.
If tomorrow this appeal is dismissed, his plaintiff's appeal is dismissed, then, my lords, I had either myself or he has to file a suit for declaration that
Suit is allowed. This appeal is allowed.
if that appeal is allowed,
In that, while allowing the appeal, all these issues have to be decided. There can't be no reason for.
but till then, my lords, till then,
All of you are there as legal representatives. You will represent her.
till then, my lords, it has to be decided, my lords.
Now it is giving you an edge, and the court, without the issue with regard to who has succeeded to the share, whether the issue has to be decided whether. that
Now what has
property-
happened is one more.
Family property.
Now
or
one
not.
more thing. What has happened is now, my lords, he is putting up construction without taking any building permission.
That you question.
That I have filed another MFA. That was not listed.
The court decide. As far as that is
That application
concerned,
is also dismissed.
if he is permitted to do it, the court will decide.
Appellate court has dismissed my application. That application also.
First, let me decide this application, then we'll go to that. Please come. The agreed with the,
But I am relying upon one judgment.
please pass on. Agreed with the order passed in IA number. IA number 2 in RA number 10066 of 2024 dated 19 January 2026. Your defendant number?
I am defendant number, my lords, 4, 6 and 7.
The defendant number?
4, 6, 7.
The defendant number 4, 6 and 7 is before this court. Who is the plaintiff? Respondent number in this case?
Respondent number 1.
Respondent number 1 has filed a suit for partition. In that, the brothers, in that the siblings and the mother was arraigned.
Father, mother,
Father,
and
mother were arraigned as defendants. The suit filed by the plaintiff is dismissed. Against that, an appeal is filed. During the pendency of the appeal, the mother died. The petitioner, according to the petitioner, the mother has executed a will. The mother has executed a will on 30/10/1996, bequeathing the properties to the petitioner defendants.
petitioner and, my lords, defendant number 5 also.
Petitioner and also defendant number 5. Then she died on 30, what is the date?
12/4/2024.
12/4/2024, she died. Then an IA is filed to treat all these defendants as LRs of the deceased.
Memos.
Accordingly, that application was allowed.
Memo was filed.
Memo was filed and the same was allowed. Thereafter, the petitioners herein have filed an IA seeking to the present IA seeking to recall that order. That IA is filed under order
151
CPC.
for recalling.
Recalling the order and to treat these petitioners as LRs who is representing the estate of the deceased Basava.
IA number 3 was filed separately, my lords, to
IA
treat.
number 3 is filed. IA number 10, IA number 2 is filed, 2 and 10.
2 and 3.
2 and 3. 2 is filed to recall the earlier order, and 3 is filed to permit to consider petitioner as a legal representatives to represent the estate of deceased Pasamma. That application came to be dismissed by the court. While dismissing the application, the court has observed that
Court has observed nothing, my lords.
that according to defendant number 5, the deceased cancelled the earlier will dated 30/10/1996 on 15/2/2020. Thereafter, the respondent number 2 executed the will dated the deceased has executed a will dated 5/3/2020 in favor of defendant number 5 in respect of RS number 1238 of 28/2A/1 measuring 1 acre 19 guntas based on the will dated 5/3/2020. And according to him, he is a owner and in possession of the property bearing RS number 1238 of 2A/1 to the extent of 1 acre 19 guntas. Considering all these facts, the court has felt that such an IA cannot be maintainable, and accordingly, court has refused to recall the order dated passed in IA number 2 and dismiss the IA number 3 that is filed by the petitioner. Land counsel appearing for the petitioner submits that the mother has executed a will in respect of defendant number 4 to 7.
4 to 7.
4, 5, 6, and 7. The petitioners are before this court are defendant number 4, 6, and 7. According to defendant number 5, that will dated 30/10/1996 is cancelled, and a separate will, another will is executed in the year 2020, and he has been in possession of the property. This is a comprehensive suit. It is submitted that unless the petitioner is the court has contemplated under order 22 rule 5 has to do a limited inquiry with regard to this, and without any inquiry the court ought not to have dismissed the application. It is his contention that as far as the will is concerned, who by virtue of the will, who is the owner of the who has succeeded to the property has to be decided by filing separate suits by defendant number 4, 6, 4, defendant number 4, 7, 7, defendant number 4, 6, 7, and defendant number 5, which will not be decided in this suit. In this suit, for the limited purpose, who will decide, who will represent the estate of defendant number 5, the deceased defendant
Number 2.
will be decided in this suit. He has relied on a judgment of the apex court in case of Swami Vedavyasanandaji Maharaj versus Shyamlal Chauhan and others, reported in 2024 SCC online SC 683. Which paragraph?
Para 10, my lords.
Para 10.
10. The only purpose of substitution is the continuation of the
Like
case.
that. Read it.
Only purpose of substitution is the continuation of the case. The substitution as LRs in the case by itself will not give any title in favor of the person so substituted. It only confers
He
the
relied on the said judgment. So, in the light of the same, according to the petitioner, for the limited purpose of the same, the court has to consider the said application. Next paragraph. Land counsel appearing for the defendant number 5 submits that the court has rightly considered the memo and taken all the defendants as LRs of the deceased. Now, in view of the dispute that is raised by the parties with regard to the will dated 96 and the subsequent will dated 2020, that cannot be decided in a summary proceedings under order 22 rule 5. It is submitted that the court had rightly considered this aspect and rightly dismiss the petition. Next paragraph. Having got the land counsels on either side, there is a material non-record. In this case, the father, mother, and the children are the parties to the suit. One of the brother has filed the suit for partition. His suit came to be dismissed. According to the three of the brothers, the mother has executed a will in their favor and also in favor of another brother, that is defendant number 5. According to defendant number 5, that will is cancelled and another will is executed in the year 2020. Now the suit is for partition. According to the plaintiff, the property which the defendant number 2 has executed a will in favor of the petitioners herein and the defendant number 5 is a joint family property. According to the defendant number 2, according to the other defendants, it is a self-acquired property of the mother and she has executed the will. Now, in the process, the court has to decide whether the property is a self-acquired property of the defendant number 2 or whether it is a joint family property. Necessarily, when the plaintiff and the defendant both are denying the plaintiff is denying the same, that it is a self-acquired property, and the defendant is denying the same, that there is a will. Now, the purpose of an inquiry under Order 22 Rule 5 is to bring the LRs on record. Now, all the LRs of the defendant are already on record. Now, the issue is whether who is going to represent the estate of the deceased. For that purpose, what has to be decided is whether whether the property is a self-acquired property or a joint family property. Whether the order that is passed by the trial court is the judgment where the suit is dismissed, is it valid or not? As it is denied by the defendant, it has to be proved by the plaintiff petitioners herein that a will is executed by the mother and he is succeeding to the estate of the second defendant, or the will that is executed in favor of defendant number 5 and by virtue of the same he will succeed to that. The contention of the petitioner that a separate suit needs to be filed, and so this court is not able to appreciate the said submission. In a comprehensive suit for partition, whether it is the plaintiff or the defendant, the rights of the parties have to be decided by the court. In that view of the matter, this court do not find any merit in the submission of the land counsel for the petitioner and the order that is passed by the court, and also do not find any reasons to interfere with the order, accordingly dismissed.
Lords, in that event, my lords, in the appellate stage, we both have to lead the evidence, my lords.
Why not? Why it's a continuation of the suit?
Yes, my lords, that
No, that you have to seek. You have to seek for the additional issues to be framed, additional evidence to be adduced under Order 41, Rule 27. And all these issues have to be decided by the court because this issue is cropping up for the first time. So if you say it is a self-acquired property, and according to the plaintiff, it is a joint family, it has to be decided by the appellate court. Without deciding it, the court cannot, because appeal is a continuation of the suit.
for that purpose, my lords, but insofar as Basava's share is concerned, insofar as Basava's share property is concerned,
So far?
Basava's share is concerned,
No, that if Basava's share is a joint family property, she has no right to execute a bill in favor of both of you.
but for her share, it can be always, my
That
lords,
has to be decided, and because it is between the family, that issue also has to be decided by the court in this suit.
that has to be.
That I can't say. You have to come up with an appropriate application before the trial court. But if it is not considered, then you will come before the court.
Court officer? Court officer? Court officer? Court officer? Appear, my lord, for the petitioner in the other connected matter. In both these petitions, my lord, the petitioners.
In 20, for a 24 matter now.
So I'll only briefly, my lord, state what it is regarding.
No. Objections were filed by you?
My lord, written arguments. My lord, this matter, my lord, has already been decided by the Honorable Division Bench. The same issue has already been decided, my lord. But, my lord, the colleges have preferred an appeal before the apex court and it has been stayed. The very same issue, my lord. In this case, my lord, the students have been admitted by way of direct method, my lord. They did not participate in a counseling. That is why, my lord, the Honorable Division Bench of our High Court, Bangalore, my lord, has dismissed their petition and imposed a cost of 75 lakhs. But the same issue, my lord, the same petitions are pending before this court. Now, my lord, they are saying that
When are those matters coming?
My lord,
When are those petitions coming?
before the apex court, my lord.
Oh, I have heard one matter.
My lord, probably on, my lord, they are different, my lord.
No, I know that.
Please.
They coming.
My lord, on 11th, probably.
List this also on 11th.
Meanwhile,
Allah, there is a, my lord, now exam final year. They have already, my lord, undergone the, my lord, course. They are in the final semester of the exam. This thing.
kindly, your lordship may.
Pass order on the 11th.
In that matter, my lord has already granted an interim order to take the examination. At least same interim order, my lord, whatever the my lord's our passes order.
No, what is it? A time limit for this?
16th is the last date, my lord,
Matter is coming on 11th.
with the fine, my lord, now.
It is 16th. I'll pass orders on 11th. That day I'll hear and pass. Yes, list on 11th.
Allah, so
In the my matter, the 18th is the examination.
That's what, when is the last date? Last date is on 16th, you're saying.
16th, my lord, for submission of the.
Correct. This matter will come up on 11th. That day I will pass order, whatever order you are entitled to.
In the meantime, my lord, what I would submit in this matter is the order, my lord, that he is referring to is not applicable so far as the.
I will see on that day because the other connected matters also I'm hearing. That day I'll hear and pass final orders. Yes, you be ready for the final order on that day. Yes, 39.
39, my lord, I am appearing for the petitioner. Lord, in fact, suit is for declaration and injunction. This is the writ petition by the dependents. But on the trial court, my lord, refused to grant an order of injunction, against which, my lord, they have filed an appeal.
Appeal it is granted.
Appeal, it was granted.
Please come to the order.
And in fact, my lord, your lordship may kindly see the, before that, my lord, order dated 28/10/2024 may kindly be seen, passed by this honorable court, wherein, my lord, there is a direction that both the parties directed to maintain status quo with respect to the alienation and possession of the property. So, my lord, what my respectful submission is that order may be kindly be continued,
What do you say?
so that, my lord, the
Lord,
direction may kindly be issued to the
There's a final order.
Yes, no. I have some objections. my lord.
status quo, my lord, innocuous order. No, my lord, harm will be caused
I'll
to
just
any.
make a few submissions, my lord, regarding the merits of the matter. I have filed statement of.
Put for?
Suit is for declaration.
Declaration, what is the order? What is the IA that they filed?
IA filed by, my lord, for the injunction, but refused by the trial court.
That's what injunction he sought?
Injunction, my lord, not to interfere in his possession. Now, my lord, the status quo is granted. My lord, how, my lord, he is not in possession of the property?
When was this suit?
Suit is of the year, my lord, the 2023, 4/3/2023.
So right from 2023 till now, you don't have injunction.
No injunction.
No, my lord, I had the benefit of the interim order by the.
May order is when?
MA order is, my lord, it is a recent order. It
My lord, it is on-
challenged here. My lord, I'll just make few
My lord, it
submissions.
is on, my lord, on 9/9/2024.
9/9?
2024.
Yes.
Immediately it was challenged on 28/10/2024. My lord, this honorable
Lord, I
court
have
passed
filed
the order.
statement of objections. Your lordship may kindly take up page 19 of my statement of objections. Now, my lord, the land, my lord, they have purchased the property under a different sale deed. Original owner was one Deshpande. It is entire land is about 397 acres land. I have produced the entire map. Your lordship may kindly peruse for a moment. It brings clarity to the matter. In the year 2022, my lord, I have purchased the property under a registered sale deed.
Thereafter, my lord, a joint survey was done and my property is subdivided and it's a separate RTC is created, separate map is also created. Now they have also purchased the property different portion. My portion is southern portion. There is a northern portion. The properties of petitioner, the plaintiff and defendant are not adjoining. They are totally different properties. Despite that, my lord, they are trying to interfere and encroach over my property. Therefore, I have filed a declaration of title and injunction. In that, my lord, 39(1) and 2 application was filed, seeking restraint from interfering with the possession of my possession by the defendants. That application came to be rejected. But the first appellate court, my lord, in the appeal, my lord, the entire documents registered sealed, the boundaries were perused, and then the court came to the conclusion.
You are the owner of the property, he is also a
Yes.
owner of the
Okay.
extent.
Yes.
So there is a
Well,
registered
once
The only dispute is.
Where
the
exactly,
Encroachment of your property by him.
well,
where
encroachment
exactly, my lord, the property is
it's not-
situated? My lord, that is only the
not
objection.
with respect to encroachment, my lord. If they are for a moment, may I take yours? Page 19 of the statement.
Instead of that, please read the order.
Yes, yes. Allah, for one moment, my lord, page 19 alli, larger extent is disclosed. That is the reason.
My lord,
The entire
but,
land is
my lord,
397
before
acres.
going into that merit,
Both of you argue, I can't help you.
Yes.
before going to the merits, my lord, what I am respectful submission is that what happened, my lord, he claims to, my lord, based on, my lord, the survey sketch which has been prepared behind our back. No notice was served.
Lord,
On
with-
that basis, my
with
lord, he is
respect-
trying to, my lord, put up the claim over the property which is in possession of these dependents.
Totally different properties, my lord. With respect to status quo, my lord, my objection is they are misusing the order of status quo, and it's an agricultural land, my lord. The status quo is being misinterpreted in the over the field, and they are trying to, my lord, cause difficulty in enjoying the property. That is the difficulty, my lord. Both of us have purchased a totally different.
To the impugned order.
Yes,
What is the reason for the court to grant order?
yes, yes. The reason is, my lord, the property which is purchased.
Paragraph.
Yes.
No,
Prop-
till paragraph number 15, it has discussed about that title deed, this title deed.
Yes.
15.01, please read.
Lord, reasoning starts from page 6, para 16. Para 16 onwards. May I read, Malad? Para 16 onwards. Essentially, my lord, the reason why the interim order is granted by the appellate court is that the property which is purchased by the plaintiff and property which is purchased by the defendant are totally separate properties. They are not adjoining. The defendant's property is in the northern portion. The plaintiff's portion is the southern portion. They are not adjoining. They are not connected at all. And as per the sale deed also, there is different boundaries.
It's not so. My lord, he, my lord, makes a claim based on, my lord, the recent, my lord, the survey which has been made. On that basis, my lord, he is making a
Will you
claim.
submit on that?
Yes.
As per the sale deed.
Yes.
The sale deed.
As per the sale
your
deed.
Your property and.
My lord, his property is some other place. His property is some other place. And now, my lord,
Not adjoining properties.
it's not the adjoining property, it's some other place.
There is a
But what he is saying that this now, my lord, by virtue of producing a sketch, he is saying that, my lord, this is the property which he has purchased. It is not so. But if that is the case, my lord, if, by respective sale deed, if it is looked into, my lord, nowhere, my lord, his property is.
That's fine, that's fine.
So, my lord, what my respectful submission is that this very fact that, my lord, he is, my lord, objecting for the, my lord, the status quo order, that itself shows that, my lord, he is not in possession of the property of the present. And he wants to, my lord, take undue advantage of the injunction order and to oust these persons.
That is not correct, my lord. It's incorrect statement.
Oh, please answer to my
Yes,
query. Your
yes,
argument is over.
yes, my lord.
The query of the court is.
Yes.
Two properties or different properties.
Yes.
Now the injunction will be granted in respect of this property.
No, yes, my lord, what?
Oh, you cannot have any objection.
No, no.
When it is
My
not an
lord,
adjacent
no.
property.
Injunction has been granted in respect of the property which is in possession of the property, possession of, my lord, these petitioners.
It will be granted as per the sale deed.
Yes.
No, my lord, it is, that's why,
Let us see,
my lord, that's
let us
why,
see,
my lord,
let-
his vendor's
Come.
sale deed, my lord, that's why, my lord,
To
that's
the
why, my lord.
order, where
That
is
is,
that?
that has been considered by the trial court,
Let us see,
my lord, in fact,
the order at page 44.
yes. 44, my lord.
Resultantly, the application filed by the plaintiff is allowed and the defendants are
Yes.
restrained so and so, interfering with the peaceful position of the prey or the suit schedule property. What is the
Suit schedule property, my lord, he's shown, my lord, the property which is, my lord, in possession of these dependents. That is all difficulties. That's, my lord, how, my lord, by virtue of this, my lord, the injunction order, he want to dispossess. That's what, my lord. That's why, my lord, the trial court, my lord, has considered elaborately.
Present to the court, if you answer my queries, I'll be able to understand.
Yes.
If I don't understand, you will not get any order.
No, my lord,
That's it. My understanding is more important than your argument.
yes,
What I want to know is,
yes,
now, the suit schedule property which is shown,
yes.
is it the same property in the sale deed or not?
No, my lord,
Simple question. Only simple answer I want.
yes, my lord, in fact, it is not so. My lord, in
Let's see,
fact,
come to the
my
plaintiff.
sale deed, my lord,
Come to the plaintiff.
my lord, my lord, with the reference to sketch also, my lord, I can, my lord.
Let us forget
my lord,
about the sketch.
Yes.
Please refer to the sale deed.
Right.
Where is the sale, where is that,
My lord,
uh,
my lord, my sale deed as well as other sale. My lord, I will produce my sale deed also then, my lord, if that is. I will produce my sale deed. My lord, it is contradicts, that's each other. My sale deed is of 1992. He purchased.
understand now is by this way or the other way, you want this as status quo order
No,
to
no,
be
my lord, on
letting the
merits
court-
also, my lord, I will, my lord, so far as, if it is on merits, my lord, I want to, my lord, produce those documents, what he says that.
This matter on Tuesday, no further adjournment.
Yes. My lord, in fact, he is trying to, my lord, dispose us from the land in question.
Right. Yes, 40.
Still number 40,
Obliged.
AP Hegde.
This case, I want 10 days time to file objections.
That interim order may kindly be extended in that, my lord, earlier matter.
There is no interim order on the last occasion. In this matter, yes.
No, earlier.
Interim order earlier granted is extended in the earlier matter.
Still number 40, I pray 10 days time to file objections.
Last occasion, government advocate was directed to take instructions.
The government leader shall get specific instructions, objections, objections by the next date of hearing. This is matter on 25th of February. Is 41?
Still number 41,
Yes, my lord.
Yes.
Yes, my lord. This is the writ petition for seeking mandamus, my lord. The officer raised objection to made a particular party. We have filed application, impleading application. If that is allowed, my lord, I amend petition and
Whom you want to implead?
in the Tahsildar against whom wanted action from the Assistant
In
Commissioner.
number 1 of 2025 is filed to implead R4 against whom a direction is sought by the petitioner. Accordingly, I number 1 of 25 is ordered and the petitioner shall carry out the necessary amendment. This after 2 weeks. Is 42?
still number 42, Preeti Shashank.
Insurance company appeal, my lords. There is 5 days delay, my lords. Delay may be condoned post for admission.
Notice is served.
Please, my lord.
I number 1 of 25 is filed to condone the delay of 5 days, condone, admit final hearing PCR. Yes, next.
Still number 43, Sharath P. Anam Reddy, GS Sadiq Tanvi.
Petitioner, my lords, is the plaintiff, my lords. Plaintiff number 18, my lords. The petitioner, my lords, has filed an IA, my lords, seeking for amendment of the plaint, my lords. Now, my lords, the plaintiffs and also the defendants, my lords. Both plaintiffs and defendants, my lords, if I may. Both plaintiffs and defendants, my lords, they are claiming that they are legal heirs of one Nawaz. Suit for declaration and injunction, my lords. Declaration that, my lords, my prayer, page number 65, my lords, where I seek to declare that plaintiffs are also legal heir of the deceased Nawaz Khatu, who is a predecessor of one Nawab of Savnur, my lords. My lords, then that, my lords, the declaration that judgment and decree obtained by defendant number 1 in the OS 171 of 1984, dated 30/10/1994, is by misrepresentation and fraud. This is what is the matter, my lords. In the prayer, my lords, my second prayer is that
she has, I was not made a party, either in the OS or in the RA or in the RSA. She had claimed earlier also that she is the only legal heir. She filed a OS without making us a party, and then she got a decree in her favor. Then she colluded with one Kumbharwada Masjid, and then she has alienated certain properties, Manoj. When she was alienating the properties which were adjacent to our property in the year 2010, then is when we came to know that by misrepresentation and fraud, she is trying to do all this, Manoj. And on the same ground, Manoj, in the plaintiff and the plaint also, Manoj, in page number 64, para 9, Manoj, I've already claimed, Manoj, that by misrepresentation as in fraud, she has been alienating the properties, and she has claimed a judgment 171 of 1984, Manoj. And on the same, the issue has also been framed, Manoj, whether we have to prove that she has gotten the judgment in the OS through misrepresentation and fraud, Manoj. When that being the case, when there is an issue also being framed, and when there is a prayer also that she has got the judgment in the OS through misrepresentation and fraud, Manoj, we had cross-examined her, Manoj. That is her power of attorney, who is her husband. We had cross-examined her husband in from 9th month of 2024 till 2nd month of 2025. And in the cross-examination, Manoj, she has elicited how the misrepresentation has happened. And we, through this IA, Manoj, we have already pleaded that there is misrepresentation. We just wanted to bring in the facts as to how the misrepresentation has happened. That is the crux of the matter, Manoj.
So, no, you will, whatever the latches, lacuna, you will fill up by this amendment.
No, my lords. There is no latches or lacuna.
If it is not required, why should you do it?
My lords, it is required because, my lords,
After the cross-examination and whatever the clue you get from the cross-examination, that won't be the basis for filing a written statement.
No, my lords.
For the additional pleadings.
My lords, pardon.
Please come to the order. Now I understood what is your submission. Come to the order.
My lords, order, my lords, page number 44, my lords. From page number 43 is my stand, my lords, that only in the cross-examination we have come to know how the misrepresentation has happened. And in page number 40, from page number 49, my lords, is the order. Yes, my lords. Para number 19, my lords, where he explains what is amendment of pleadings, my lords. That is first, my lords, in page number 48.
Yes.
Then, my lords, in para number 20, my lords, the proviso orders Order 6 Rule 17 CPC mandates that no application for amendment shall be allowed after commencement of trial.
Para 21.
My lords?
Para 21.
Yes, my lords. In the present case, the suit was filed in the year 2010. The trial commenced more than 2 years ago, and the matter is presently posted for final arguments. In the affidavit, the plaintiffs have not explained why they have waited for 15 years to file the amendment application. The plaintiffs were already aware of the earlier court proceedings. This is a wrong finding, my lords. We were not earlier aware before the cross-examination about the criminal miss and also that P&AC that Kumbharwada Masjid had got in their favor. Then, my lords, in para number 22, he says the affidavit accompanying the application.
You read further.
Yes,
the
my lords.
plaintiffs were already aware. After that, in fact, they had even filed.
Yes, my lords. The plaintiffs have not explained why they waited for 15 years to file the amendment application. The plaintiffs were already aware of the earlier court proceedings such as miscellaneous petition number 369 of 1981 and RA number 73 of 1994 before the application. In fact, they had even filed miscellaneous petition 43 of 2018 related to the same subject matter. Yet they did not take any steps to.
Pausing here. How can you say you are not aware?
Well, this was not filed by me. That is a wrong finding. In the cross.
Miscellaneous petition 43 of 2018.
Miscellaneous petition 43 of 2018, I was not made a party. It's not filed by me, Manoj. It is actually filed by the Kumbharwada Masjid. There is one P&AC 8 of 1979, Manoj, where they get the order stating that the certain scheduled property belongs to the Masjid, Manoj.
Yes, yes.
And based on the same, Manoj, she files miscellaneous petition, Manoj. And in the miscellaneous petition, there is a expert opinion report, Manoj, which comes out. And based on the expert, after the expert opinion report says that it belongs to Nawaz Khatu, the signature doesn't belong to Nawaz Khatu, they followed with each other, they compromise. The lady doesn't appear in the miscellaneous case, and then in the RA, they compromise, Manoj. This miscellaneous 18 of 90, this finding itself that I was a party is wrong, my lords. That is there in the cross examination.
Is no, this miscellaneous petition number 369 of 1981.
Yes, ma'am.
RA number 73 of 1994. Is the petitioner aware of these proceedings?
Absolutely, my lords. I have produced the
Say,
lords. I have produced the objection, statement of objection, wherein the annexure A3, annexure 3 is the miscellaneous 43 of 2018, my lords,
let us,
and wherein the petition number 16
is
is
that page number?
page number 56. My objection, my lords. Statement of objection, my lords, page number 56.
That one. Hmm.
The petitioner herein is the petition number 16 in that proceedings, my lords.
What is the name of the petitioner?
Majid Khan Ahmed Khan Biradar, 53 years, agriculture, Saunur Taluk. Not only him, my lords, all the plaintiffs in OS number 118 of 2010.
Majid Khan, son of Ahmed Khan Biradar.
Yes, my lords.
Where is he?
Page number 58, petition number 16.
Yes, Majid Khan, son of Ahmed Khan Biradar.
Lords, why it was filed? It was filed questioning the.
My lords, this miscellaneous 43 of 2018, my lords, was not filed questioning the.
We are on the point, miscellaneous number 43 of 2018, you are a party or not? Just now you said you are not a party. That is a wrong observation made by the court, which is incorrect on the face of it. Because you are a party, you are arrayed as petitioner number 16.
My lords, I am Majid Khan, my lords, not Majid Khan. And there are too many people with the same name in the same petition. also.
Son of Ahmed Khan Biradar. That also 3 people are there.
My lords, if I may be permitted to submit. This miscellaneous 43 of 2018, my lords, this has been filed.
I think you have to prepare your defense now. Shall I adjourn it?
It may be
This
taken
is
up.
matter on Tuesday. Prepare
Yes,
well
ma'am.
and
My lords, may I make a submission, lords? Here in this case, my lords, interim order is passed not to dispose of the matter without leave of the court. Judgment, not to pass the judgment without leave of the court. My lords, their side argument is taken as heard in the 2015-year-old matter, my lords, and the matter is posted for my argument. At that time, they brought with the order of this honorable court that not to pass the judgment. And
have it on Monday.
my lords,
We'll have it on Tuesday, my lords.
Tuesday.
Yes,
please.
Until then, interim order may be extended, my lords.
Interim order earlier granted is extended. Yes, next.
Please.
Seal number 44.
Please.
Lord, before going into the merit of the petition is concerned, the present petition is filed challenging the work order which has been issued in favor of the respondent number 6 herein, wherein a tender process was called for supply of food materials to the pre-matric boys hostel. After that, my lord, the present petitioner and the respondent number 6 applied. I have been declared as L2 and he has been declared as L1 in the proceedings that was taken on 29/10/2025. That order is questioned by the petitioner before the appellate authority by filing an appeal. Since interim order was not granted before the appellate authority, the present writ petition was filed and interim order is granted, not that staying the work order. On the last occasion, the government has submitted a statement of objection along with the vacating stay, stating that since the appeal is pending before the appellate authority, it can adjudicate the right before the appellate authority. And to that effect, the petitioner herein has filed a rejoinder stating that suppression of fact during an antedated work order having been issued in favor of the respondent number 6. That on that basis only the honorable court entertained my writ petition and interim order is granted. So my respectful submission to the lordship is that let the appellate authority shall decide the appeal after hearing both the parties and it can adjudicate on merits of the case is concerned. It is my respect. If they want to decide the petition on merit, then I am on, it has to be.
Work order is issued on 29/11/2025, wherein that is in challenge. On the ground that earlier the government has stayed certain this tender process on 2/12. That communication, government has made a communication that prior to such order, the already work order has been issued. Insofar as the December is concerned, my lord, the supply of food is completed. After the interim order, my lord, there is no supply of food. And I already executed, my lord, the bank surety of 50 lakhs and also entered into an agreement with the government. In such a situation, my lord, non-supply, my lord, it is going to happen. However, my lord, the appeal is pending, that challenging that the declaration of me as a L1, that on the basis of certain financial, if my lord, when that is in pending, my lord, he cannot challenge the work order, my lord, that it has to be challenged before the appellate authority, my lord. Let the appellate authority has decided, my lord, that application, and now this writ petition is not mental in view of mandatory provision of appeal under section 16 of public transport.
And yes, will direct the appellate authority to decide.
My lord, one more submission.
My lords, my lords, the 1 month's, my lords, the groceries are supplied by the, my lords, the success. 1 month grocery to the, my lords, the students of the matriculation and pre-matriculation hostels has been supplied. Because of the interim order, now they are not supplying, my lords. My lords, this interim order should not come in the way of, my lords, non-supplying, because of my student will be put under starvation. That they will continue to supply subject to final decision of the appeal.
Lord, one submission to that effect. If they want to get an order from this court that respondent number 6 may be permitted.
First of all, you are not entitled for any order from this court. By virtue of this order,
Please.
the entire activities are, why should it be stopped?
Lord,
You are not supplying.
I am supplying.
When are you
No, no,
my
they
lord,
are not supplying. They are not supplying, my lords. Even he is not qualified as a bidder. He is L2 bidder, my lords. My lords, respondent 6 is successfully, my lords.
That order passed.
Lord, annexure A is the impugned order, work order which has been issued at page number 12. It was passed on 29/11/2025.
My lords, before that, the work order has been issued and the, my lords, respondent number 6 has started to supply the, my lords, the commodities to the, my lords, hostels. And 3,000 students.
Tender matters, as if it is a statutory appeal. Appellate authority has not granted, why will in a tender matter, they will grant a stay?
My lord, to that effect only, I made a submission on the last occasion. We filed a rejoinder stating that before closure of the technical bid and financial bid, a work order which has been issued to the respondent number 6, which is not permissible under the law. That is the contention. To the rejoinder, they have accepted my whatever the contention and the documents produced before this honorable court. They have not placed any records. My lord, my financial bid itself is rejected on 23/12/2025.
No, somebody, you or somebody else.
Yes, ma'am.
Have to.
My lord, one more sub.
There should be a supply.
Yes, ma'am.
If not, that's why.
Please.
Let him supply. Let him supply. Let the appellate authority decide about the procedure and other entitlement of both the parties and pass an order. Whatever supplies he is going to make is subject to the result of the
appeal.
final
Yes.
outcome of the.
Appeal.
Yes, ma'am. I agree to the lordship. My lord, I agree to the lordship's submissions. But my one more respectful submission to the lordship is that if that would be the case, they would have not me permitted to supply for the month of December and January. If that would be the case of the respondent Sarin, if they are supplying, they would have not issued me indent and I have supplied. I have produced the document to that effect.
All these grounds can
I have,
be urged in
Allah, to that effect, I have placed this in the rejoinder.
Before the financial bid and technical bid has been completed, work order has been issued. That contention he can, my lords.
Why was he granted the work order?
No, no, he is not.
He is not granted. He is not a
Lord, I have
successful
produced the
bidder.
document to show that pursuant to the indent order, I have supplied the materials. I have produced in the month of January.
No, my lords.
Along with the rejoinder, I have produced the documents.
On what basis it is done?
Lord, I have been continued. In view of this, my lord, one more
No, my
submission.
lords.
One more submission. In view of the state have taken a decision insofar as this notification, no steps have to be taken as per annexure F, which was issued on 12/12/25. The work order which was antedated, that is on 29/11/2025. That was the contention taken before that.
Oh, if it is one party.
When the
who
state has
participates-
taken a decision.
A party who participates in the tender process once.
Yes.
Forever, they should only continue with the tenders.
Yes, ma'am.
They should only be supplying the goods, nobody else.
Yes.
If it is, they will come to the court, they will obtain the orders and it will continue forever. That's what appears to be the.
My lord, to that effect, my lord, my respectful submission to the lordship is that let the lordship shall direct the appellate authority to decide within a period of 1 month. Till then, my lord, since indent having been issued and innovates, I have paid and have supplied the materials, within 30 days, let the appellate authority decide. If they are eligible, they can.
Why did you grant intent to the?
No,
My lords,
indent is given.
That is for him to say.
Please.
Yes.
My lords, the work order issued to the, my lords, respondent number 6, he only supplied the material and bill also he has raised. And he did not supply any after the, my lords, this tender has been completed.
Then counsel for the petition submits, sir,
Please.
for the month of December and January.
Yes.
He has supplied the material.
Please.
The same is denied with the learned AGA. And the council appearing for the, which respondent?
Respondent number 6, my lord.
6, ma'am.
6.
Or
Six submits that you have supplied.
Yes, ma'am. After interim order, I
After the order, he has supplied. The petitioner shall place the AGA shall place the relevant record pertaining to the supply of material for the month of
December and January.
January.
Please.
If any false submission is made before this court by any of the parties, this court will impose exemplary costs.
Please.
And I'm not going back on this.
Please.
I will do it. And if a wrong submission is made on behalf of the government, appropriate the orders will be passed, even considering that.
Please.
Why the government has not filed the objection till now?
Objection has
vacating
been filed.
Hakidar, they have
Objection
filed.
have filed.
Where is that?
Please.
What did they say? What did you say about this
Please.
supply?
My lord, they have not filed to that rejoinder, they have not filed any objection. They have accepted my rejoinder. With regarding to supply and a rejection of my tender is concerned.
On and off, once somewhere will
Yes, for that purpose only, my lord, I am making submission to the lordship.
The line of
Let the-
petitions I am seeing in this Dharwad benches,
Please.
every tender that is floated is before the court. In every case, there is an order.
Yes.
Then then either it is to, either we have to say that the government is not at all following the procedure and doing it. Otherwise, why the interim orders are granted in every tender matter?
My lords,
Lord, for that respectful submission is that, my lord.
Let him complete. The
Please,
difficulty is
my
when
lords,
the
my
council
lords,
is
the interim
submitting
order was-
and I'm posing a question to him, if the other council argues.
Sorry, my lord. Sir.
My lords, the interim order was granted in this case based on saying that it is antedated signature, antedated my lords order have been passed. In fact, after completion of the my lords tender process itself, my lords, the work order has been issued to the
Please
successful.
get instructions in this.
Please,
I will
please.
pass orders.
Please.
This is matter on 18th of February.
Lord, the interim order shall be granted.
Interim order all granted is extended till then.
Please.
Seal number 45, Malikan Swami P. Hiremat, Vishwanath Hegde.
Kindly
In this
tomorrow,
case,
you should
writ
withdraw
appeal
this
is
petition.
dismissed, my lord, Anashri, that is dismissed today. This writ petition will not survive for
What
consideration.
is that?
Writ appeal, why Anashri came to be dismissed today by the division bench of this honorable court.
Kindly tomorrow, I'll withdraw it.
No, tomorrow. Why should we grant it tomorrow? Which is dismissed?
Anashri, my lords, writ appeal number, page 87, 100-750 of 2025.
I'll
Very
ascertain
late.
your lordship.
Counting of results of the other 16th respondent, that being writ appeal came to
Question
be
this
dismissed.
order before the division bench. Division
Their
bench-
question, their
Huh?
question,
Their question.
please.
And their writ appeal is dismissed.
Please, my lords.
What is this consideration of the representation? What is the representation?
Presentation regarding the functioning election. So let them announce the calendar of events regarding the first meeting of the second respondent. Now only 15 directors are elected. Results of the one director, 16 director, that being stayed by the division bench. For that reason, counting of votes, my lords. Regarding 15 seats is concerned, already announced. Regarding 16 seat, they have to stay in writ appeal. That writ appeal came to be disposed of today itself. Then there is no impediment for the second respondent to declare the results of the 16th director.
That I understand.
Please, my
He
lords.
says to consider the representation.
My lords,
Then-
I am one of the aspirant wherein I contested in the election. My results are not declared.
He's impleading a
Freedom.
respondent to your lordship, impleading application not been allowed, your lordship.
Representation.
It's pending.
Presentation they
That is the
submitted.
prayer he sought in the petition. What is that prayer? What is that, that representation to be considered?
Presentation was to conduct the first meeting of the board and elect the office bearers. The impediment was, there was an interim order of stay in the writ appeal. Now today that writ appeal is disposed of, dismissed.
So in the light of it, this can be considered by you?
Yes. Now there can be direction also.
Yes. The present petition is filed. Speak the following prayer. The petitioner is the it is stated that the respondent bank consists of 16 elected directors representing from various constituencies. Elections were notified and the calendar of events were issued on 25/9/2025, notifying the date of election as 25/10/2025, much before the term of the earlier vote coming to an end. It is stated that in this process, several writ petitions are filed, and due to many interim orders subsisting, the results of elections to all constituencies were not declared. After disposal of the writ petitions, elections to 15 constituencies were declared. In respect to the constituency relating to the representative from affiliated consumers cooperative societies and processing cooperative societies, the votes cast by the ineligible voters was ordered to be considered in WP number 100750 of 2025. The same is challenged in writ appeal number 107649 of 2025, and an interim order was granted on 4/12/2025. It is a grievance of the petitioner that out of the 416 posts of director, results to 15 seats being declared, demand joint representation dated 23/1/2026 to the returning officer and assistant commissioners C, requesting issuance of notice for convening the first meeting of the newly elected board in view of there being majority of the elected members and to conduct election to the board of directors. It is a grievance of the petitioner that the said representation is not considered. When counsel appearing for the, who appears for the second respondent?
Milord, I appear.
When counsel appearing for the second respondent submits that the writ appeal which the petitioner is referring to, which is filed by him, that is 1067649 of 2025, where an interim order was granted on 4/12/2025, is disposed of today by the division bench.
Milord, writ appeal number 100750. 100750 writ appeal number.
Not this one.
No.
Writ petition and writ appeal.
So, 107649 he takes.
Writ petition number.
No, writ appeal number is 107649.
No.
100750. WA, my lord, sir, 100750 of 25.
100.
Please.
100.
750.
That is writ petition.
Writ appeal. Writ appeal.
Vice versa.
Vice versa.
So you take writ petition as writ appeal as writ petition. It is submitted that writ appeal number 1000750 of 2025 is disposed of with the division bench of this court today, observing that
Writ appeal is dismissed.
Dismissed.
Writ appeal is dismissed. When counsel submits that in view of the orders passed in the writ appeal, there is no impediment for the respondents to declare the results.
Result of the
It
16.
is submitted that they will consider the representation and will pass appropriate orders. Next, having heard so and so, there is a material not record. The limited prayer in the writ petition is to consider the representation dated 23/1/2026 in the light of the submissions made on behalf of the second respondent. The writ petition is disposed of, directing. You appear for 2 and 3 or only 2?
No, I am appearing for respondent number 2, 3.
The third respondent is directed to consider the representation dated 23/1/2026 in accordance with law.
Please.
All areas will be closed. Yes, next. Next.
Number 46, admission matters.
Time petition dismissed.
Admit post of file hearing TCR 47.
Please.
Bill number 47.
Milord, on quantum matter may be referred to Lok Adalat.
Yes, it is submitted that the matter may be referred to the Lok Adalat. Yes, next.
Seal number 48, Shanapas Poliwat. Deepa Udaya.
Please, Milord. For the respondents.
Please.
In connected matter, I appear for the respondent, Your Lordship, sir. In connected matter, I appear for the response. Case of injury, Your
Admit
Lordship,
file
sir.
hearing TCR.
Alat. It was the last occasion, Your Lordship, sir, posted this matter for disposal, Your Lordship, sir.
Now it is not possible.
Kindly date, Your Lordship, sir. Pray to.
Matter.
Pray to.
Matter on. Wait. This is matter on 19th.
Please.
Seal number 49.
Yes,
Ramesh Ajirule?
49.
49? Ramesh Ajirule?
No representation on behalf of the petitioner. This is matter after 2 weeks.
2 weeks.
Appellant.
Number 50.
Next 50.
My lord, sir, only disability has to be changed and amenities, no compensation is awarded. That is the ground. Only disability has to be changed. Doctor has stated 40%, my lords, ought to have taken 1/3. Here, tribunal, 2 fractures, my lords, compound communicated fracture of tibia and fibula. About income, my lords, they have already satisfied the awarded amount and amenities not awarded.
This who appears for the respondent.
I appear for respondent, my lords.
What do you say?
Doctor has given 40% to the particular limb, my lords, not to the whole body. So the tribunal has considered 25% to the particular limb and taken 8% to the whole body.
25% is also on the higher side. It should be 1/3.
Yeah,
No,
my
no,
lords.
no. What is he submitting? Out of 40, tribunal assess it 25. Out of 25, 1/3 has taken 8%. So that is wrong in,
1/3 of 40.
my lords.
What do you say? There should be some basis for the trial. When there is a medical evidence, there should be some.
He is
basis
not a
for the-
treated doctor, my lords. He is not a treated doctor.
Not necessary that he should be a treated doctor. That's
Actually,
not the law.
he has, no, madam, no, my lords. Actually, he has taken treatment after the accident after the 1.5 years.
We'll
There is no
consider
continuum.
this with up to 2 weeks. Yes, next.
2 weeks.
Yes,
Bill number
51.
51? Yes,
Yes,
Saudagar?
51.
My lord, this is insurance company's appeal, wherein the fastening of the liability has been challenged because a delayed complaint is filed after 4 days. And the
Before
claimant,
amendment or after amendment?
the claimant was stated to be pedestrian. In the evening about 7:30, there is an accident. So my vehicle is involved in the accident. And therefore, and further, my lord, this person has suffered the fracture of tibia and fibula and nasal bone, for which the doctor examiner has assessed 40% disability, comprising of 20% for the nasal bone and 20% for the lower limb. So I'm seeking for the stay for this matter.
They have given the complaint after 4 years from the.
4
date of
days,
accident.
4 days, delayed complaint. Somebody, 4 days.
What was the amount granted by the court?
Compensation is 8,50,000, but
It is submitted that the insurance company is on the ground of liability as well as the quantum, 50%, 4 weeks,
before this court or before MSCT?
wherever you want.
Please.
Yes.
Bill number 52?
Notice.
Lou Prasad?
Yes.
Please. Suit for specific performance of contract, my lords. The suit came to be partly decreed, my lords. By the issue number 1 to 4 was answered in affirmative, and the main issue that was partly decreed by directing the respondent to pay the earnest money, my lords. Thereafter, we have preferred an appeal before the first appellate court, my lords, wherein I have filed an IA number 2 for not to obstruct peaceful possession and enjoyment of the property. Since at the time of execution of the agreement, he has handed over the position. That was the trial court was clearly observed in the judgment, and the issue was framed with regard to possession of the
So
suit.
having injunction pending suit.
My lord.
Were you having injunction pending suit?
Yes, my lord. I have an injunction at the time of suit was pending. In appeal, I have filed an application for not to obstruct my peaceful possession. That was rejected by.
Was it recorded that you were having injunction pending suit?
Yes, my lord.
The appellate court has recorded in the order with regard to your injunction pending.
Yes, my lord. But the first appellate court was pleased to observe that the subject matter of the suit property acquired by the KIDB authority. Now the preliminary notification was issued. Therefore, the possession cannot be considered at this stage. On that ground only, the application was rejected, my lord.
Then if that KDB, if that property is attached, acquired,
Yes, ma'am.
then why do you require this injunction?
My lord, since the preliminary notification was issued and the final notification was not issued, my
How
lord.
will you enjoy this property? When the criminal notification?
Since before issuance of preliminary notification, I have an agreement in the year of 2014, my lords. I have filed a suit in the year of 2022.
True.
Yes, my lord.
What is the requirement of an injunction now? You can't
Since
enjoy the property.
yes, my lord. Since I have invested hard-earned money and developed the property, since I am entitled in as per.
Come to the order. Come to the order. Paragraph number 16.
Yes. Page number 15, my lord.
No, internal page 14 of
Please.
the order.
Please, ma'am. It is further contention of the applicant despite.
Plaintiff has clearly admitted
Yes, ma'am.
Paragraph number 16 of the impugned order.
Yes. The respondent appeared through his counsel and filed a written submission along with a memo prior to treat the written argument as objection to this
Is there
application.
any problem with these numbers? This- Where it starts? Where the impugned order starts?
My lord, page number 9, my lord. See, running page number 9, my lord.
Para 18.
Please, ma'am. Apart from the above, the plaintiff who is examined as a PW1 in his evidence has clearly admitted in cross-examination regarding the acquisition of the suit land by the government KIDB. The relevant portion of the cross-examination PW1 appearing at page number 9 at 7th line, which read as follows. The KIDB has acquired the land and they have issued a preliminary notification. And further, from the above own admission of PW1, the applicant, coupled with Exhibit D3, confirms that from 1/2/2024, the final notification, the suit scheduled property is absolutely vested to the government of Karnataka. When such being the fact and circumstances, the applicant has failed to make out a ground that, as on the date of filing the application, he is in possession of the suit property. Apart from the above, in view of the issuance of notice by the KIDB to all the family members of the respondent, as per Exhibit D2 and D3, the respondent or his family members whose name are jointly reflects in a record of rights of the suit property, suit scheduled property. Land lost their title possession over the suit scheduled property because of the suit as government notification 1/2/2004 vested to the government of Karnataka. Under such facts and circumstances, the question of alienation creating a charge over the scheduled property by the respondent does not arise at all, since he too lost his alleged title possession over the said suit land. Hence, in view of the above facts, documents, reason, the appellant has failed to make existence of prima facie case against the respondent herein. When he has failed to prove the existence of prima facie case against the respondent, then there is no need to consider the point, that is balance convenience and comparative hardship. Even otherwise, the same are not in lies in favor of the applicant herein. Your Honor, I draw your kind attention to the page number. Page number 54, running page number 54. That is the judgment of the trial court, wherein the issue number 4 was framed with regard to possession of the property. The trial court was pleased to observe that the present.
I think that your appeal has to be dismissed with cause. Now, who will seek injunction? Prima facie, you are in possession of the
Yes,
property
yes,
and somebody is interfering. You yourself agree that the government has issued a preliminary notification.
Yes, ma'am.
Now in all the revenue records, now the name of the so-and-so.
It is still not yet appeared, madam.
Even if it is not, you
Yes.
can't use the property when the when the preliminary notification is issued.
Yes, ma'am.
Where is a question of they interfering with your position when the position is with them?
My Lord, since I am in possession of the property, notification was issued, but I have developed the property by investing my hard-earned money. Still, the physical possession was taken by not taken by the KIDB authority, ma'am. And at the time of taking physical possession,
What is the stage of the land acquisition proceedings?
my Lord, still it is under process that they have to issue a notice. It is the duty of the KIDB authority who are in possession of the property. His right has to be protected.
Notices are issued to you.
My Lord, even the respondent is the owner. I am in possession of the property. It is the duty of the KIDB authority to protect my interest. And if at all I am in possession, if at all I have invested the money, and that has to be considered at the time of passing an award, my lords. That is the only reason. My Lord, now.
No, it's a case that I wanted to dismiss it. At least I'm issuing notice. Yes,
Please.
notice. 53.
53.
For the respondent.
No representation on behalf of the petitioner. List this matter for dismissal on Thursday. Yes.
Call. Number 54. Aram Kulkarni. Shuraj P. Mudhol.
Appear for the petitioner.
Appear for the respondent.
Challenging, my lord, the annexure B, my lords, and annexure A as well. My lord, the annexure B, my lord, is
Mo is moved for this matter.
Lord, it is regarding, my lord, the back billing charges. My lords, the respondent number 2 has issued a demand notice to pay back billing charges, my lord, to the tune of 1,60,000. My lords, without there being any mentioning any provision.
That's true. Right from 21 it is
Lord,
pending. What is that?
may I make one submission?
Please.
You moved or you moved?
I have moved, my lord, the matter.
What do you, Lord?
Since is, my lord, that, my lords, he's carrying on the business, my lord, activity in his premise. Now, my lords, he's entitled, my lord, for the refund of 1,60,000, my lord, from the corporation, HESCOM, my lords. Hence, my
Now
lords.
you
Lord.
realize suddenly in 2026.
Lord,
It has been moved continuously, my
Lord,
lords.
Lord, may I make one submission? Appellate authority order may be, my lord, set aside and remand the matter to the, my lord, appellate authority and to hear the matter. And his case is that, my lord, no opportunity was given, but the document shows that, my lord, the opportunity was not given. Your lords may fix the date, let him appear before the appellate authority, and within 4 weeks we will pass an order. Annexure A is the order of the appellate
It's
authority.
not regarding, my lord, the remanding. I'm not seeking remanding of the matter, my lord, to the appellate authority. My lord, the issue is this, my lords. If your lordships may kindly peruse ink page, my lords, 18.
When the now you're questioning the order of the appellate authority.
Yes.
On what ground you're questioning?
My lord, I'm questioning, my lord, initially, my lord, the annexure B impugn notice, my lord, demand notice. That, my lord, was questioned before the appellate authority. Appellate authority, my lord, in my absence, my lord, without hearing, my lord, the petitioner.
That is a
You
ground.
set aside that order.
That is a ground, my lord.
My lord, the intact, my lord.
Why should we
No,
decide? on the merits of the matter?
my core argument, my lord, is that they cannot issue, my lord, such notice asking for back billing charges
To
Or
enter
is the same
appellate
ground?
authority, appellate authority will decide that.
Yes.
in reasonable time.
Petition is filed. Seeking the following prayer. Extract the prayer. It is a case of the writ petitioner that petitioner is having a electricity connection for the stone crusher in the name of J Industries and Stone Crushers. On 18/2/2026, respondent number 3 inspected the stone crusher site and issued 2 rating reports. By raising certain objections stating that there are 2 separate electricity connections in one premises. But the petitioner submitted detailed reply to the respondent number 3 on 29/2/2016. The petitioner in the reply specifically stated that the connection bearing YMGR 30 LT meter is serviced on 12/12/1973 for the stone crusher in the name of J Industries Stone Crushers, Yamagarni, Taluk, Chikkodi, and YMGR 282 LT meter is serviced on 27/1989 in the name of Mrs. Walchand Keshaw for belt conveyor and pumping the water from quarry. And it is stated that the said 2 connections have been installed in 2 different premises. Since the wall between 2 premises was collapsed, they are fixed on the same wall as temporary arrangement till construction of new wall. It is the case of the petitioner that the respondent number 2 and 3, without considering the reply submitted by the petitioner and without affording sufficient opportunity, issued the demand notice dated 21/3/2016 and directed to replace a faulty capacitor within 30 days from the date of receipt of the letter. It was served on the petitioner on 10/5/2016. Immediately, the petitioner has approached the appellate authority by filing appeal on 7/6/2016 by depositing a sum of rupees 80,227, that is 50% of the assessed amount.
80,000, my lords.
Huh?
80,000, my lords.
80,227, that is 50% of the assessed amount. It is a grievance of the petitioner that the appellate authority, without intimating the date of hearing to the petitioner and in absence of the petitioner, passed the impugned order dated 16/6/2020, which made the petitioner to come before the court. Land counsel appearing for the petitioner has argued on the merits of the matter and also submits that the appellate authority, without issuing any notice, without giving an opportunity of hearing, and contrary to the principles of natural justice, has passed the order. And even on the merits of the case also, the said demand notice is contrary to law and the same needs to be set aside. Let counsel appearing for the respondents
Please.
submits that the demands, the basing on the after inspection and considering the case of the petitioner, the demand notices are issued and the appellate authority has rightly confirmed the same. Next, for having heard the so-and-so. The order impugned does not disclose the notice to the petitioner. Before passing any order, the appellate authority ought to have given an opportunity to the petitioner and then ought to have passed an order. In that view of the matter, the order impugned dated so-and-so is set aside and the matter is remanded back to the
First respondent.
appellate authority to consider the same in accordance with law by giving an opportunity to the petitioner. Without further notice, the petitioner shall appear before the appellate authority when? On 23rd February.
Please.
On 23rd February and within how many days?
Within 2 weeks, madam.
Huh?
Within 2 weeks, madam.
Within 2 days.
Please. 2 weeks.
2 weeks. Within 2 weeks from there on, the appellate authority shall pass appropriate orders.
Please.
Accordingly disposed.
Only one request, may I make, Madam? Appellate authority is wrongly described. It is superintending engineer.
Huh?
Appellate authority, respond number 1 is superintending engineer, but in the cost it is wrongly shown as executive engineer. So
You say any, whoever is appellate
Appellate,
authority.
please,
who is
concerned
that?
appellate. Concerned
Engineer.
superintending engineer is the appellate.
Appellate, it shall appear before the appellate authority superintendent engineer.
Please, madam. Annexure A is passed by superintending.
Superintendent engineer on so and so day.
Please, please.
All contentions may kindly be kept open.
All the contentions are left open.
Please.
Obliged.
Yes.
Bill number 55. Mrityunjay Tata Bangi. We have Shilwant here for respondent in this matter.
Lady may kindly provide me with short accommodation.
Any date may be fixed.
Yes, list the matter on 19th of February.
Much obliged.
If interim order is there, extend.
Bill number 56. Yes, Saldikiri. Deepak S. Magnur.
Short accommodation, my lord. Senior is out of station.
This is matter in the month of March.
March.
No representation on behalf of the respondent.
Bill number 57.
57.
SP Patil. Shuraj P. Mudhol.
No represent.
Respond.
No representation on behalf of the petitioner. This is matter in the month of April.
Bill number 58. Urgent. Bill number 59. Nandish Patil.
Lord, writ of mandamus. My lord, this honorable court had directed me to impede the state as party to the proceedings. I have impeded. My lord,
Where is IA?
Your lordship, senior colleague is head up in another quarter. Kindly have this matter.
Where is that IA?
my lord, IA is already allowed. I have already impleaded as a party pursuant to the order passed by this honorable court dated, my lord, 17/1/2025.
The petitioner to plead the state as party to the response. What is this writ petition about?
My lord, writ petition is, my lord, petitioner is a mining company, my lord. My lord, in the year 2010, my lord, Ankola forest officers, my lord, registered a crime against the petitioner company stating that the petitioner is engaged in the illegal mining. My lord, there was a direction by the Supreme Court also with respect to these mining companies, my lord, for conducting investigation. Where, my lord, if the illegal mining activities is above 50,000 metric tons, it's the central government, and if it's below the 50,000, my lord, it's the Lokayukta. Pursuant to that, my lord, inquiry was conducted, and my lord, in the inquiry, my lord, B report came to be filed, page 16, my lord. The trial court accepted the B report. My lord, my excavator, JCB and everything was lying at the Belekeri port. My lord, that, my lord,
Respondent is the competent authority.
my lord, it's the port authority, respond number 1. He has to consider my representation.
Who appears for the director of ports? You appear? Which respondent you appear?
Respond number 1.
He appears for one.
He appears, Vidyavati Kotri Shettar
Yes.
appears. No?
Huh?
Yes. Vidyavati Kotri Shettar appears, and he is her colleague. No?
The senior colleague is the head of in another quarter. Kindly have this matter.
Ask him to come, just a representation to be considered.
Please.
And
Ask
pass
him
over.
to come, pass over.
Pass over.
Please, my lord.
Bill number 60. 60.
Let's I appear for petitioners, my lord.
Yes.
My lords, this is the third round of litigation, my lords. Lords, it is my suit for
partition and separate possession. Let's in the year 2012 it was filed. Let's I filed IA number 3. They filed IA number 3 seeking the permission of the leave of the court to file a written statement after inordinate delay, my lords. On that day, my lords, I formally objected the application, my lords. It was rejected, and they filed a writ petition challenging the order, my lords. And they did not obtain any interim order by this court. And my lords, the suit carried on its way, my lords. And the suit was decreed, my lords. Challenging that, they filed RFA. And RFA was, my lords, after hearing the matter, this honorable court remanded the matter subject to the condition of depositing of 50,000 as a cost on them, and they permitted, my lords. The RA judgment is at page number 90, annexure J.
Then what happened?
My lords, in RA, my lords, this court specifically stated, my lords, at page number 90, my lords.
Page number?
Page number 90 of the petition. Judgment and decree dated 25/11/2013 passed by the so and so Gadag. The matter is remitted back to the trial court. The trial court is directed to accept the written statement filed by the defendant number 1 to 3 and permit the parties to adduce the additional evidence. However, it is made clear that defendant shall not be permitted to file any additional defense. This was the specific direction in RFA, my lords. My lords, later the respondents did not come forward to deposit the 50,000 cost, and again some IAs were filed simply to drag on the matters, my lords. My lords, later one simple application was filed seeking permission to deposit that 50,000 amount.
So now please come to the specific dates. When is the order in RA? Or judgment in the RA, 5th March 2022.
My lords, RA judgment was passed, my lords, 5th March 2022.
2000 from the date of receipt of the 4 weeks time is granted.
Please, my lords.
And then when did they file that memo or whatever it is now you're referring to?
That's what has happened is they filed one more application seeking permission to deposit that amount, my lords, 50,000 cost.
Because it is beyond 4 months.
Yes, that was again rejected, my lords. Again, they challenged that order by filing one more writ petition. Again, in writ petition, order was passed, my lords, by putting some conditions that not to drag on the matters. It is at page number 101 and 102, my lords. This court, my lords, again had put some conditions that the trial court shall not expedite the matter, shall expedite the matter and decide the case within 3 months. And paragraph and point number 3 is important.
2022 is the RFA order.
Yes, my lords.
2nd August 2023, this is still pending.
This one more writ petition was filed, my lords. It was just to drag on the matter, my lords. My lords, point number 3 is important. Trial court is directed to permit the petitioner to lead the rebuttal evidence as indicated in the earlier order passed by this court in RFA. Let's RFA order is important now. Let's RFA in RFA order, they were permitted to make additional to lead the evidence, but not to take the additional defense.
But this runs contrary to that.
Now again, they filed one more application after disposal of this writ petition, saying that this Honorable High Court had made some directions, so accept the fresh written statement.
This is a typographical mistake.
My lords?
This is a typographical mistake in the order. Because RFA order was that they shouldn't reduce any further evidence.
Yes, that is
even in this writ petition, whatever the court said is in accordance with RFA order.
in accordance with the RFA. Again, they filed one more application, my lords, IA number 6. My lords, in IA number 6, they filed IA number 6 seeking permission to file a new written statement in accordance with the judgment passed in that writ petition, which was not so. My lords, that application, my lords, kindly see the memo which I produced, additional documents, that order sheet of the suit, page number 6 of the memo. On the very same day.
No, come to the impugned order now.
Impugned order is, my lords, the next step of IA number 6. IN number 6, they filed seeking permission to file a new written statement. On the very same day, that application was allowed, and the new written statement was taken record.
Order was when?
Let's on 22 to 2024. Immediately, my lords, on 1/3/2024, I filed IA number 7 seeking recall of that order, stating that the old written statement should be considered as per the order of this honorable court in RFA, not the new written statement, which is taking many additional defenses. This is the issue, my lords. That recalling application of mine is rejected. Hence, I am before this court. My lords, this honorable court in RFA, it is very clear that no additional defense should be taken and old written statement should be considered.
The IA, when he has filed the IA for filing the return, to take that written statement, what was your objection?
They did not permit me to object it. The copy of the IAS were not served, my lords. That's what it is stated in the order sheet, my lords, page number 6.
What is the prejudice caused to you? That written statement or this written statement is one and the same?
No, my lords. There is complete.
Not objecting for filing of the written statement when it was directed to be filed 2 years back, when they filed it after 2 years.
No, my lords. First written statement was filed in the year 2013. The new written statement is filed in the year 2022.
No. RFA order, what is RFA order? Court said
They should consider the old WS.
whatever it is filed, it should be, they should be permitted to, that shall be taken on record, the written
Yes.
statement. So where is the question of filing a new written statement?
The new written statement was filed subsequently of the RFA judgment.
My lord, sir.
RFA judgment was passed in the year 2020.
Come to the RFA judgment again.
Please, my lords.
At page number 90, my lords.
Page number 90. Operative portion is at 90, my lords.
The trial court is directed to accept the written statement.
Yes.
That is what I am asking. When there is nothing, no IA is required now. Already what was there before dismissing the suit or allowing the suit, whatever is a written statement, that has to be accepted. That is already there in the record.
Yes.
Because that was rejected.
That is the old
one.
Old WS.
The court has directed that to be accepted.
That to be accepted. Now they have filed IA number 6 with the new written statement, which is taking with the complete.
Nowhere in the order it has been stated that it has to accept the written statement which has been filed in IA number 3 in 2013.
RFA judgment is clear.
Please read the order at 90. I think plain English you should be able to read. Read it.
The trial court is directed to accept the written statement filed by defendant 1 to 3 and permit the parties to adduce the additional evidence. However, it is made clear that the defendant shall not be permitted to file additional defense.
Already filed by the defendant.
Please, my lord.
That has to be accepted.
My lord,
And first of all, when already a written statement is filed and there is a positive direction to accept it as it is, why should you file?
My lords, that was not accepted, my lords. That was rejected, and the OS which was filed, my lords, that has also been set up in this RFA order, my lords. The first para, it has been the RFA court has set up.
Impugned order is at annexure Q, my lords.
Page number
129.
Operative portion is at, my lords, the reasons given by the trial court, my lords, at page number 140, 141, my lords, 142. My lords, the impugned order also says the same thing, my lords, which are perusal of the
paragraph number 16.
16. Perusal of the Honorable High Court of Karnataka, Dharwad bench. Order. However, the Honorable High Court of Karnataka, Dharwad bench has not whispered in the judgment passed by the passed in RFA number 10037 of 2014, stating that our earlier written statement filed by us may kindly be considered and same may be brought on the record, and no such order has been passed. And however, the Honorable High Court in paragraph 7 of the said order, however, we are of the opinion that
Agreed with the orders passed in. On a memo agreed with the orders passed on I number 7 in OS number 52 of 2012. Dated 18 March 2024. The plaintiff is before this court. The plaintiff has filed the suit for
Partition and separate position.
partition and separate position, which came to be decreed. In the said suit, with the inordinate delay, when the defendant wanted to file the written statement, the same was rejected. Again, such a writ petition is filed, and as no stay orders were granted, the suit was proceeded and the suit was decreed. Against that, RA was filed. That RA came to be that came to be allowed by setting aside the judgment and decree. And in the said RA,
My lords, RA was not filed.
Huh?
RA was not filed. My lords, after OS, they filed an FDP, my lords. In FDP, I have filed I number 9 for depositing the 50,000 rupees which was imposed on me.
RFA is filed.
Please, my lords. After,
RFA.
please.
RFA was filed. That is RFA number 1000337 of 2014. That came to be disposed of by order dated, by judgment and decree dated 5th March 2022. The judgment and decree passed by the Additional Senior Civil Judge and CJM Gadag in voice number 52 of 2012 is set aside, and the matter is remanded back to the trial court. And the division bench has observed that the trial court is directed to accept the written statement filed by the defendant number 123 and permit the parties to adduce additional evidence.
My lords,
However,
may I make a humble submission? At page number 90 of the RFA, my lords, there's an observation made by the my lords. The first parody said that, however, we are of the opinion that one more opportunity has to be given in the interest of the justice to the appellants but defendant 123 to file a written statement, my lords. So on that basis, even I number 7 has been rejected.
Ultimately the judgment and decree, that is what matters. Discussion doesn't matter in what is executable is that.
I number 7 was rejected based on this.
Directed to accept the written statement filed by the defendant number 123 and permit the parties to adduce additional evidence. However, it is made clear that the defendant shall not be permitted to file any additional defense. However, for the inconvenience caused, the appellant defendant number 123 are directed to pay cost of rupees 50 lakhs to the plaintiff within 4 weeks from the date of receipt of the certified copy of the order. It is the case of the petitioner plaintiff that, in spite of an order passed on 5th March 2022 in the RFA, till 2nd August 2023, not 2nd August, they have failed to pay the said amount. And when they sought the leave of the court to pay at a later point of time, the court had dismissed the said application. Then again is that they preferred WP number 101125 of 2023, dated 2nd August 2023, whereby the petition is allowed and the order is set aside subject to the petitioner paying additional cost of rupees 10 to the plaintiff on the next date of hearing before the trial court. The trial court is directed to permit the petitioner to read the rebuttal evidence as indicated in earlier order passed by the court in RFA number 10037 of 2014. Trial court shall expedite the matter and decide the matter within 3 months. Thereafter, the respondent has paid 50,000 and also filed a written statement. That written statement was taken on record. It is a contention of the petitioner that no opportunity was given to the petitioner to file his objections. The order in the RFA is very clear that the written statement that is filed by the petitioner shall be taken on record and no further shall not file any additional defense. Which makes it clear that the written statement that is filed earlier shall be taken on record. It is a case that the petitioner, the defendant respondent herein has filed a new written statement in the year 2024 by IA number 5.
IA number 6, ma'am.
IA number 6. And the same was accepted without an opportunity. Hence, they have come up with the impugned IA to recall the said order. The court, without appreciating the contentions raised on behalf of the petitioner, had dismissed the IA. It is submitted that the order impugned needs to be set aside. Next part. When counsel appearing for the respondent defendant submits that nowhere in the entire order in the RFA, it is stated that the petitioner shall, the earlier the written statement that is filed shall be considered, and the petitioner cannot file a new written statement. The court had rightly considered and permitted the petitioner to file the written statement, and there is no infirmity with the said order. What else?
My lords, I number 7 was rejected on the ground that the observation made in the RFA. I number 7, which was filed by them for the recall, my lords, that was rejected on the order. That was rejected based on the observation made in the RFA, which I had said.
It is submitted that court had rightly considered the order passed in RFA and rightly dismissed the petition. There are no grounds to interfere. Next, having heard the counsels on either side, there is a material on record. The suit is filed in the year 2012. The petitioner has failed to file the written statement. The respondent has failed to file the written statement, and the suit is dismissed. Without a written statement, the suit came to be decreed. Against that, RFA number 10037 of 2014 is filed. That came to be disposed of on 5th March 2022. A perusal of the order passed in the RFA is clear that the trial court is directed to accept the written statement filed by the defendant number 1 and 3 and permit the parties to adduce additional evidence. However, it is made clear that the defendant shall not be permitted to file any additional defense. On the first count, when a suit of 13, when an RFA is disposed of on 5th March 2022, what was the defendant doing without filing the written statement, without a whisper about the written statement till 2024 is not known. Right from the beginning, even as per the order in the RFA, the only grievance is that without the written statement of the petitioner on the defendant on record, the suit has been disposed of, the suit has been decreed. Then the court has directed that written statement to be taken on record. The petitioner, and that he also does not, is not permitted to file any additional defense. In that view of the matter, the court in the RFA court is very clear that the written statement as on the day that is filed shall be taken on record. The respondent, in spite of an order passed by the court in the writ petition that the suit has to be disposed of within 3 months, in view of all these applications, the same could not be disposed of. In the considered opinion of the court, the contention of the petitioner has the court has wrongly dismissed the IA that is filed. Accordingly, I number so and so. Accordingly, this court is passing following order. I number so and so. The order impugned dated so and so is set aside. Consequently, I number so and so filed by the plaintiff is allowed. Number 2, the court shall take into consideration the written statement that is filed earlier, that is before the dismissal of the RSA, before the dismissal of the suit. 3, the court shall expeditiously dispose of the suit itself within a period of 3 months from the date of receipt of the copy of the order. Court shall not grant unnecessary adjournments to the parties.
Well, it's one submission. The date of that written statement may be.
What is the date?
21/2/2013.
21/2/2013. 21/2/2013.
Please.
Yes,
Grateful.
Number 61. Question side.
So I have for the petitioner.
Lord, in this, the state has filed memo for disposal.
Proposal I have filed, my lords.
Lord, the petitioner, his employment was terminated because the respondent state was directed by the law minister to appoint some other person.
Kindly see the prayer, my lords. Prayer at ink page number
Order dated.
15,
Passed by the respondent number 3, Deputy Commissioner.
please.
What is the order passed by him?
Termination order, my lord.
Terminating the,
Petitioner from his employment.
from the,
From his employment, my lord. He was working as legal cum probation officer.
legal cum professional officer.
Probation officer in the office of District Child Protection Officer.
When was he appointed?
My lord, he was appointed on 4/4/2021.
4/4/2021. What are the terms and conditions of appointment?
He's an outsourced employee.
I make one.
Outsourcing employee.
He is outsourcing employee.
That's what, let him.
Please,
He's an outsourcing employee.
Outsourcing.
Lord, one more humble submission is, in fact, the petitioner has engaged services of senior counsel. He has requested to seek time, my lord.
I refused to grant time yesterday.
Please, my lord.
Then,
Please, my lord.
please go ahead.
The facts are that, my lord, the petitioner employment was terminated. Thereafter, he filed this writ petition challenging the termination.
The court
Please, my lord.
is an outsourcing employee.
Please,
In that case, what are your rights?
please, my lord. The settled position of law is that, my lord, an ad hoc employee cannot be replaced by another ad hoc employee. The petitioner was terminated and some other employee was appointed to the same post. No notice was issued to me.
Right.
No notice was issued to me, my lord.
That's what, please show to the court your employment. Where is the terms and conditions of your employment?
Please, my lord.
Come to that.
Ink page, my lords, annexure C, ink page number 23.
20.
3. My lords, after his name, the conditions are there in Kannada.
What it
And,
says?
my lords, it says, my lords, his appointment is temporary. And more particularly, my lords, serial number 4. And it is a temporary, my lords, government service. And this appointment, the other, my lords, service rules of the government employees will not be applicable. That is clearly stated. Moreover, my lords, after the, my lord, filing of the writ petition, he has been reinstated to the same post.
He has been
Reinstated. He has been, that is, my lord, sir, I filed a memo for disposal application.
Pursuant to reinstatement, my lord, I was pressurized to withdraw the writ petition continuously. The reason being simple, my lord.
no, not pressurized. Why is it the weapon against the deputy commissioner or what?
My lord,
Now when you're reinstated,
please, my lord.
why should you have this writ petition again?
My lord, this honorable court on earlier occasion, my lord, 29/1/2025 has made few observations, my lord. Before that also on 9/1/2025, this honorable court had directed the respondent state to produce few documents which led to termination of the petitioner's employment. That was subsequent to the reinstatement. That order is not being complied, my lord. And when we are continuously pressurized, when we have made allegations against certain officers.
Oh, I'm not able to understand.
Please, ma'am.
What is your right? What is your right to be continued?
My lord,
There is no even specified term also. We have taken you for a short time on an outsourcing basis. What is your
Please,
legal right questioning them that it should be in this manner? You shouldn't take other persons and all.
my lord, as I submitted, my lord, the settled position is that ad hoc employee should not be replaced. And the prayer which I have sought is continuation of my employment till there is a regular appointment.
You are an outsourcing if that is the case,
Please, my lord.
nobody can engage any outsourcing employee if the analogy what you are submitting has to be applied to the case.
My lord, because the position of law applies to me also.
Legal right.
Legal right is that, my lord, because if my employment is for no reason, without notice,
They are not satisfied with you, they will take somebody else. What is wrong in it?
for no reason, my lord. And Honorable Apex Court has condemned this kind of practice, arbitrary termination without notice, without reason, in several cases, my lord.
Just because the respondent happens to be the deputy commissioner
Please,
and you're
ma'am.
working with that department,
Please,
it
ma'am.
will not give you any right to come before the court by filing a writ petition.
No, my earlier termination was because of the reason that the ruling party's law minister had recommended some other person to be appointed to my post, my lord.
Who told you that?
My lord, I have produced a certified copy of the recommendation letter, my lord, along with memo dated 9/1/2025. On earlier occasion, this honorable court had made several observations regarding that. the fact that I was pressurized and I am harassed till today also, the pressure,
No, anyhow, now
employees.
you have got another recommendation, that's how you are in the, in your, in service.
My lord, even if this petition is disposed of, my humble submission, my lord, tomorrow vindictively, if they take any action against me.
Forever, we have to protect your position by keeping this writ petition pending.
No, I'm not asking, my lord, I'm not requesting, my lords to
Now
keep
you
this
are, now
pending.
you are reinstated.
Please, my lord.
What remains in the writ petition?
My lord,
Writ petition should pass that, till he shall be continued, till he retires.
No, my lord.
He shall be, these things should be done to this petitioner.
Please, my lord. The relief which I have sought, the reason is being simple, my lord. The contractual employment is itself a condemnable practice. The very object of
Why did you join again?
no, I have not joined anywhere else, my lord.
No, here, why did you join?
My lord, I am not in a position to bargain for my legitimate rights.
All that argument for the sake of, looks very novel for the sake of argument.
Please, madam.
Practically, that is not what happens in reality. So, all this, we are not going on contractual employment, that issue and that. We are only on your legal right.
Please, my lord.
In the light of the fact that you are already reinstated, nothing remains for consultation in these writ petitions.
My
I
lord,
will discuss the writ petition. on
If they comply the court's order, another subsequent event, my lord, subsequent to this, the district child protection officer, after filing of this petition, she had threatened all other outsourced employees working in the office of being removed from their services.
Sorry, about other
Several
employees.
sequence of events have happened, my lord.
About other employees. You
My
are
lord,
not
the
concerned
only
with-
place where we can seek for our grievance is only court of law, my lord, because they are not taking any action against respondents because it is the law minister who is on the, who has recommended.
Or not the things we will go into in a writ.
My lord, the recommendation letter I have produced before honorable court.
You have no legal right, they have no obligation.
My lord, legal right I would have
Legal right
established.
you have.
My lord, when Supreme Court,
You are a outsourced employee.
Please, ma'am.
What is the legal right?
my lord, I can be continued till there is regular appointment, my lord.
No.
If there is no misconduct on my part, if I have not committed any mistake, if I am not wrong on my part, my legal right is that I shall be continued.
This matter as parted on the top of the list on.
Kindly on 11th, my lord.
On 18th of February. I'll dismiss it.
Kindly on
the
11th,
day.
may I request on 11th, my lord,
11th is not possible. On 18th,
please.
not on 18th, let's have it on 24th of February as parted and I'll dismiss it on that day. I'm making it very clear.
Please,
Yes,
oblige. Interim order may kindly be extended.
yes, interim order only granted is extended in that. Yes.
Seal number 62. VG Kattimani.
Your petitioner filed the.
Yes, my lords, I seek some instructions, my lords.
There is
I
a
need some
representation to refund the amount, my lords. There is a identical order has been passed, an Exer B, my lords.
13/1/2026, learned HCGP shall get instructions by 5/2/2026. Why you did not get even after 15 days also?
Short accommodation.
Well, there is a refund of the amount, my lords.
Let's see what is that you are seeking. I will direct them to consider your representation, not release the amount. Where is your representation?
An XRF earlier in the writ petition has been considered, but till today they have not considered, my lords. Identical matter, my lords, an XR B, my lords. They have passed the order, my lords. And also that notification has been challenged.
What is the amount that they have to pay? How will this court determine? What is the amount to be paid to
In
you?
Annexure G, my lords, there is Annexure G, my lords. One of the petitioner has taken the amount, my lords. Remaining amount has to be paid to me, my lords.
No. You say you give an amount, 5,73,577.50. How
Yes.
will this court know that this is the amount that they are supposed to pay to you? It is a question of fact,
Please.
which can't be decided. Now, if you have given a representation to them, seeking this amount, I'll direct them to consider in accordance with law. But if there can't be a direction that you pay 5,73,577. Where is the representation given by you?
Annex A, my lords.
Page number?
Page number 10, my lords.
Please come. The petitioner has given a representation to the respondents. Respondent number
Respondent number 3, my lords.
76 on 7/6/2024 to the respondent number
3.
huh?
Respondent number 3, my lords.
Respondent number 3 seeking seeking that the sale proceeds kept in the office kept with the respondent may kindly be released to may be released in favor of the petitioner. And the seized sale proceeds may be refunded to the petitioner at the earliest. It is the case of the petitioner that petitioner has purchased black green gram in local market of Akkialur village in Haveri Taluk from different agriculturists and stored in Karnataka State Warehouse, Haveri. The third respondent, Deputy Commissioner Haveri, has seized the black green gram of petitioner. Petition has filed WP number 1008887 of 2016 to release the seized black green grams. Then the petitioner has filed a review petition before this court, and the same was dismissed. The first respondent has written a letter to the second respondent regarding the refund of the refund of the amount. The second respondent also communicated to the first respondent regarding the refund of the amount. The third respondent directed the fourth respondent to take action regarding the same. It is a case of the petitioner that the respondents have not taken any action in spite of an order passed by the court and the representation given by the petitioner. Considering the submission of the land counsel for the petitioner, they shall be directed to the Deputy Commissioner, that is the
Respondent
Number
2, my
3.
lords.
that is the third
R3,
respondent.
yes.
Please, third respondent.
Third respondent to take appropriate action pursuant to the order dated order in WP number 1008887 of 2016 within a period of 2 weeks from the date of receipt of the copy of the order.
Please.
Yes, next.
Seal number 63, Rajshekhar Burji. We have shield 1.
My lords, praise for a short accommodation, my lords. Advocate.
My lords, I have moved the matter because I have been allotted tender work.
Give that.
I have been allotted, they have challenged the tender work, my lords. They say that without acquiring their land, the tender has been allotted to construct a bridge cum barrage, my lords. I completed the work. My amount is held up because this writ petition is pending. Any date, a date may kindly fix, short date, because he is seeking for time.
Tomorrow may be given, my lords.
The tender work and paper publication wherein the tender work is called is under challenge before this honorable.
No, by virtue of this tender,
Please, my lords.
this notification tender is given to you, you have worked out.
Work is completed.
Tomorrow may be given, my lords. Advocate on record is not due to some personal inconvenience, my lords.
Then what remains to set aside the tender? What will happen now? He has executed the work. This is matter as part of tomorrow.
Please, my
Top of
lords.
the list.
Top of the list.
Yes, 64.
Seal number 64, Chetan Munwali, Ramchandra Mali.
Any interim order in this? No representation on behalf of the petitioner. List after 4 weeks. Counsel for the respondent is present. Yes.
Seal number 65.
This case, I have been distributing fair price shop since last 30 years, my lords. Up to 2020, during Corona, as I was not well, that was given to some other person. And again, it was allotted.
Move the memo.
I have moved the memo.
Why?
Without hearing me, my license has been my order for fair price distribution has been cancelled unilaterally.
Where is that order?
Order under challenge, my lords. Annexure N.
Page number?
Page
Is
number.
it correct?
Yes,
Yeah,
my lords. It
41.
is a, my lords, temporarily, my lords, an arrangement was made because may I read the my lords and submit?
No, only one thing I want to know.
Please.
Whether a notice is given to the petitioner before cancelling the authorization.
We are not cancelled, my lords. It was, my lords, temporarily, my lords, given to the, my lords, the respondent number, my lords, 6, for the purpose of, my lords, easy distribution of the, my lords, commodities, respondent number 6. It's only a temporary arrangement is made.
In the month of January 2000.
Yes.
The procedure under the act. If you have to make a temporary arrangement, basic, whatever, yeah, before that a notice is required or not required? Ask,
Notice is.
show me from the act.
Yes. Notice is required, my lord, certainly.
Let us see.
Please. Control order.
Which deals with this?
There is no such provision is contained in the my lord's control order. But anyhow, my lords, against the order of any, either for cancellation of the my lords, the license.
Order which is passed without principles of natural justice,
Yes.
that alternative remedy will not apply. Please show me what is the procedure when an arrangement of this nature has to be made. I request the HCGP and AGA both to have all the acts, all
Yes.
the instructions with you whenever you're arguing before the court. Mrs. Mata, on Tuesday.
Seal number 66. Please.
Why a memo is moved in this?
So the proceedings are stayed, my lords, in view of the interim order here. 2010 suit.
Yes.
My lords, some documents which are in Kannada also.
Let's see whether,
Yes, yes.
whether I need to look at the documents or not.
My lord, the petitioners here were the defendants in a suit filed for declaration and for injunction, my lord. The suit came to be decreed without being there, relief of possession was granted, against which we filed an appeal RA. RA was dismissed. In RA, there was an order for possession also, without being any amendment or anything. Against which, my lord, we filed a second appeal. Second appeal, my lord, was allowed on the ground that during RA, my lord, some additional documents were filed. That was not taken into account. So this honorable court allowed the allowed the second appeal and remanded back. And thereafter, my lord, that applications was allowed. The IA which we filed in the year 2016 before RA. Subsequently, my lord, that against which, my lord, we filed another 2 IAs. One is for additional evidence to produce the documents that the deceased and the deceased, the owner of the defendants, who claims the deceased as their father, was having a relationship with the petitioner grandmother. They lived as husband and wife for more than 45 years. So on that basis, we filed an application to produce the diary and other documents like mutation entry, everything, my lord, in an IA in the appellate court, my lord, and amendment of the written statement. That application and written statement were allowed, and trial and lower appellate court remanded the matter back to the trial court to give a finding on these issues. Against which, my lord, they filed a miscellaneous appeal saying that the lower appellate court should not have remanded the matter. It should have taken it and decided, or it should have, under order 41 rule 25, it should have directed the trial court to secure the evidence and give a finding and send back as provided under order 41 rule 25, my lord. Against which they filed MSA, my lord. The notice was served because, my lord, this appeal we did not appear And immediately, my lord, the MSA came to be allowed and directed the lower appellate court to once again decide the appeal as provided under Order 4125. Now, my lord, the lower appellate court has, without considering my application, it has deemed rejected, only allowed one of the document and rejected my amendment. In respect, I sought for amendment of para 10A to F, my lord. Yes. My lord, the impugned order, for lordships may permit me to just the
Annexure P.
the
Huh?
annexure
Page number
P.
169. The up to para number 85, page 191 is the discussion regarding the pleadings. 86 is the finding.
Where is the reasoning starts?
Yes, ma'am.
86, page number 191, my lords.
So before that, if your lordships may get the relevant would be, my lords may, though in the impugned order, my lord, it says that IA filed is partly allowed, defendants are allowed, appellants are allowed to produce registered sale deed dated so and so by way of addition. IA filed is partly allowed, defendant permitted to insert by way of amendment to the written statement para 10F only, as shown in the application. In view of the following issues, whether defendant proves that the Sharda purchased property of so and so, of property item number 1 or registered so and so. In view of the provisions of Order 4125, the matter is remanded to the so and so to give finding on issues. Liberty is reserved, my lord. Thereafter, and there the matter was kept. This appeal was kept as signed time, my lord. Last.
Please read from 54.
Please.
Para 54.
Para.
54 of the impugned order.
Yes. The appellants sought permission to produce certain documents at additional. They want to produce important one diary said to be maintained by Siddhappa and pension document of Sharadabai so and so. Appellant also sought permission to amend returns to include some contention regarding relationship between Siddhappa and so and so. They wanted to contain Siddhappa married at Gokarna in the year 1951. Same is mentioned by him in the diary. More important, they want to contain suit schedule property so and so. Item number 1. Property was in fact purchased by Sharda under registered sale deed dated so and so. As already of this court by judgment dated 1412 allowed the appeal remanded the matter. The reason for remand is that that the court came to the IA filed by how to be allowed. This judgment was again challenged before the Honorable High Court in MSA number, as already observed by the Honorable High Court by judgment dated to set aside judgment remanded to consider appeal, keeping with the power vested and the first under Order 41 Rule 25. To put it simple word, dispute is only with respect whether property were transferred to Shadab and whether Shadab continued as owner of the property. In fact, defendant rely upon some worthies given to revenue authorities by Siddhappa. Thereafter, they want to rely upon relinquished deed said to executed so and so. But now it is for the appellate court to decide whether defendants are to be allowed and to amend written statement and to produce the documents. Your Lordship, thereafter it said para 64, my Lord, next. So far as first and second conditions are concerned, absolutely there is no material. Defendant in 2 general want say that they were clean. So and they found the diary and wherein factum of marriage with the Shardabai at Mahabaleshwar at Gokarn is mentioned. Much was argued on this, but it is pertinent to note that the diary sought to be produced in the year of 64 onwards. According to defense, used to maintain and he was making mention day-to-day affair. But this diary now produced comments from 60. In fact, the diary is discontinued at some place, but there is a reference of going Gokar in the year 1970. There is also a reference to family tree, but this entries will not prove the legal marriage between Siddhappa and so and so. Undisputed fact is the legal wed wife, which was still young. Both parties, in fact, indirectly say that Sharadabai and were living together. Defendants say that they were husband and wife, but plaintiff only says Sharada was manager of the suit property. Question is whether is required to be effective dispose of matter. First of diary such cannot say to be diary maintained by Siddhappa because there is no continuity. Diary being in the year 64, there is some discontinuation. Again, it starts from 174. So this, my lord, whether those documents are relevant or not, my lord, It was already earlier round of litigations, my lord. It was held that those required itself. Since, my lord, the earlier order was set aside because it was the trial court, lower appellate court did not comply, order 41, rule 25, my lord. So, my lord, that is the reason, my lord, their lordships directed me, what are the applications to be filed, my lord. So I produced the another memo with the documents which sought to be produced, my lord. So, my lord, nothing prejudice would be caused that if this entire application is allowed, my lord, partly allowing, my lord. May my lords may just
What is the suit for?
suit is they filed suit for declaration and for permanent injunction.
Declaration that?
Declaration, they are the owner by virtue of Siddhappa died and they are his legal heirs. And we are Sharada Bai was manager only and she was not as a wife itself. That was their contention. And we contended that they, Siddhappa and Sharada Bai lived as a husband and wife and he maintained document and diaries, my lord. My lord, kindly file for a moment page 154, my lord, earlier that were allowed. This honorable court in MSA only remanded the matter, but not set aside those orders, my lord. The lordships may kindly see page 154.
Yes, what do you say?
And even in this order also, my lord, 91 page says
Only
that.
seek for early disposal, my lords, because of the year 2010 and para number 86 may kindly be raised.
We'll allow that application, the other one also. Let the suit be disposed.
There was the earlier round of litigation before the appellate court. The appellate court has blindly allowed the application, rejected the application. Therefore, they had to challenge the same. And now, in this case, in the impingement order, there was a detailed discussion as to why the documents are not necessary. At para number 86 to
When they want to file the documents, no, at this stage, that kind of a roving inquiry is not
My lords.
required by the court. So what we do is we'll allow this application and we'll decide, we will direct the appellate court to decide the matter
under a time frame, my lords.
within a time frame.
No, trial court is remanded, my lord. The lower appellate court has kept the matter sine die and directed the trial court to give finding and send back, my lord, as per direction of this honorable court, my lord.
Now
Yes,
when this court directs the appellate court,
To-
lower appellate
yes,
court to
yes.
decide, it will take care of that.
Yes, because this order is passed, my lord. This honorable court directed page 168, my lord, in MSA. So that is being considered.
Now the entire
We will
appeal
direct
has
the
to be.
appellate court to decide the appeal. So how it will decide the appeal, it will take care of it.
Yes.
By asking the trial court to speeden up whatever it is.
Yes.
Agree with the.
Those applications are, my lord, annexure J and
In all, 3 applications
J and
were filed, my lords.
No,
Only the order is in respect of 2 applications. That ambiguity should not be there again.
J and K.
There is an application at I,
No,
annexure
where
E.
is that page number?
My lord, annexure J is page 110, my lord, my application. And another amendment is annexure K, my lord. That is 100.
Impugned order.
Impugned order, my lord, is annexure P.
Page number.
Yes,
Yes, I.
169, man.
No, an application under order 41 rule 27.
Yes.
Why should be there an order on this? When an application is filed under order 41 rule 27.
Yes.
Court will decide whether it is necessary or not at the time of passing of the judgment.
Yes, at the time of fasting only it was decided, not separately, my lord. Your lordship may kindly see, the IAs are allowed and thereafter, my lord, what has happened earlier, it was allowed entirety, my lord. So they challenged this one, say, my lord may kindly see, earlier order may kindly see, my lord, the lordships may get this. The lordships may get page 157, my lord, earlier RA order, which was in, these applications were allowed. So they challenged this one.
No, this is, the matter needs to be referred to the trial court to give a finding on the issue and submit the record and answer the points.
Yes.
Consideration accordingly.
Yes, your lordships may kindly see for a moment, page 157, ma'am. No, this order was passed. So they challenged before MSC in this honorable court, my lord.
I am asking about the present order. Where
Yes,
is
ma'am.
it?
Present order should have been allowed entirety.
What is that? That page number I am not able to find.
Yes, last operative portion itself, my lord.
Page number?
194, my lords.
194, my lord. The IA dated so and so is allowed, 2016. Defendant are allowed to produce. IA dated 20 is partly allowed. Defendant are permitted to, by way of insert to amendment of written statement, para 10 only, to show in view of this following issue is framed whether so and so, my lord. In view of the provisions of order 41 rule 25, matter is remanded to senior civil judge Khanapur to give finding on issue framed by this court. Parties are liberal to adduce evidence on the issues framed. Whole exercise to become within 6 months. Thereafter, trial court to submit TCR along with its finding. Since matter is of the year, parties are direct to appear so and so. Send back TCR application mentioned above and document filed by the parties before trial court. So matter is.
As per this, we will direct the trial court to decide this issue within a month. Thereafter, the appellate court also will give a direction.
Yes.
A time frame, within a time frame also.
My lord, that may require some evidence, like 2 months or. I am not saying the burden of
Only
whether
thing is
the
that 2010 matter,
Allala.
2012 it was disposed of, and in the appeal, the
No, I
matter
am
is
not
being-
saying, my lord, we don't know what is the pressure of that court.
and they are in possession. That's it.
No, so almost half of the pressure is created. The
My lord, deemed rejection is there, in fact, that application. That is there, well, their lordship, while considering interim order on 20th August, my lord has held that.
agreed with the order passed in RA number 238 of 2012, dated 21st March 2025. The defendants are before this court. The defendant has filed IA number
My lord, page 110 is annexure J, my lord. And annexure K.
Annexure J.
Annexure J.
have filed an IA under application under order 41 rule 27.
And another application.
And another application is
Annexure K, my lord, page 115 for to seek
Order
amendment
6
of the
rule
written statement.
order 6 rule 17.
And further, another I, my lords.
And by way of an application under 41 rule 27, the petitioner
Annexure E.
That is.
wants to produce a document. Now, this order is pertaining to this only.
Annexure E may kindly be.
Annexure E was also earlier, 2016. man.
Annexure E is allowed.
Allowed.
The annexure J, it is silent, the order is silent.
Yes, that's what.
The
J and K are.
J and K, on all the three Is.
the court, you've done about both the one. One is under order 41 rule 27 and the other is order 6 rule 17. The court by order impugn had allowed the IA dated, IA filed under order 41 rule 27 is partly allowed, whereby the appellants are allowed to produce a registered sale stated 25/5/1973 by way of additional evidence. And IA dated 29/10/2022 filed under order 6 rule 17 is hereby partly allowed. Now the petition is before this court. And after that, then the defendant appellants are permitted to insert by way of amendment to the written statement, para 10F only as shown in the application. and an issue is also framed where the defendants prove that Sharda Bai had purchased property in survey number 38/1A of, how do you spell it?
That Mangyan Koppa.
Mangyan Koppa.
Yes.
Property under a registered sale deed.
Suit item number 1.
In view of the provisions of Order 41 Rule 25, the matter is referred to Senior Civil Judge Khanapur to give finding on the issue framed by the court, and parties are at liberty to adduce evidence. The court has, the whole exercise has to be completed within 6 months. Thereafter, trial court to submit TCR along with its findings. Since matter is of the year 2010, parties are directed to appear before the trial court on 24/4/2025 without waiting for the notice. The Land Council appearing for the petitioner submits that the petitioner, by way of an IA under Order 41 Rule 27, is he wants to place on record
Lord.
where is it?
My lord, page 112, my lord. The diary, mutation entry and other aspects of the DC. 112, my lord. The para 3, my lord, relevant.
The petitioner wants to adduce the place on record by additional evidence. One diary book wherein the day-to-day events are written by late Siddhappa. After going to the contents of the said diary, they came to know that he married Sharda Bai during his lifetime in the year 1951. And also they want to produce the pension payment order and ID card of Sharda Bai. Along with that, the Vardi application given by Siddhappa to revenue authorities. It is their case that they came to know about this in the second week of October 2022. As such, they want to place all these documents on record. The court had observed that first of all, the diary as such cannot be said to be a diary maintained by Siddhappa because there is no continuity. Diary began in the year 1964. There is some discontinuation, and again it starts from 1/1/1974. So it is not the contemporaries document, and as such, it is rejected. Then coming to the reliance upon the mutation entries, how far those entries would come to the rescue of the defendant is a point to be determined, irrespective of the fact that whether or not there was a legal marriage between Sharda Bai and Siddhappa. Coming to the pension payment order, the court has observed that that passbook will not be helpful to find out the answer arising in the suit. As far as the RTC extracts are concerned, the court has permitted them to produce a sale deed dated 25/5/1973. In the earlier also this include 25/5/1973. The Land Council appearing for the defendant submits that the court at this stage cannot decide whether the same is necessary or not. It is submitted that if those documents are taken as additional evidence and the trial court decides about the same also as contemplated under Order 41 Rule 25, it would decide the issues that are involved in the suit, and the court ought to have allowed the application in toto instead of allowing only sale deed to be produced as additional evidence. Then counsel appearing for the respondent plaintiff submits that this is a suit of the year 2013, and from 2013 till now it is pending.
2010, my lords.
Huh?
2010, disposed 2012.
2010 is, and from the last 16 years, the suit is pending. It is submitted that the court has rightly considered and passed an order considering the fact that it is a suit of 2010, there shall be a direction to the court to dispose of the matter as expeditiously as possible. Having heard the counsels on either side, peruse the material on record. This court has seen the application that is filed under Order 41, Rule 27. The reasoning that is given by the court and going into the conducting a rolling inquiry at this stage, whether they are helpful to the petitioner, to the defendant or not, are not necessary. In the considered opinion of this court, all the documents that he wants to accuse as additional evidence under Order 41, Rule 27 ought to have been allowed by the court. In that view of the matter, this court is passing the following order.
So also, my lord, so also written statement, because those are in consonance with those. Amendment of written statement.
Whatever you filed an application under Order 21 or 41.
Two applications were filed.
Another annexure K is for
Rule
amendment,
17.
because that consonance with these documents, that written statement is pleaded, my lord. So if application is addition is allowed, my lord, so there has to be pleadings, my lord. Please.
In the light of these documents being allowed to be taken as an additional evidence, the petitioner can also amend the written statement by incorporating the pleadings in the written statement. In that view of the matter, this court is passing the following order. IA dated 28/3/2026, filed with the petitioner under Order 41, Rule 27, is allowed, and the petitioner is, the defendants are allowed to produce all the documents as per that are sought for under Order 41, Rule 27.
With permission, my lords. So application 29/10/2022, an application was filed. The trial court has partly allowed that application.
That is what we are now
So
dealing with.
earlier to that, the order if perused, only 28/3/2016 application is allowed. Only a sale date was produced along with that.
What is other application? Two dates are there.
Two applications
What
were
about
filed.
that date?
That application 2016 is allowed as per this impinging order. And as regards 22, the application filed in the year 22, the order is silent upon that. The other side is not submitted.
That's what their lordship has set aside it.
What's the date of that?
That order date is, my lord, annexure J itself.
J.
Yes.
J and K.
That is 20.
So all the three applications he followed also.
29.
This 28/3/2006 IA
16.
of 16,
16 is allowed. We have not challenged that one, my lord.
it is partly allowed.
Yes, ma'am.
Only one document was produced along with it.
Saying only
That is
one
the sale.
document is allowed.
Yes.
What are the other documents in that?
Along with
Other
that application, only one document was produced.
Then second,
Thereafter, second round of applications came in the year 2022. Similar application, but set of documents along with this earlier document also.
What is that date?
that is 29/10, my lord. Your lordship, which annexure J was referred, 29/10/2022.
That is with regard to,
No,
regard to the amendment.
yes, ma'am.
Same date, two applications.
No, your lordships may get page.
41/27 and
In 2022, when you filed an IA at Order 6 to 17, there you filed another IA under 41 Rule 27.
Yes, ma'am. Both were,
Silent about it.
yes, both are silent. Both.
Then the court, in the order, the court has not considered the IA that is filed under Order 41 Rule 27.
it is discussed, but in the operating portion, nothing has been, in the discussion there is there.
In the operating portion of the order, there is no mention about the IA that is filed under Order 41 Rule 27 dated 29/10/2022.
Obliged.
2022, considering the fact that at this stage the court cannot consider, the court ought to have allowed the same. Accordingly, IA
They are not,
Number for that?
no, they have not given number in that.
IA filed under Order 41, Rule 27, dated 29/10/2022 is allowed. The defendant is at liberty to to raise the additional pleadings in support of the same. And the court, the appellate court shall frame the issue in that regard if necessary. The parties as
My lord,
directed by the appellate
that
court.
second IA number, that annexure K, my lord, that is in consonance with these pleadings, well.
Yeah, that is?
6 Rule 17,
The amendment of the.
same date.
Even the IA that is filed under Order 6 Rule 17 in connection with this,
Dated-
with connection to the IA 41
Yes.
and 227 is allowed.
Yes.
Is allowed. And the parties shall appear before the court when?
Lord, first of, sorry,
Any date.
you'll appear.
Last week of this month,
Last week of?
this month, my lords.
Shall appear before the court on 26th
Seven.
of February.
Yes, my lord.
26th of February, and within 2 months from
Yes.
the date of receipt of the copy of the order, the court shall, the trial court shall dispose of the application, and the TCR shall be sent along with the order to the appellate court, and the appellate court shall decide the pending RA number 38,
238/12,
2012, within a period of
3 months, 2 months, my lord, thereafter. Thereafter,
3
2
months, my lord.
3 months from the date of receipt of the
Yes.
order from the trial court.
Your lordship may observe
Cost
that.
is imposed because 2010 disposal suit, application in the year 22. Some heavy cost is imposed that would justify.
My lords, it is, of course, my lord, 5,000 maybe, I do say.
10, my
my
lords.
friend.
10,000. Cost of 10,000.
Your lordship, in the meanwhile, I may permitted to file amended WS, my lord. Your lordship
The
may,
petition shall file the amended written statement.
please.
Number 67?
Yes. Yes.
My lordship, please give me next week time.
How appears?
Happy for the respond. It may.
This is matter of 2 weeks. Yes, 68.
Lordship, I'm back to appear through VC Lordship. This is the writ petition, Lordship. Respondent has filed a DV petition against the petitioner's Lordship. Respondent number 1 is the mother-in-law. This petitioner number 1 is the sister, daughter-in-law. Another 2 are the grandson of the respondent number 1, Lordship. Lordship, kindly appreciate, we are challenging a very short legal point in this matter, Lordship. On 14/8/2025, Lordship, the trial court has directed the petitioner to file their assets and liability affidavit.
Why you are questioning a criminal miscellaneous order in this writ petition?
This is the DV petitions, Lordship.
Huh?
It's a DV petition, and the
How can a
writ petition
petition
is
be
maintainable,
maintained?
Lordship.
Huh?
Writ petition is maintainable, Lordship.
How?
But this is a procedural order is passed. There is no specific order passed against us, and all the order which was impugned, we are consciously challenging in appeal. This is the procedural order passed by the learned trial court, and we are challenging the procedural order only. But you kindly see the impugned order is on page number 14, Lordship.
My lord, section 28 of DV Act.
We'll see some other day. This is matter after 2
The
weeks.
matter is,
I seek interim order may be.
Interim order only granted 60.
Please.
69.
Number 69?
kindly short date given me, Your Honor, because
It's on 17th.
respond number 1 is older.
Kindly have it on 18th, Lordship.
Yes.
This is the
18th, Lordship.
This is
Yes,
petition-
Jadhav?
petition filed by the husband, my lord, wherein challenging the maintenance
Any urgency?
because of 25,000 days, every month is more. the
Notice
maintenance,
interim
my lord.
maintenance 25,000 is awarded. Notice his salary is 1,10,000 and his father pension is 50,000, my lord.
But the fact is that, my lord, the marriage solemnized,
Court of which proceedings?
Before the trial court, my lord, sir, divorce petition is filed. Notice interim application I have filed, my lord, sir.
No, that is true. Why is it GMRES? Which is a petition?
GMFC.
WP 108471. GMRES.
my left side. Yes, it is.
Huh?
Actually, it's JMFC, my lord, but My lord, what happened, my lord, in this case, my lord?
What was the maintenance granted?
25,000, my lord.
Huh?
25,000.
What is your income?
My income is every month is 25, 1 lakh, 1 lakh, my lord.
1 lakh?
1 lakh.
1,10,000, my lord.
What is the difficulty to pay 35,000?
My lord, this is the case, my lord. The wife is suppressing she is suffering for heart disease, my lord. And
All those things will be decided during the trial.
yes, my lord.
At this stage, whether you are capable of paying that amount or not.
Yes.
Your salary is 1,10,000.
I filed the divorce petition because of it. That is the reason. Because of
Whatever
that is a very serious reason, my lord.
Down to disentitle the wife for maintenance and
And
35,000 is.
she is also B engineering, my lord. She is also B engineering. She is also working, my lord.
When were you, when the parties got married?
2015, my lord.
2000?
2015, my lord.
She's not working?
No, my lord, she's not. Because of this illness, my lord.
What illness?
She's not, my lord, she's suffering from the heart, my lord, the problem.
Never worked?
No, earlier she used to be work, but because of the husband, my lord, she left the work. Thereafter, my lord, she was deserted by the husband. And she is residing with her parents, my lord. Since, my lord, I am unable to, my lord, maintain myself, and I filed, my lord's application for interim maintenance. 1,10,000 is the husband, and 50,000 is his father
Sorry, my lord.
pension, my lord.
And she is suffering from she is for heart disease, my lord. Even when petitioner husband for call for some contact, my lord, she is refused to join, my lord, because of the doctor says that pregnancy is very dangerous to us, my lord. Her, my lord. Hence, he filed the divorce petition only for that reason. my
All
lord.
these are all the grounds for granting divorce. Please tell one good reason why wife is not entitled for maintenance.
Because of she is also engineer, my lord, she is
Herself for saying that she's suffering with a heart problem, that she is not
no,
physically not capable.
recently I came to know about that. She is from birth, she is suffering from that.
That's what. That's
Even
why they say
even parents of the
she's not in a position to work,
yes, my lord.
and you are having enough money to pay the
And
maintenance.
my lord, we are approached that elders, my lord. We are ready to settle the matter, my lord.
Let them settle
Uh,
by a number.
If sent to for the mediation,
No, my lord.
one chance, my lord, only one chance.
My lord, before the trial.
On Monday, my lord, one chance. If it not settled,
Submitted that the petitioner, the land council, the petitioner that the matter may be referred to the mediation. Land council for the respondent submit that there is no scope for mediation as the last chance. Parties are directed to appear before the mediation center on 16th.
16.
Yes, next.
16.
Seal number
Please,
70.
and there is no stay, my lord. Kindly, there is no stay, my lord.
There is
I
no
will
stay.
decide, you can't have both, either you go for the mediation or I'll decide it on the merits of the matter.
Only request to not to execute that.
Not to execute.
By oral, my lord.
Mediation cannot be, is a supplement for stay.
Yes, please.
Yes.
On 16th, my lord. And to
Yes, 70.
Seal number
My lord,
70.
70 basic accommodation. Basic accommodation.
This is this matter after 4 weeks.
Interim order.
Intermodal only granted is extended till then.
Seal number
Great.
71.
Yes, 71.
Vishwanath Bhatt. GB Baramgod.
Serial number 36 also pertaining to the same society, Your Lordship. It is already
What
adjourned.
happened to that?
Elections, Your Lordship, wherein they are permitted to,
happened to 36?
that is adjourned.
What happened?
Serial number 36.
List this matter also along with that, 2 weeks.
Any date may fix, my lordship.
will come.
Already notice is served to the
Matter
respondents.
on 4th of March. Yes.
Further hearing matter. 72.
I'm appearing,
Very good.
appearing for appellant, my lordship. Council is out of session, my lordship. Kindly have it tomorrow, my lordship.
List this matter after 2 weeks.
2 weeks.
3 weeks. 3 weeks. Sir.
Interim order may be extended.
Delete from the caption for the hearing.
3 weeks.
This set. All these final hearing matters, give the date for these 4 matters. Yes, call the for passwords.
Password matter. Seal number 3. Anand P. Saudi. Very sharp Budihar.
Oh, I said this, I'll take up this matter at 2:30. No, give it, I forgot this 2:30 matter.
Anyway,
List this matter on 24th at 2:30.
24th.
At 2:30. Is any other password? You should remind this man. When I particularly said to the.
Yes.
Yes.
Seal number 5.
Please.
Srikanti Pat.
75, my lord.
Huh?
75, adjourned, my lord, 75, final hearing.
I have not called. Let it be
Yes,
there in the list. Let it
date,
come tomorrow, not
next.
tomorrow, let it come on Monday.
Yes,
Yes.
please.
Seal number 5, my lord. Sorry, my lord, I couldn't appear on the last occasion. I appear for respondent.
Huh.
Lord, the application is, my lord, filed under 16 rule 6. Lord, for summoning a principal of, my lord, particular education institution. Lord, for production of original register.
We'll have it some other day, Monday.
Please.
Yes, next.
9.
I request on Tuesday, my lord.
Tuesday.
Please.
Yes.
Tuesday. 10th. Seal number 9. KL Party. KL Lord Khan.
Yes.
My lord, my clients has got apprehension for the very reason only when it is brought to the notice of the court, visitation was allowed in the court premises.
What is the apprehension?
Apprehension is that there is a threat from the very father of the children that he is going to take away the children whenever he meets them.
Can you do that?
No, that is the apprehension what I am required to.
Can you do that? When
The reason for that reason only I am proposing let the Keshapur police station, which is nearby to the home of the children where they are presently staying, any time may be fixed by this
Court
court.
will never grant visitation in a police station.
No, let it be there in the court itself. No, anyhow, his proposal is with respect to Sundays. Sundays there will be no court. Let there be any other day exclusive in the court premises itself. As it is, his grievance is that only on Saturday between 4 and 5 is not able to come.
We'll see. We'll see. This is matter in the month of March. Yes.
March.
Tomorrow, Monday, madam. Tomorrow I'm out.
Possible. Why now you don't want on a Saturday? No, they say some apprehensions which the court has to consider. So either you can have it on Saturday or no. This is matter of 2 weeks.
No, may I request him to pay the maintenance?
You can't dictate the terms and say.
No, only request is there, my lord.
Only one thing, if your client is ready to give visitation to him as he wants, then I'll ask him to pay immediately. Or else, whatever is the order and whatever is the remedy, you people can.
Please.
Yes.
Seal number 10. Password matter 10.
There are totally 6 writ petitions, my lords. And my lords, it's as against the order that has been passed by the court, my lords, in MA. There is a suit was one for bare injunction, my lords, where temporary injunction.
Matters on 19th.
19.
It is.
Seal number 50, 59.
59 is what?
Yes.
Yes.
Request for
59?
20th,
Huh?
20th instead of 19th,
20th is not possible. Let it be on 23rd.
please.
Yes, next.
Lords, this matter, my lord, I had sought for release of machineries. Lord, in fact, they have filed statement. In fact, they want to be cleared, my lord, but they are saying forest authorities are not permitting them to clear
Actually, the respondent number 1 is a formal party, my lord. It is in the custody of the government, forest department. They have to seek a mandamus against them. The prayer itself is,
Let AGA shall get instructions with regard to the release of the machinery.
The thing is, my lord, the representation is given to me, not the government.
Lords,
my
I
lord.
make one
The
submission.
prayer itself, they have to.
My lords, I'll seek.
Then we'll do one thing. I'll dispose of the petition saying that you should give an appropriate representation.
My lords, I'll make one submission, my lord. My lord, in this, my lord, Lokaयुक्त has conducted investigation and filed a B report. Once B report is filed, my lord, forest authorities cannot, my lord, come and object for release. My lord, it's my machineries are lying in the properties of, my lord, premises of respond number 1. Therefore, my lord, I have given representation to respond number 1, that is the port authority. My lord, now port authority, my lord, saying that the forest authorities are not permitting them to release. My lord, under these circumstances, my lord, this honorable court directed me to impede the state and forest authorities, my lord. I have already impeded. Therefore, my lords, my humble request is to cannot, my lord, let them take
To be considered.
Please.
Representation who will consider to whom you have given, then only the order can be passed.
Please.
Now the authority who can consider your representation, the second.
My lord,
state.
let them take the, my lord, instructions from the forest department, my lord.
My lords, kindly dispose of this petition. Let them make an application to the.
He's not interested. You get instructions, Wilson. If he's not understanding how he'll get an order, we can't help him. This is matter after 2 weeks.
Without
Please.
application.
AGA shall get instructions.
Please, my lord.
ಒಂದು ಕೊಡ್ಬೇಕಲ್ಲ? ಇದು 75.
Sir, ಅದು 10 ಯಾವ್ದಿಲ್ಲ?
23.
20.
ಜನ ಬಿಡ್ತೀನಿ ಬಿಡ್ರಿ ಮೇಡಮ್ ಕೆಲಸ.
Court officer. Court officer.